the Michigan Board of State Canvassers at 8:38. We have a very full agenda, so we are giving people who wish to speak, who have indicated their desire to speak to any particular agenda item. We will give people 5 minutes if they are opposing the staff report, and if there is opposition to a staff report, we'll give the person who may be arguing in favor of the staff report also 5 minutes. But we're going to stick to that time because we have, as everyone can see, a very long agenda. Our first item of business is consideration of the minutes of the meeting of April 26, 2024. Do we have a motion?
Madam Chair, I move that we approve the minutes of the meeting held on April 26, 2024.
I'll second.
All in favor?
Aye.
Aye. Motion carries. The next item on the agenda is report on the review of nominating petitions filed with the Secretary of State for the August 6, 2024 primary. Director Brader, do you want to address this matter?
Yes, thank you, Chair Gerwitz. So first, I just want to start by thanking the Bureau of Elections staff for the many long hours and all the excellent work they've put into this process. The efforts to prepare for this started long before we started getting candidate filings in the spring. There was a huge amount of effort and thought that was put into improving our materials and improving our process, from the candidate filing forms to manuals to canvassing process improvements that we've discussed, helping candidates through the process, answering questions. I would say that overall, we did see an improvement in reducing avoidable mistakes. We always have some, but I think we did see relatively fewer of the types of issues that trip people up than we saw in past years. In terms of the review of the signatures themselves, a lot of the process improvements really helped us out here. I think it was very beneficial that we clarified some of the codes and the reasons for rejection that we have used. I think getting rid of some of the outdated reasons for rejection was beneficial. Some of the more modernized processes we used, like scanning all the petition sheets right away, using digital numbering instead of hand stamping, and also random sampling for the U.S. Senate petitions, overall made this process much more smooth. But even with that, there were still many, many hours, late nights and weekends getting this all together. So I really appreciate all the time that everyone put into it. Our goal at the Bureau of Elections in this process is to help candidates in understanding the requirements that they need to fulfill to run for office and do everything we can to prevent avoidable mistakes and errors from keeping them off the ballot. Once we get the forms in, though, our job is to review them uniformly and determine if they have a sufficient number of valid signatures. And we want to do the best we can to make consistent recommendations to the board after reviewing those petitions. This year, we reviewed about 130 candidate petitions, all told, for U.S. Senate, U.S. House, State House, and many judicial offices. And then many of these also, as you saw, involved challenges that were filed and responses to those challenges, which involved additional review beyond our review of the 130 petitions. We always want to make sure that we do the best we can to make our recommendations consistent with the election law, with the court decisions, interpreting it, and with the board's practice. In some cases, just based on the varied statutes that we have, there are errors or inaccuracies on forms that we recommend that the board still accept the petition, and there's others that we recommend the board does not. And again, this is based on different statutory sections, different statutory languages, court decisions, and the board practice. But we're trying to apply that as clearly and consistently as we can for all candidates. And of course, you know, as the board knows, we have talked about some possible updates to the election law that the board has supported, and we can talk about some other process changes that we can possibly do with or without statutory changes. But for now, obviously, we're applying the law and the procedures that we have. So the first thing that we're asking the board to consider is a general motion to approve most of the candidates that filed with us in a single motion. So these are candidates where there was no staff report necessary. We do a staff report for a candidate only if we determine that they have an insufficient number of valid signatures, if there is a challenge, or both. So we have 28 of those staff reports that we're going to get to for individual candidates, but first we're going to have you consider one motion for the rest of the candidates. And so even with these, even though they didn't require staff reports, we are aware that there are some that disagree with this list and dispute the listing that we have here as the one that the board should approve. So I believe we're going to hear from some stakeholders on that momentarily. After we hear from them, I'll likely have some responses if you want to hear them from staff, and you may want to hear from the AG's office as well. But just a couple things I want to mention about our general process for reviewing really all petitions, but especially U.S. Senate. First, for the United States Senate candidates, other than the two that we have staff reports for, we have staff reports for Beydoun and Slotkin. We discussed at several meetings over the last couple of years doing the random sampling for U.S. Senate petitions, or really for all statewide candidates, but this year that was Senate. And after a lot of discussion, a lot of meetings, consulting with experts, consulting with stakeholders, the board did approve the process of using random sampling for the Senate petitions. After what happened 2 years ago with the gubernatorial candidates and other nominating petitions as well, where we had a very high volume of sheets that consisted entirely of fraudulent signatures. Candidly, 2 years ago, we had never seen anything like that on that scale before. And so what we did 2 years ago, just being faced with this for the first time, was we looked up as many of those as we possibly could. And we ultimately felt confident in that case that all those sheets should be thrown out because we had looked at so many that if there were any good signatures, we would have seen at least a few. But that was obviously a very difficult, not to mention very time-consuming process. Trying to look up tens of thousands of signatures in the qualified voter file takes a very long time. The signature lookups are not always quick. So multiplying that by tens of thousands is not easy. And so to avoid that situation happening again, we recommended, and the board agreed, that instead of trying to look up every single signature for these positions that can have up to 30,000 per candidate, we would instead do random sampling. So using the random sampling system, which is similar to what we do for initiative petitions, for initiated laws, constitutional amendments, referendums, we updated that process a bit, but it's essentially the same process. By using the random sampling, we would be able to recommend to you that whatever percentage of valid signatures and whatever percentage of invalid signatures are in the entire petition are going to show up proportionally in the sample. And so we don't need to go into this question of did we look up every single signature, because we have a statistical projection that's very reliable and we look up every single signature in that sample. This year, I do think the sampling method was very effective in letting us do a full review of the Senate petitions, and it also freed up time for us to review many of the other petitions. And many of those were also very time consuming, especially the Court of Appeals petitions, which required at least 6,200 signatures. So that was definitely beneficial. The other thing that I think was key this year, and a really good and a good thing that we use sampling, is that this year was different from 2 years ago. This year, we did again have a lot of sheets that showed clear indications of fraud, but unlike 2 years ago, they were not 100% fraudulent signatures. So last time, as I mentioned, we looked through sheet after sheet after sheet. We couldn't find any good signatures in these. But this time they were mixed in. We had some entirely bad sheets. We had some entirely good sheets from these circulators. We also had sheets that had a mix of signatures that were valid and invalid. So what we had done 2 years ago would not have worked this time, because we couldn't have actually said, we should throw out all these sheets, because we couldn't say that every single signature this year was bad. So it's definitely a good thing that we're able to use the sampling for the U.S. Senate candidates so that we can give you a reliable projection of the validity rate. And I think, as we talked about over the course of the last couple of years, in the future, we should also consider things like automatic signature verification software and other things that would let us look at more signatures more quickly. But I think what we did this year was a major improvement. So for the Senate petitions, what we did was we drew a 750 signature sample for all of those petitions, and we made that sample publicly available. And people had the opportunity to review that sample and to submit challenges to signatures in the sample. But we also, with or without a challenge, we looked up every single signature in the sample. We made sure it was on a facially valid sheet. There were no header issues, et cetera. We also looked up the signature individually to determine whether the signer was registered in the jurisdiction according to qualified voter file, and also that the signature matched. And so for each of the candidates that's on this list to approve, we determined that they had the required number in the sample to project that they had enough signatures in the petition overall. And, there was one which we have an individual staff report on where we found they didn't have enough, but that we'll talk about later. For the ones that are on this list, they all, as you can see from the report we produced on the Senate candidates, they all pretty easily cleared the threshold of valid signatures they needed in the sample to project that they had enough in the petition overall. And so I mentioned there's a challenge deadline and folks could challenge this. The deadline to challenge Senate candidates was May 2nd. We got some letters expressing concern about some of the sheets, circulators, signatures in some of these Senate candidate petitions. And I'm sure you're going to hear more about that shortly. The main thing I just want to say is from staff's perspective, claims about what was going on more generally in the petition is completely irrelevant to our determination of whether they have 15,000 valid signatures. And that's because our projection was based on the sample and we reviewed every signature in the sample. So yes, for all the Senate candidates within the sample, we saw non-matching signatures for all the candidates. But so it's not surprising that if you look at the entire petition, you would also see potentially large numbers of non-matching signatures in a 30,000 signature petition. And maybe you'd also see some showing clear indications of fraud on the sheets. And that's, again, not really surprising. But it doesn't affect our determination because the random sample was already factoring in that in. The idea of the random sample is to determine how many bad signatures are in that sample, which we did, and make a projection for the petition overall, which we did. So of course, we're reviewing these letters, and as we did 2 years ago, we'll refer anything suspicious for law enforcement investigation, but it has no impact on our projection of the validity of these candidates. We also got another late challenge attempt, which was on the Ackerman petition. Ackerman is on this list. There was an attempted challenge that was after the deadline, which we didn't process because it was too late. We did look at it though, and for reasons I can explain when we talk about this one in more detail, we think even if we had processed it, it was extremely unlikely that this challenge would have brought the candidate under the required number of valid signatures. We also have an issue that I think is going to be discussed about a recently appointed judge, Judge Polizzi, which creates some unusual timing issues for the ballot this year. And so Judge Polizzi's name is not on this list, but I think we're going to hear an argument that she should be. This isn't a nominating petition issue, but we did get a request to present it to you. So we think the most appropriate time is during this agenda item. So I may have some more to say about that when that comes up, and the AG's office might as well. And then one other thing that the AG's office may just want to mention to you is we do have a pending a court decision coming down about another judicial candidate on the list who is currently on the list, which is Davis, that there's something happening in the courts right now, which may or may not affect what we need to do here. So with that, I'll wrap up so we can hear from the candidates and the interested parties. At the Bureau, we definitely understand that these campaigns have put an enormous amount of time and energy into this process as well. And I understand that some are going to agree or disagree with our recommendations. We've done our best to give you consistent recommendations that are correct under the laws and the procedures that we follow, but ultimately you'll have the opportunity to hear from them before making your own determinations on the nominating petitions.
Thank you, Director Brader. We have you have given us the report on the number of candidates who you have found to be sufficient. And that is how many, the candidate listing that you have provided to us?
The total number that are just on the single motion.
Yes. Agenda item 2.
388, and that includes candidates that didn't file nominating petitions. So it would include like state rep who did filing fees, and it would include people who filed with the counties as well, right? No, not with the counties. Take that back. So just the people who filed. It would include everybody who filed nominating petitions with us, and it would include people who didn't need to file nominating petitions, which would include judges, right, that filed affidavits of candidacy, and then also state rep candidates that could do a filing fee.
And we have had a request to speak to agenda item 2 from Chris Trela. As I said in my introduction, 5 minutes. I know you're not a man of few words.
Because you're the first one.
And we're really going to stick to this. Otherwise, we will be here until next week.
Good morning.
Adam, your timing, right?
Yes.
Okay.
Does that count? The first 2 seconds? Just wait. Don't hold on. Good morning. Chris Trela from Clark Hill. I am a practicing attorney on behalf of Michigan voter Emily Judd, the Michigan Democratic Party, and the DSCC. As Director Brader noted, we submitted a couple of letters outlining various indications of fraud and forgery contained in the Senate GOP submissions that track very closely to what occurred in 2022. A little bit, I felt like Marty McFly pulling up in my DeLorean, and I'd gone back to 2022 because the patterns that we saw here in the GOP Senate petitions largely tracked a lot of what we saw in 2022. But as staff noted, there is more sophistication. I think our letters and in the response and Director Brader's in the staff report, I think a number of questions that this board has to answer and address lead that there should be a closer look at the full universe of petitions submitted by these candidates for a number of reasons. First, the question I think is everybody's on mind is, does this board have the authority and a duty to investigate evidence of fraud and forgery outside of the petition signature challenge stated in MCL 168.552? The answer is clearly yes. Separate and apart from the mandatory duty to investigate subject to a challenge, the plain language of 552 Section 8 states, and this is separate and apart, upon receipt of the nominating petitions, the Board of Canvassers shall, mandatory, canvass the petitions to ascertain if the petitions have been signed by the requisite number of qualified registered electors, and then subject to 13, which talks about getting signature cards and what you do to compare it. For the purpose of determining the validity of signatures, the Board of State Canvassers may cause a doubtful signature to be checked. And so, yes, this board does have a duty and the authority to look into the genuineness of signatures outside of the challenge procedure. That is independent, and staff largely does that, but the board has to do that. The second question, I think, is there sufficient evidence of fraud in the GOP Senate petitions to call into doubt whether there are enough valid signatures to certify these candidates? Again, the answer is yes. This year, the board has presented to it and in the information 19 sworn statements from individual voters attesting that the signatures submitted on petition sheets were either not their own or they did not sign that petition sheet, including an affidavit from a woman that was contacted who, when asked about her own signature, and said, yeah, I didn't sign it. That's not my signature. And oh, by the way, the signature below that lists my brother. He died in 2022. He did not sign this. So there is information, and that's at least 4 times the number of affidavits that was presented to this board in 2022. The staff found and confirmed that circulators named in the Nielsen complaint engaged in fraud and forgery and invalidated a number of those signatures sufficient enough to have that candidate below the threshold. Those same circulators submitted over 3,200 signatures in the Rogers submission. Now, while some of those, only a few of those may have shown up in the sample, there are 3,200 signatures submitted in that in the universe of Rogers that are also have been already found by the staff to have committed fraud and forgery. This board has a duty and should investigate those things. We also detailed a number of indications of fraud throughout the signatures, and while we only had time to identify Rogers, based on the crossover of circulators and other indicia of fraud, it is across the GOP candidates. And the issue that this year's fraud presents is it's difficult if you're only looking at one candidate's circulator petitions at a time. If you're not comparing across candidates, there is substantial amounts of fraud you are missing. And we're seeing, and what we saw, what we call rainbowing, but it's a form of roundtabling where you may have valid signatures on one sheet, but then they're being duplicated on the other sheets, identical. And it's the same, say 7 to 8 voters show up either on a different day or the same day signing for another Senate candidate. Again, those are clear indications of fraud and forgery. I would also just note that, and I won't go into it, there's been a lot of talk about sampling, but I would say whether or not the board has fulfilled its investigation to investigate the entire submissions of the GOP candidates and the staff report that confirms that those submissions contain evidence in forgery. No, not as of today. The board, following the sample procedure, this board the staff followed and checked the random sample of 750 petitions. They were checked against the QVF, but that is only 2.5% of those. If I could just real quickly on the path forward, 30 seconds on the path forward, if I may,
Okay.
Madam Chair.
30 seconds. Got that
By
out.
statute, the board has until June 4th to complete the canvas. We've narrowed the list, and I have a list here today of the other GOP candidate petition sheets that a review could be completed by June 4th, we believe. We understand that it's inefficient and time consuming. Alternatively, if the board is satisfied that the canvas is completed, the board has the authority and duty to investigate and determine whether any penalties should be imposed under MCL 168.5544. Candidates can be certified, names placed on ballots,
Wrap it
and
up,
staff
Mr.
can
Zabelka.
complete it and come back after a full investigation. The board needs to do a full investigation of the fraud contained in the GOP
We,
circulators.
Eric Doster has also requested to speak, so we will hear Mr. Doster and then questions for both of you can come from the. Mr. Doster?
May I begin?
5 minutes.
5 minutes. Chair Gerwitz, members of the board. Thank you. Sorry, it's my height. Eric Doster on behalf of Rogers for Senate. I'm not going to sugarcoat this discussion. This is a blatant attempt by Alyssa Slotkin's allies to try and disenfranchise tens of thousands of Michigan voters for a pathetic public relations stunt. The challenge deadline here was May 2nd. As of that date, no challenges were filed against the Rogers petitions. But by letters dated May 17 and May 23 from Alyssa Slotkin's attorney, these letters somehow get filed with the press, and I assume eventually with this board, announcing that there is, quote, potential fraud, end of quote, with respect to the Rogers petitions and demands that this board disenfranchise voters and subvert democracy. And what are these instances of, quote, potential fraud? In our response that we filed with this board, we have broken down these potential fraud claims into 5 categories. First, Alyssa Slotkin's attorney argues that the circulator cannot allow voters who live in different parts of Michigan to sign a statewide petition. This particular circulator that they're complaining about lives up north and collected signatures from downstate Michigan voters who were up north. As ridiculous as this sounds, this was an attempt to disenfranchise 1,882 Michigan voters. Second category, Alyssa Slotkin's attorney alleges that a few incomplete addresses, incomplete names, or signatures that allegedly look different from the accompanying printed name, according to untrained eyes, somehow requires that every signature collected by these circulators be invalidated. Another 1,905 voters disenfranchised. Third category. Alyssa Slotkin's attorney alleges that because a small number of voters claimed that they, quote, did not recall, not that they did not sign, but, quote, they did not recall signing the Rogers petition, somehow requires that every signature collected by this particular group of circulators be invalidated. That's 4,580 attempts to disenfranchise Michigan voters. Fourth category. Alyssa Slotkin's attorney identifies 2 circulators that it claims engaged in fraudulent activity, but makes no specific allegations against these particular circulators. And then somehow every signature collected by these 2 signatures must be invalidated. That's another 1,508 Michigan voters disenfranchised. Final and fifth category. Alyssa Slotkin's attorney references 10 circulators that were challenged with respect to petitions circulated for other candidates, not Mike Rogers, that are engaging in fraudulent activity, but makes no specific allegations with respect to this particular circulators with respect to the Rogers petitions. And as observed by the Michigan Bureau of Elections in this document, which I hope you've all read, it's very important, particularly to this discussion, and it's the document titled Petition Sheets Showing Clear Indications of Fraud, dated May 24th, 2024, and I quote, "Some circulators submitted wholly valid petition sheets for one drive and sheets showing clear indications of fraud for another," end of quote. Consequently, it is wholly irrelevant, according to the Bureau, whether or not any Rogers circulator was referenced in a complaint involving another candidate. Nevertheless, Alyssa Slotkin's attorney thinks the somehow requires that every signature by these 10 circulators must be invalidated. That's another 2,419 voters disenfranchised. In total, Alyssa Slotkin's attorney says that 12,293 Michigan voters should be disenfranchised. And how did the Bureau review the situation? Well, I think Director Brader's done a really great job of explaining their process and following this board's procedures, but staff here did essentially three things. First, as indicated in, again, this document, petition sheets showing clear indications of fraud, staff did not process these press hits as legitimate challenges because they were submitted weeks after the legitimate challenge deadline. Second, as indicated again in the same fraud document prepared by staff rejected the notion that all of petition circulators' petitions are to be universally invalidated. And according to staff, and I quote, "Because staff used random sampling for U.S. Senate candidates, it was not necessary to separately review petition sheets showing clear indications of fraud in those petitions. Whatever percentage of invalid signatures exists in each Senate candidate's petition, whether because of sheets showing clear indications of fraud or some other reason, is reflected proportionately in the sample and in turn in these projected number of valid petitions in the universe. Therefore, the separate review of sheets, and again, I'm skipping because I'm realizing I'm running out of time, just was irrelevant, and the determination of whether Senate candidate petitions were sufficient."
Mr. Doster, you're repeating what Director Brader
I know, but
indicated to
that's
us.
important.
Right, I agree. So,
Okay, so let me conclude by just saying this. If I can have the minute that Mr.
30
Trebelka had.
seconds.
He had a minute,
And
but
let me add that we have something that a court always says at the beginning. I think we have all read the material that was submitted to us,
well,
including your long response to the two letters from Mr. Trebelka. So I think that we're pretty familiar with the arguments. And we have also read, of course, the material that has been provided to us by the Bureau. So
well, let's look at the final thing, if I may, Madam Chair, what the staff did. And this is probably the most important thing. They did review everything that Mr. Trebelka is asking the board to do. They looked not only for potential fraud, but actual fraud. And when you look at the staff, I guess it's a staff report, it's the document called Random Sampling Results. And if you look at it, they looked at, and that's the category of invalid signature. And according to the staff, the invalid signature number for Mike Rogers was 39. Oh, but the invalid, and that's your fraud, for Alyssa Slotkin was 59. So I guess we're not going to let the facts get in the way of a good public relations stunt.
So enough, Mr. Doster. I will invite Mr. Trebelka to join you, and any questions that the members have can be directed to either one of you. We have questions.
You sure you don't feel more comfortable sitting on the right?
I'm fine right here.
Okay.
Member John.
My question more for staff related to the random sampling. Obviously, we're all concerned about fraud, regardless of partisan inference one way or the other. I think it's clear that the fraud has been happening across the board. With random sampling, how confident are we that random sampling is able to catch the fraud that's in these petitions?
100% confident. I mean, I think, first of all, I mean, if you look at, for example, the Rogers petition, he submitted, just for sake of simple math, 30,000, which is the maximum he could submit. And he needed to have 15,000 valid signatures. So half had to be valid. When we pulled the sample, which was 750, then as you'd expect, he had to have half of that, 375 in the sample, to be valid for us to recommend certification. Now, admittedly, like with statistics, if they were right on that number, like if he had 375 valid signatures in the sample, then it would be a close call statistically, and that would be sort of the edge of what statistical projection can do for you. But in this case, he had 602. So it was not close, and it wasn't particularly close for any of the candidates that we're recommending certification for. But also, I would just note that when we were talking about the idea of doing random sampling because of what happened in 2022, we did go back and look at one of the petitions from 2022, which was the Craig petition. The reason we chose that one is just because that was when we already had scanned. When we applied this methodology to that, we did find the bad signatures in that sample, as we would expect to. And in fact, we actually found a lower validity rate of signatures through random sampling than what we had recommended to the board based on what we did in 2022. So we're completely confident that this catches invalid signatures for the purpose of determining if they have enough valid signatures in the petition. Now, what sampling doesn't fully do is collect all the information that we need to refer things for investigation, but we are going to do that. So after we've completed our primary job here, which is to determine who makes the ballot, we are going to be looking back through all the sheets and referring anything suspicious for investigation for law enforcement, whether it's in the sample or anywhere in the petition.
Further question?
I have a question, kind of follow up on that. So two kind of factor. Given that in the memo that we know that I don't want to use fraud at this point, but I don't, maybe that's the word to use. I'm not really sure offhand, but I guess the question I have on the randomly sampling process is, are you looking at the circulator on the, like, if it says page 237, line 7, like that's the signature you're checking. And that signature checks out. But the circulator of that petition is on the list that you have now noted over cross campaigns. Is that taken in consideration that you have? I mean, because the patterns aren't, I know that the random sampling process, you use Craig's, but in 2022, the majority of the circulator issues and the circulators who were deliberately committing fraud, it was the entire sheet. Now, through the memo that you gave us, you're saying that it's not, like, some of them will be good, some of them are not. And I guess the question I have is, when we went to random sampling, which I know I had concerns, I did vote for it, but I had some concerns about it. Given that it takes away physically looking at all the entire sheet as a whole. And I get the statistics, I was here, but my question is, are we taking in consideration, are we looking at just the signature? Or are we looking at, I mean, I know that you would look at the form, obviously, wouldn't look just like at the line, or am I off? I mean, are you just looking at the line? Or are you looking at the actual form? Maybe look at the signature of the circulator as a kind of a cross reference. I know it's kind of a convoluted question, but I'm trying to get it out of how to put that into words. I'm sorry.
So for each of the 750 signatures in the sample for each of the Senate candidates, we first looked at the entire sheet that signature was on to determine if there was some reason that signature should be rejected. So it could be, a header issue that actually knocked out all of Beydoun's, for example. They all had a header issue. It could also be that it was signed after the circulator date. So there's many reasons. And we looked at all of those reasons that the signature in the sample could be rejected. But then we also looked up individually the voter's name and in the qualified voter file to verify that the voter is registered in the jurisdiction. And then we also looked at the signature and matched it against the qualified voter file signature. So we were verifying each signature individually. And so if a circulator like submitted to us say there's 10 signatures in the sample that came from one circulator, and that circulator gave us 5 signatures that were valid and 5 signatures that were invalid, we would have knocked out the 5 invalid ones and we would have counted the 5 valid ones.
If I can follow up, I just want to confirm that on nominating petitions, an individual, a registered voter in the state of Michigan can only sign one petition for the candidate, correct?
Yes.
I'm just going to say this too, per party. So they only can sign one.
I think it's either party, right? Are they allowed to do one Dem, one Republican?
And-
Could do.
Sorry.
In this
Adam, go ahead.
specific instance, they could do one for the Dem, one for the Republican, because there's 2 different. Like you can't sign more than the number to be elected. And because the Democratic primary will elect one and the Republican primary would elect one, I believe they could do one.
But regardless, if they signed more than they were allowed to, the second one they signed, we would reject that signature.
Yes, that is correct. Sorry. Yes.
So if you sign like Rogers and Pensler, for example, and we
Right.
would reject the signature that was a later dated signature.
Presuming the first one is also valid.
But-
Like if there's an issue with the first one, then.
Madam Chair, if I could make just one brief comment on that question.
Yes.
I think there's the two questions I would have with the sample process in that case is how would you determine whether or not there was a duplicate signature on that signature in the sample if you didn't review all the other signatures for the Senate GOP candidates? And second is we noted in our errors that there are circulator errors as well, and that there appear to be fraudulent circulators. We identified in our letters signatures of circulators that are completely different for one Senate candidate allegedly circulated by the same person and completely different for another one. And so I think those are things that I think somehow should be incorporated if you're using the sampling process.
Whether,
Madam,
it seems to me, Director Brader, if you would confirm that whether we're doing random sampling or simply responding to challenges or undertaking, as we did in 2022, undertaking an examination of petitions even without a challenge, where we saw significant fraud, those examinations are not likely to find the kind of duplicate signatures that we're talking about. It is very difficult as I understand it, to find that if we're talking about 30,000 petition signatures for each of these Senate candidates, to find in those 30,000 one that has one signature for Rogers and another signature for Pensler. That is very unlikely to happen.
Madam Chair, I just want to clarify.
May I answer the question,
Wait.
please? I've been,
No, just a minute,
I wanted to clarify why I asked the question first, if I can do that. Is that a lot of times we have things that come to the board. And as long as I have been on this board, I want to make sure that, sorry, wanted to answer that basically that the rules are kind of clear and they're set out. And I know I've done this, it's been a pattern to me to confirm on rules. And that is why I asked the question, not because I felt that there were duplicates of people signing each petition. That's not, I just want to make sure that individuals know and that registered citizens in state know that you're not allowed to sign more than one. It wasn't because I was trying to say that that was a duplicate. I just want to kind of clarify why I asked the question. And it was more to set the rule in this public meeting that is the rule in the state. That's all.
And you wanted to say something to that.
Thank you, Madam Chair.
question.
I wanted to no, fine. I just wanted to answer the question. And that is, how do you check in the sample for things like duplicates? Well, the answer is very simple. You file a challenge by the May 2nd challenge deadline. You do not file this cheap PR stunt weeks after the fact. There's a legitimate process that's already in place to deal with the random sampling issues that seem to be of a concern here about duplicates. File the challenge by the May 2nd deadline.
And go ahead.
Mr. Trela.
Yes,
Let me
sir.
ask you, okay? By the way, I have to tell you, when I saw the Detroit Free Press with your letter that you filed, not a challenge, but a request for investigation, for a moment, I thought maybe you had hung up a shingle with the former attorney for our party. Don't take that personally, but can you ask why why weren't challenges filed in a normal, legal, proper way?
So let me just address Mr. Doster's point in terms of timing. One is, I would note, and I think as you look at statutory challenges, Mr. Doster was here in front of you, and I'll tell you specifically, his candidate, Mr. Rogers, collected 30,000 signatures in 39 days and finished in mid-November and sat on those signatures for 5 months and still turned in signatures that are, being generous, questionable. And second, as he stated, he'd advise his clients not to turn them into the last day for the very reason you say, because it makes it more difficult to challenge and review. You hear the board say it, that, or the staff, reviewing these signatures in the statutory time limit of 7 days is very, very difficult. And we utilize every tool in our toolbox. And quite frankly, we didn't get that done because it was so difficult to get done. And because, as the staff recognized,
We've got 30 other people, other candidates that had challenges that all got them in on time, some with room to spare.
respectfully, those other challenges didn't have to review at least 90,000 signatures. Those individual signatures for a lot of the other candidates are smaller batches. And so that is one of the key differences, I think. Second, again, as noted, we did not, because we recognized of the challenge deadline, which I would also note, this board has discretion to accept challenges after the deadline, so they should choose, is to provide the information to the board so that they can determine and ferret out fraud. Any fraud is too much fraud. And what this encourages is, if it says the only way we're going to look at fraud outside the sample is if that's what you're suggesting, and seems to be what Mr. Doster is suggesting, is if a third party has the money, the resources, the sophisticated technology to review 90,000 signatures in 7 days is the only way this board's going to ferret out fraud, that's just sending a signal and a beacon to all the paid circulators to come into the state of Michigan and flood it, because they still get paid. I don't know what kind of contract Mr. Rogers had with his paid circulators, but they came in and collected an ungodly amount of signatures in a very short window of time. I'm not sure another candidate has collected 30,000 signatures. Plus, I don't know what quality review they did, but candidate Peter Meyer, who withdrew, is on the record of saying they went through, found fraudulent signatures, and turned them over to authorities. Contrast that with the message we're sending to Mr. Doster advocates. Sit on those for 5-6 months, and I'm not aware of any fraud or fraudulent signatures being turned over by Mr. Rogers to authority. So to answer your question, when we reviewed them and found significant evidence of fraud, patterned the same way that we saw in 2022 across the board, we felt the obligation to give it to staff and say, look, here's what we did. We know it's time consuming. We know staff has limited resources. Here's things to look at. And they chose to do it. They've reviewed it and they've given you a report. So I reject the notion that that's some sort of publicity stunt. Identifying fraud is never a
given us
publicity
report,
stunt.
and in their report, this is essentially, these are clean petitions. These are fine.
Well, I would also note that the report focuses on one section of the statute, okay? And Mr. Doster focuses on one section of the statute. He focuses on third-party challenges and the deadline for that. This board has an independent statutory obligation and authority to canvass the petitions and verify the signatures. It doesn't say sample them, it says canvass them and investigate. There's a second statutory obligation, which is under 544C. This board has an obligation to determine whether circulators committed fraud or submitted forgery, as well as the extent that a candidate aided or abetted in that or knowingly submitted those signatures. If there is fraud, any amount of fraud in Mr. Rogers' sample, the question has to be asked. He sat on it for 5 months. Did he knowingly submit those? Or does the fact that he paid thousands of dollars for those signatures mean that he aided and abetted in those submissions? Those are independent questions under 544C that this board has a duty and the authority to investigate.
You know, I agree with you that we have an independent obligation to canvass the petitions, independent of whether or not there is a challenge filed. However, we decided after much investigation and contemplation and discussion to canvass those petitions using random sampling.
Yep.
We did.
Yep.
And the random samples, which were taken and available to people, to everyone, the random sampling indicated that Mr. Rogers and the other candidates whose petitions you may be questioning provide that there were a sufficient number of valid signatures. And we are, as Director Brader responded to Member Daunt, we are confident that there are a sufficient number of valid signatures. Director Brader also indicated that the question of whether or not there was fraud committed, whether there were circulators who were providing invalid signatures, whether they were, supervising the creation or themselves, whether those circulators were forging signatures. That's something that can be independently investigated. However, that does not affect the validity of the random sample, which is the way we decided to canvass the petitions.
Understood, and I understood that. I understand that's the board has adopted the sampling process to complete their obligation to canvass and to do that by June 4th. So I'm not questioning or trying to undermine that. I do think that there are some questions I would raise statistically about the effect of the amount of fraud within a total universe and how that may affect or may not affect the sampling. But, I think the focus here is that the staff has recognized that there are indications of fraud submitted in the GOP Senate candidates. And the question is, what do you do about it? And I say, fraud is fraud. Any fraud is too much fraud. And those who are responsible for the fraud, whether it's an individual circulator or a candidate themselves, must be held accountable. And this board can do that in a timely manner and still certify today based on the report, based on your sampling procedure, but then move in and look at the extent of this fraud under 544C and determine whether or not any of the appropriate penalties are appropriate after staff completes their investigation and makes a report to this board.
Madam Chair,
Madam Chair.
can I say something first? 2 points I want to make. One, I appreciate everybody that comes here has a job to do and they're representing clients and they have partisan interest. I take severe issue with the idea of casually throwing out that maybe Mike Rogers or whomever was basically like allowing this, condoning this. I think that's absurd, and I think that's kind of thing is beneath you, Chris. 2, this has been going on for a couple of years now. unless I'm mistaken, there's one prosecution active on this in the state on Sean Wilmoth, I think his wife and one associate. What is the Attorney General doing, rather not doing, that this isn't more of a priority? I think that sends a beacon that fraud is okay if the people who are doing this are continuously allowed to get away with it with no consequences. So perhaps that's a question we should ask, not whether these candidates are condoning this. Why isn't our law enforcement agency pursuing this in a more vigorous fashion? It is a threat. Everybody claims it's a threat. What the hell is she doing?
Any other questions?
If I might respond to,
Yes.
again, I was very patient and there was just a lot of garbage that was, sorry, Chris, but a lot of that was garbage about what Mike Rogers knew and didn't know and 39 days and all that. But let's look at the facts.
I'm asking Chris not to engage in that type of stuff.
Okay, but okay, then I will stick to the facts. The facts are, if you want to look at fraud and what, I mean, Chris indicated that the staff found that these GOP circulators committed fraud. Or which GOP circulators? The facts that are available to this board are contained in their random sample report, which shows that the invalid signature category of Mike Rogers, that's the fraud category, was significantly less than the fraud category of Alyssa Slotkin's petitions. So those are the facts. If you want to talk about who's engaging fraud, and again, we haven't done a cheap public relations stunt alleging fraud by the Slotkin campaign, and it's just, this is beyond the pale. And again, I would just ask this board to uphold the procedures that you affirmed for the random sampling process, uphold the staff's work. They've done everything you've asked. They looked at not only fraud, they looked at invalid invalid city or townships, not registered, bad circulator dates, the whole 9 yards. They did that, and Mike Rogers was certified for the ballot with more than 40% that he needed to certify for the ballot. And these reckless allegations of fraud have no place in the discourse before this board. Thank you.
Thank you both.
Thank you.
We have one other request to speak on agenda item 2. And that is from Mark Brewer. And I understand, Mr. Brewer, that you are speaking with regard not to not to any of the Senate candidates, but to candidate for the Court of Appeals, that is Matthew Ackerman.
Yes, ma'am. My name is Mark Brewer. I'm a partner at the law firm of Goodman Acker, and I'm here representing challenger Bonnie Beauvais regarding the challenge that we filed on her behalf regarding a candidate for the Court of Appeals, Matthew Ackerman. This board is the only bulwark against signature forgery. Only this board can discover it, investigate it, and stop it, perhaps by referring it to the Attorney General or other means. And the board really needs to have a zero tolerance policy toward forgery. It completely undermines the system. If signers or circulators get away with it, it simply continues to undermine the system. And what we've seen this cycle, as Director Brader acknowledged, is that the forgery has become more sophisticated. The forgers out there took a look at what happened in 2022, and they've become more clever in the way that they hide it. So it's really incumbent on the board to maintain its vigilance against forgery. It's a game of cat and mouse, and the forgers are constantly looking for ways to fool the board and to allow their forgery to continue. So I do want to focus on the Ackerman complaint, which is a very different context from what you just heard in the United States Senate. As demonstrated by both the Nielsen and the Ackerman complaints, which are really companion complaints that we both filed and were reviewed by the same set of lawyers and analysts, there was a gang of forgers at work on both of those petitions. The staff's Nielsen report found signature forgery in her petitions, which in part substantiates the forgery claims of the Ackerman challenge. Those claims are substantial enough to warrant full consideration by the board after a complete staff report. And for reasons I'll explain in a moment, there's ample time to do that. I'm not going to reiterate the detailed allegations of forgery, which are set forth in our complaint in dozens and dozens of pages with hundreds of examples of forgery in the Ackerman complaint. I would like to focus, though, on the footnote in the staff report, which rejects the idea that a full review of the Ackerman petitions would not result in them being disqualified from the ballot. One of the first claims in that footnote is that nearly 500 signatures should not be rejected on the basis of circulator forgery. Circulator forgery is a very serious problem in this state. That footnote says that the procedures that the staff uses to review petition signatures do not include circulator forgery. However, the law is very clear that circulator forgery is illegal in this state. It's illegal to make a false statement in a certificate on a petition. It's illegal if you're not a circulator to sign a petition as a circulator. And it's also illegal to sign a name as circulator other than his or her own. That comes directly from the election law. All of those provisions make circulator forgery, the forgery of a circulator signature on a petition, illegal and should disqualify the entire petition. But another way, I could come before you and file thousands and thousands of petition sheets as circulator, and in a way that would be physically impossible for me to have done so, but yet you would have no recourse against me having obviously forged my name on sheets I did not circulate. That's not the law, and we cannot permit that to happen. The analysis and the balance of the footnote is speculative. It's not based on even random sampling. It says it's highly unlikely, it is unlikely, extreme unlikelihood. Those are guesses. That's speculation. There's no examination of the Ackerman petitions as there should be. So turning now to the fact that our challenge was filed a few days after the deadline. First of all, the April 30th deadline is not really a deadline. It's consistently referred to that way. But the statute simply says that any challenge filed after that date may not be considered by the board. It doesn't prohibit you from considering it. It simply says you're not required to do so. And I think of all the circumstances under which a challenge filed a few days late should be examined is when there's evidence of forgery, as there is here. It took my team and I a long time to evaluate the more than 30,000 Court of Appeals petition signatures that were filed, and we looked at all of them. There was no favor here. I was hired by Ms. Beauvais to review all of them. And we found forgery, significant forgery and other problems in the Nielsen and Ackerman petitions, and that's why we brought those challenges. In addition to that time and the statute, this board has a longstanding practice of considering challenges after the 7-day period. I think only member Bradshaw will probably remember what I'm about to say. In 2014, this board accepted a challenge to a ballot proposal the day before its meeting. I represented the petitioners in that case. It was a ballot proposal to raise the minimum wage. The initial staff report said we had enough signatures. The day before, our opposition filed a challenge based on duplicates they had discovered, and the staff report then changed. The staff report said, looking at this late filed evidence, we now conclude that there's not enough signatures. So again, this board has precedent for considering challenges, again, up to the day of the meeting. And so there's ample precedent here for this board to consider this full-fledged sworn challenge with detailed evidence. There's also a unique circumstance that you have that enables you to look at the Ackerman challenge. Only 4 candidates filed petitions for the Court of Appeals for 2 positions. Under the law, there will be no primary in this election. Whichever candidates you certify go directly to the ballot. So you face no deadline of today or June 4th or the immediate near future to certify. There is time for you to direct the staff to conduct a thorough investigation of the Ackerman petitions, bring you a report, which then you can make a reasoned decision about whether Mr. Ackerman should qualify for the ballot. So for all these reasons, we ask that you accept the Ackerman challenge, direct the staff to conduct a report, make a report for you, and bring that back promptly. so the board can make an informed decision about whether Mr. Ackerman is qualified for the ballot. We do not believe he is, but we will see what the staff report yields. Thank you very much, Madam Chair.
Mr. Doster, you have also asked to speak.
Thank you, Madam Chair. Appreciate the last minute. I didn't know I was going to be speaking on this. Eric Doster, on behalf of Matthew Ackerman for Court of Appeals. I sit in an unusual position because I represent Mr. Frankel, who filed one of the challenges to the Nielsen fraud petition, a challenge, by the way, that was filed timely by April 30. There's a number of things wrong with Mr. Brewer's argument. First, he said that this board has the authority to review a challenge after the April 30 statutory deadline. Not only does the statute section 552 suggest otherwise, but the reasoning that Mr. Brewer gave you, referencing a ballot proposal that a late filed challenge in 2014 with respect to a ballot proposal, which is not governed by section 552. And this board did allow some late challenges back in 2014. This is a candidate petition. And on candidate petitions, the statutory mandate is that the board can process the challenge received by the 7 days with some exceptions. And those exceptions, in fact, were invoked by this board with the Senate filing deadline going from April 30 to May 2. But there's also this case called Callahan, a 2002 order from the Michigan Supreme Court, which said that this board could not review a complaint filed after the statutory deadline. So you don't have authority to review it. But even so, the board, the Bureau of Elections did review the Ackerman challenge that was filed after the fact. And as they said in their footnote, they reviewed it. And because Matthew Ackerman had so many signatures necessary, that it was highly unlikely that any review would have yielded a different result. So they've already done that for this board. So this board has already done its duty with respect to fraud, invalid signatures, whatever, dates and the whole 9 yards. The board has already complied with its duty. So for all those reasons, I would, and by the way, what happened also with respect to this challenge that was filed a week late, the Bureau of Elections appropriately dismissed the challenge, and we weren't allowed. We didn't even get a chance to respond because it just wasn't anything to respond to. So there's just a lot of reasons to accept what your staff has done and to reject this, again, this last minute ditch effort to go after a challenge that was filed well beyond the statutory dedeadline. With that, I'll ask
Mr. Brewer, do you want to come back and join Mr. Doster? Do we have questions? I have a question for our attorneys about the issue just raised by Mr. Doster, who says that the board has no authority to consider a challenge filed after the 7-day period.
Member Gertz, if you're speaking of Mr. Doster's reference to the Callahan case, I did look at that. It did say that it did reverse the decision to look at a late filed.
I'm sorry, Dan.
The court in that case did reverse, a decision. It said that you couldn't review a late filed challenge after the 7 days. But I would note that the statutory language has changed since that decision, so that it used to say shall not consider a late filed challenge, but now it says does not need to consider, or whatever it is, So it's not clear to me that Callahan is really operative anymore in light of the statutory change.
If I may respond, but it only, Callahan is still viable in that for the proposition that I cited for this, the board can extend the challenge period for the circumstances as set forth in the US Senate candidate. That's where the signatures weren't allowed. That's where the statute was amended to allow this board flexibility that in fact, hey, you didn't give the sample or the petitions available to the prospective challenger. So therefore the board can extend, and I believe it's only an additional 7 days or something like that, as I recall the statute. I might have that wrong, but Heather, but anyway, that's the only amendment to the statute since then.
Well, I disagree with Mr. Doster and agree with your counsel and the Attorney General. After the Callahan case, the statute was changed to say the Board of State Canvassers is not required to act on a complaint respecting the validity of signatures unless it's filed within the 7-day period. So it went from shall not to you have discretion to consider a complaint that's filed after the 7-day period. The 7-day extension that Mr. Doster just referred to only arises in the case of when the petitions are not timely available to a challenger. It's a very narrow exception, but it does not restrict the board's discretion after the 7-day period to act on a challenge.
Thank you. Director Britter, I have a question, and that relates to circulator fraud, in that what has been brought to our attention is that circulator certificates in different handwriting from using the same name have been found, I think, both in the both of the Court of Appeals candidates who have been challenged. So you will have 6 different handwriting circulator. I'm not putting this correctly. You have somebody signing as circulator using one name, but clearly that circulator certificate comes from 5 or 6 different people. Are you taking the position? Because it seemed to me from what the footnote with regard to the Ackerman complaint, the footnote suggested that that was not something that would be considered. Am I correct?
So as I understand the attempted challenge, it was suggesting that the person who wrote the circulator's name in the circulator box and signed it was not that person. They were impersonating a circulator. We don't have a specific procedure to address that type of challenge. We do sometimes get challenges that are related to circulators, and I'm just going to ask Adam to explain what those look like. But typically we need a specific timely challenge to aspects of the circulator box to review that. I think for future years, we could look at developing and adding to our manual processes for that specific type of challenge, which is asserting that, not only as opposed to the circulator having made some kind of error, that it actually wasn't even that person who signed it. But we don't have those procedures right now. So this is not something that we have a process, but regardless, we would have needed that challenge to be timely. Even if we could consider it, would have needed to be timely. Adam, do you want to add a little bit more just context to how we look at circulator issues?
Yeah, so in general, there's a number of court cases that deal with circulator requirements as well. So first, you don't have to be a resident of Michigan. You don't have to be a registered voter in Michigan to circulate a petition. So there isn't a clear way on how to treat some of these things equitably. If someone who's registered in Michigan signs a petition, we would be verifying their signature, but then we wouldn't be verifying or validating a non-registered voter or a non-Michigan resident. So now now we're not being consistent with how we're treating. So that's part of the other complication with circulators as well. In the instances where challenges have been raised to the board in the initiative petition context, mainly that I'm thinking of right now, challenging residency or things like that of what's written on the form, there's been evidence provided with it. So the one that's coming to my mind was that a circulator put an address that was actually a UPS store. And we accepted that challenge and actually invalidated that signature. because of the requirements around there. But there was evidence provided of the building itself, I believe registration records from another state or something like that, but there was something connected with it. So in general, when we're looking at circulator stuff, we're looking at, is that box filled in? Is it signed with something there? Is the circulator's name an address that is not a PO box there? Is it dated, et cetera? We're looking at the facial elements of it. And then from there, we would process any timely received challenges that would provide us evidence with something to the contrary to invalidate based on that element.
I'm looking at the petition manual. And it's defects in the certificate of circulator, which render an entire sheet invalid. A petition sheet is invalid if it contains one or more of the following defects. The petition sheet is not signed by the circulator or is signed by more than one circulator. I'm not quite sure how a sheet is signed by more than one circulator, but if you have 5 sheets, all of which have the same circulator name, but in 5 different handwritings, then you know that at least 4 of those are signed by a circulator fraudulently. So,
Sorry, go ahead.
okay, so one of, and it might be all of them, but at least only one of those can be a legitimate circulator certificate. And the rest of them, I don't know which one it is, but it creates, but you have some ability to look at the validity of that signature and to compare it to whatever is in the QVF. Understand that, right, and that person doesn't even need to be a Michigan resident, so you might not have that. But you do know that there are 4, if I'm saying that you have 5 circulator certificates signed in 5 different handwritings for the same circulator, you know that at least 4 of them are false.
So 2 points with that. So one, we actually have what that bullet point means when it says to not sign it or to have multiple on the same page. We have had instances where circulators have drawn a line down the middle of the block and 2 people have filled it out. And that's invalid because we don't know which circulator circulated when. So that's what that means with that point. And then this only other piece I would point out is that there's no requirement that the circulator fill out that circulator box beyond signing. So the circulator needs to sign the petition, but somebody could put their name down, like I could assist in writing somebody's name down for them and then the circulator sign it. So that it's just another complication with how all of this works together. And especially if they're not a resident in Michigan and they're not registered to vote, we don't have a way to compare that signature in those 2 instances.
Madam Chair, may I respond?
Yes.
Join the dialogue here. First of all, this is about the signature. So regardless of what the rest of the box does, we have forged circulator signatures. The staff has done a tremendous job with the manual, but it appears that the manual has a shortcoming and that it doesn't track the election law, which is what governs here. And I quoted earlier, an individual shall not sign a petition with a name other than his or own, make a false statement in a certificate on a petition. If not a circulator, sign a petition as a circulator or sign a name as circulator other than his or her own. Now, I understand upon the staff's facial review, they may not be able to determine that. But here we have given them evidence of forged circulator petitions, example after example after example of the same name appearing as circulator in different handwriting. So now we ask that those be examined and as to whether there's a violation of the law, which would invalidate those entire petitions. Perhaps the manual should be corrected going forward, but the law governs here and the law says those signatures are forgeries and those petitions should be tossed.
If I may make one.
I'm sorry, I don't have any questions for Mr. Doster or Mr. Brewer. I actually have a question for our Attorney General representative, if I can. So Heather, I'm not a lawyer. What interpretation are you giving to us as the board members on the question of timing? in the interpretation of that statute, given Callahan in 2002, I think I said that correctly, and what the statute says now. What would be your advice to us on the board in regards to timing? Because I do remember that. I actually do remember that 2014. I know that it's not a nominating petition, but I do remember that. I do remember that meeting very well. It was not an easy meeting.
They never are.
No, they're not. But I know that it's two different statutes. I understand that part. But for us, given nominating petitions, what are you recommending to us for the question of timing?
I guess I'm not sure it's a recommendation, but looking at the plain language of the statute as it exists right now, it says the Board of State Canvassers is not required to act on a complaint. That's not the same as shall not act, right? So it seems to me that the plain language of the statute suggests that the board does have discretion to look at a late filed complaint. And then the board should just consider, there's factors as to maybe why you wouldn't, consider a complaint late. But you're not barred from doing.
I'll make a recommendation. But not, I mean, obviously defer to the AG's office on the interpretation of the statute, but just in terms of the general issue of the late challenges, without weighing in on whether the board has, what the board's authority to do is, we do need to have a deadline for challenges. Because if this year it can be 2 days late, then first of all, 2 years from now, we could have 30 people submit 2 days late. We could have people submit 3 days late. And at a certain point, we need to have time the staff needs to have time to do our own independent review of the 130 some petitions we have. We need to have time to do an independent review of the challenges that we get. We need to give the candidates who are challenged time to review the challenge and respond, and we need to have time to review their response. We also have to have time to put together these staff reports for you, and then give the candidates and campaigns time to respond to those as they're doing today. So we don't really, like, practically speaking, for a consistent and uniform process, we do need to have a deadline, in my opinion. But putting that aside, I think, I can certainly imagine some compelling circumstances where it might make sense for the board to consider later information, even if it wasn't in a challenge. I don't think this instance meets those requirements. I mean, one, yes, there's this issue about potentially people forging another person's signature in the circulator box. I'm not saying that we shouldn't or couldn't consider that in any way, but I am saying that in order to consider that, we would need, particularly given some of the novel issues being raised here, we would need specific timely challenges that pointed us to all of the individual sheets that are, alleged to be invalid and why. So we would need that. Number two, going back to just the more kind of compelling circumstances or lack of compelling circumstances here, even if, as I said, or as the footnote in the general staff report indicates, even if we did consider those 499, and even if all of them were invalid, which I think is unlikely, and that's, just to speculate that because some of those circulator boxes were forged or may have been forged, that all of the signatures on all of those sheets are invalid. I think that's quite a leap. But even if we assume that, what we're left with then is that would bring Ackerman in this case about 300, I think maybe exactly 300 signatures under the threshold. When we start our review of the signatures that are alleged to be fraudulent. And there are about 4,000 of those. So, or 4,400 of those or something like that. So just when we looked at the Nielsen one, what we found is about half of the signatures that were alleged to be invalid were invalid, and about half of them were valid. And so even if we took all those 500, out, when we looked through these additional 4,400 that are questioned, in order to take Ackerman under the threshold here, we would need to find that like about 4,000 of those were invalid. So about 90% of those were invalid, which would be a much higher rate of invalidity compared to what we found in Nielsen. So yes, I can't say that to a certainty, but just given the context here, I don't see compelling circumstances for the board to ignore the challenge deadline, given some of the complex issues here and given the fact that it would have taken quite a showing of invalidity to bring this candidate under, even if we had the challenge timeline.
May I respond, Madam Chair?
Yes.
Our complaint contained dozens and dozens of pages of lists of individual circulator and signature lines, which were invalid, organized circulator by circulator. We've given you all the detail you need to do the examination as we are required to do when we filed a challenge. We specified circulator names. We specified petition signature lines. It's all there. It just needs to be reviewed. And in the course of that review, you may discover other matters. You can't simply project and speculate and guess that it's unlikely or it's not possible. We need to take an examination. Candidates get on the ballot in this state based on facts. Did they file enough signatures? Not based on a guess or it's likely that they had enough signatures. And there's time to do this. There's ample time to do this. This board doesn't have to certify these candidates, frankly, until August, given that they're only going to appear on the general election. So we're not suggesting delay. I look forward to Mr. Doster's defense of the forgery in the Ackerman petitions that he attacked in the Nielsen petitions, but I'll leave that for him to deal with. There's time here to deal with this very serious issue of forgery under these unique circumstances. If you want to change the deadline or make a deadline in the statute, that's for the legislature. That's for the legislature. Legislature did have a deadline, but they changed it. If you think there needs to be a deadline, ask the legislature to impose one, but you have the discretion to consider this challenge under these unique circumstances, and we urge you to do so.
Madam Chair, I think I've given my dear friend, Mr. Brewer, enough rope. So I'll continue on with the point. At some point, where do you draw the line? And when we were advised that the Ackerman challenge wasn't going to be considered as a legitimate challenge, my first reaction to the Bureau of Elections was, had you not done that, have you considered this challenge? We were going to file 2 more challenges in the same Court of Appeals race, and ours would hit, and they wouldn't be highly unlikely. So if you're going to start relaxing challenge dates and statutory deadlines and considering complaints that are, which you really can't do, as I've indicated earlier. But if you're going to start opening up that Pandora's box, I look forward to Mr. Brewer's defense when we file 2 fraud challenges that will be sustained against in this same Court of Appeals race. And then you've opened it up not only just Court of Appeals, but every race now beyond April 30. So I would just ask that you uphold the Bureau's sound determinations in this regard.
Thank you. Anything else? Going to recess for 5 minutes, no, 10 minutes. This has taken longer than we had intended, but probably not longer than we had anticipated. Okay, we'll be back at, let's say, 10:15.
I'm thirsty.
I would say it. Give it your all.
Oh, sorry.
So we have several complicated issues, all related to agenda item number 2, the certification of candidates for the ballot. The first issue that was presented to us was from Mr. Trebilcock, who I thought was asking us to ignore the result of the random sampling and not to certify, although it was not altogether clear to me whether Mr. Trebilcock was simply asking us to investigate or whether he was asking us not to certify. In any event, I think that it's my opinion that we decided to do random sampling. The random sample of all of the Senate petitions that we're talking about here indicated that each of those candidates had a sufficient number of valid signatures. And so I would not refuse to certify the Republican candidates. And I can't remember exactly which ones he was addressing, but I guess it was all of them. So that's my something that a position that I think is an important one, an important position for us. What do others think about the Trebilcock challenge?
I think that it was, as we always do, people bring up questions of process and concerns of process. Did I feel that it was, did I feel that he was asking us not to certify? I don't know. I think more, my impression was there should be investigations and we should be investigating if there are instances or indications of fraud. But I think that anyone, all of these, whether it's in the deadline or not, that there should be. But I think, I asked my questions during that process of whether or not we should go to random sampling. But I do feel that it's a good thing to bring up questions and ask. I'm at this point, if you're asking, Chair, if it would at this point change my position of whether or not supporting the staff report, I don't think so, but it does add to the questions that we always have when we come to these certifications for petitions.
Could I toss one in?
Sure, of course.
So take it out of the realm of elections a minute, okay? If I went out and bought a car and there was a problem with the car, and it was a violation of the state, the Secretary of State got involved. Secretary of State is not gonna assume I am the criminal. They're gonna go after the car dealer. And I'm telling you that because what I'm gonna suggest is that we go ahead and we do the certification here. We accept what Jonathan and his folks have told us. But then after we're through today, maybe we look at this and say, there are some circulators that may be bad actors. And maybe we ask the Bureau of Elections to look into or open a case on those circulators. I'm not using the right words, but you get it. Is that a reasonable, if we think we've got circulators working in the state that are bad actors, it's not candidate specific. It's going to affect everybody.
And in some cases, those circulators are working for multiple candidates. So, that is something that happens in this state. So when we go from volunteers to a paid incentive industry, that's what happens. So yeah, I think so. I'm confident to support the Bureau's decision and the Bureau's staff report today.
I agree, and I think a motion is probably coming soon. And on the issue of the circulator, having friends in the petition circulation business, the circulator problem is a key concern for them. because is not only is it undermining our system, it's undermining the integrity of the system. It's undermining their ability to conduct business. It's undermining the funds that candidates of all stripes pay to these firms to do this. And it's really difficult to catch. And I think legitimate firms strive very hard to have a good model and have integrity and check these things. And I know of people who have captured this and passed it along to law enforcement and to the Bureau because they care about this. And so I think if there's a way for us to, encourage review outside of what we're dealing with here with these candidates, then I think we should consider that. But I think ultimately it sounds like we're ready for a motion on certification of the staff report. But Jonathan,
Well, just a note on just the structure of the motion. So this is a general motion for all the candidates except the ones with their staff reports. And so I understand it makes sense that we heard from folks at this juncture because they had issues with some of those candidates. We heard from some folks on the Senate candidates. We heard from Mr. Brewer, Mr. Doster on Ackerman. I think we have one more person who wants to present on another name they think should be on the list that's currently not. So if the board, after having heard from everyone, is still comfortable with the list as it exists, we can just have a single motion. If they're not, then we'll need to talk about how to break it up.
Just one question. You still have one item on here, Polizzi, the governor's appointments. We need to go through that. Is that correct? Or can we just, are we accepting what you're doing?
Because Mr. Riddell, my assumption is Mr. Riddell, who's Judge Polizzi's attorney, thinks that she should be on the list that's going, and she's currently not on the list. I think it'd be most logical to hear from him prior to voting on that motion to see if the board, what the board thinks of that.
So we would need to hear from him now before we make a motion?
I feel that we need to hear all of those that are in that candidate list, if there's any concerns. So before we make a motion to approve a candidate list, I think we need to hear from all of them. So I think we need to hear about our current, our newly appointed judicial candidate. Well, yeah.
Maybe I'm misunderstanding. The individual that Mr. Riddell is not on the list, but they think should be on the list. Are we better off addressing the list as it is with everything we agree on and then moving on to that one? And we can do that individually. That way the folks who are on the list can go about their day, or?
I guess it doesn't really matter. You could do a separate motion. So we could approve this list and then consider the issue of Judge Polizzi. And then if the board thinks she should be added, the board could entertain a motion specific to her. Or you could consider it now and then just do the motion. Adam or Heather, do you have opinions on this? I don't.
Does
6-1.
does Mr. Riddell have a preference? If he is fine with doing it that way, to me, it makes sense to clear our slate of this list and then move forward.
Okay. Yeah.
We're okay with that?
Yeah.
Who wants to do the motion?
I'll happily do the motion if somebody tells me when to do it. I believe in reviewing it, somebody needs to read off the portion laying out what this list contains and what it is we're approving.
There was something in there about that.
It'd be in your folder.
It's like,
If you look in agenda item number 2 in your packet, it's number 1 is the motion regarding the candidate listing.
Secretary reads the following introduction.
Okay, that's me, right? Okay. Okay, let me read that.
I'm sorry. I'm trying to look at this recently submitted letter, which.
The letter, you're trying to look at the motion.
No, I'm trying to look at this letter that is the last thing that came from somebody named, also addressing the forgery issue.
we'll make that part of what we ask the Bureau to do.
Right. Okay.
So I will proceed to introduce the motion. The list you have before you contains the names of candidates who have filed a nominating petition found to be sufficient under a review carried out by the staff. The candidates are seeking nomination to the offices of United States Senator, Representative in Congress, State Representative, Judge of the Court of Appeals, Judge of the Circuit Court, and Judge of the District Court. Those candidates who have individual staff reports based upon a staff finding of insufficiency of the petition, a challenge, or both regarding the sufficiency of their petition pending before the board today do not appear on the list, although we understand that some interested parties have discussed some of the candidates appearing on this list. Prior to addressing the petition sufficiency issues that will be discussed on the staff reports, staff recommends that the board adopt a motion finding the petitions filed by the candidate whose names appear on the attached list sufficient.
I move that we accept staff recommendation and find the petitions filed with the Secretary of State by the candidates appearing on the list sufficient, with the understanding that the list does not contain the names of the 28 specified candidates who have petition sufficiency issues pending before the board. I further move that the candidates who filed a sufficient petition with the Secretary of State for the offices of United States Senator, Representative in Congress, State Representative, Judge of the Court of Appeals, Judge of the Circuit Court, and Judge of the District Court be certified to the Secretary of State for the August 6, 2024 primary ballot. This certification is to include any additional candidates who we find to have filed sufficient petitions under today's hearing.
I'll support.
All in favor?
Sorry, Chair.
Sorry.
Before the
Member
vote,
Gurwitz, yeah.
the AG's office just wants to make one note about one of the names on this list.
Thank you, Jonathan. Yes, I just want to explain something that I do not believe holds up your motion and that you can support the motion vote. But there is a candidate on that list. It's Kalilia Davis, who's a candidate for 36th District Court in Wayne County. And we currently have litigation against her with respect to whether she should be disqualified from the ballot for multiple reasons, whether it's her AOI or other defects. We had a hearing in that case, and that case is against the secretary. So the board is not a party. So we had a hearing in that case yesterday where the judge indicated that he intended to issue an order next week disqualifying Ms. Davis from the ballot. And so we don't have that order yet, nor would that order really run to the board. So my recommendation today is that there's no need to hold up or belay certification of her name at this point, because the court's order is going to run to the Secretary of State. And in that case, the Secretary of State will simply not include that candidate's name on the certification that the Secretary makes to the counties themselves. I just want to clarify that because I believe it was in the news a little bit yesterday about this, and in case there's any questions of why she's still on this list.
Just to confirm that order would be, the judge would sign that order at a date, not today, but later in the future.
It may be next week as early as Monday, but we don't have an order.
It'll be after what we do today.
It'll be after, it is after today, correct? And that's, unless there's any more questions, I just want to make that note.
We have a motion. Do we have any further discussion of that motion? I have real concern about the Ackerman issue, but I'm particularly cognizant of the importance articulated by Director Brader of having deadlines given the difficulties that the Bureau has in processing these many petitions. I will urge and we'll make a motion later to further investigate persons who have been identified through various complaints whether timely or not, persons who have been identified as forgers or and I am particularly concerned about circulator forgery. So that is something that I think we will need to address. Anything else? All right. The motion has been made and seconded. All in favor?
Aye.
Aye. The motion carries. And now we have another issue to address with the candidate list. Is that correct, Director Brader? Do you want to explain it?
Sure. It's not something that we brought before you, and I'm not 100% sure what the board's authority is here. I would defer to the AG's office on that. This is not an individual who submitted nominating petitions, so there are not nominating petitions to canvass. But the issue is essentially that a judge was recently appointed after the deadline to submit nominating petitions or the affidavit of candidacy that an incumbent judge would fulfill. So based on that, our view is that although she is a judge, it's too late for her name to appear on the ballot for August or November. And so it would be a write-in, and it's too late for anyone's name to appear on the ballot for that race. But there is a attorney here on her behalf who disagrees, and I think wanted to present to you on that. So we could hear from him, and I can share my thoughts, and you may also want to consult the AG on this.
So, yeah, please state your name for the court reporter, or for the board reporter, I should say.
My name is Peter Riddell with the Honigman Law Firm on behalf of Judge Laura Polizzi. So Jonathan gave a very nice summary, and you have a handful of correspondence between us and the director on this issue that are, I assume, are in your packet. The issue here is Judge Nicholson in Rochester in the 52nd District Court, the 3rd Division, announced her retirement on or around February 29th. The retirement was to be effective April 1st. No notice was provided to the Secretary of State or the Bureau of Elections regarding her retirement or resignation. The Bureau, no redesignation memo was then issued for this vacancy that became effective on April 1st. So there was no opportunity for an individual to circulate petitions or have noticed that this would appear on the November ballot. On May 17th of this year, Governor Whitmer appointed my client, Judge Polizzi, to the bench. On May 24th, the judge filed both her oath of office and her affidavit of candidacy. As is highlighted in the correspondence, the Michigan Constitution requires, it's a mandate. It is not optional that an incumbent judge is required to receive the incumbency designation on the ballot. Judge Polizzi is an incumbent judge seeking election this year. She is entitled under the Constitution and state law to the incumbency designation. In the past, after the effective date of a resignation or retirement, the Bureau would have normally issued a redesignation memo. I've included in the letter that we attached today, the 2020 redesignation memo, which had multiple updates as vacancies and appointments occurred. In this case, Judge Polizzi had no advance notice, no ability, no opportunity to gain access to the ballot through nominating petitions. She was forced upon appointment to file her appropriate affidavit of candidacy and oath of office as soon as she could. Through no fault of her own, she is being denied access to the ballot and her constitutional right to an incumbency designation. If the governor made the appointment today, would this be an issue? Right? The issue is, when did the vacancy occur? The Bureau, right, had no notice of the vacancy prior to the filing deadline on April 23rd. Therefore, April 16th is the controlling deadline by which a vacancy, if a vacancy is known, occurs prior to April 16th, it would appear on the November ballot this year. If the Bureau had no knowledge and the Secretary had no knowledge of the vacancy on April 16th, it should not appear on the ballot. In the alternative, the judge, through her constitutional and statutory rights, is entitled to her incumbency designation on the ballot, and you are certifying the list for the ballot today. Her actions were as timely as they could possibly be, given the circumstances. I'm happy to answer any questions and have dialogue with Mr. Brader if appropriate.
Is she sitting now?
She is sitting. She was sitting. Her first day in the court was Tuesday.
If we can frame them.
Yeah.
I guess I can sort of summarize how we look at this at the Bureau. And again, to the extent that we're interpreting the Constitution especially, but also statutes, and to the extent they involve the board's interpretation of those statutes, I defer 100% to the Attorney General. But from our perspective, I mean, we completely agree, like there's nothing else that the judge could have done here. The issue is that there is a deadline it's not really an issue of whether she gets the incumbency designation, which if she were on the ballot, we agree she would. The issue is whether her name can get on the ballot under these circumstances. And the issue with that, and which is a little different from the other cases that we've had on this, is that the deadline either to submit an affidavit of identity with nominating petitions or an affidavit of candidacy for an incumbent judge has already passed. So it's too late to for her name to go on the ballot. It's an unusual situation, but that's what we think the election law requires. And I guess just a couple other things to note. If it were otherwise, number one, there isn't necessarily like a deadline for that or a back end for that. So this could theoretically happen at any time, you know, even closer to August or November when ballots had already been circulated, and we could have a major problem there where we have a name that has to go on the ballot when, you know, it's 2 weeks before the election and people are already voting. The other issue is that if her name did go on the ballot in this circumstance, then it would be impossible for anyone else's name to get on the ballot. So it'd be impossible for anyone else to file to run against her except as a write-in. So those are just some of the consequences that would fall, you know, from this. But, you know, obviously it is an unusual situation. But that's the way that the Bureau of Elections views it. Adam, do you want to add anything to what I said?
Was she appointed to a partial term,
Correct.
which ends?
It would end in January 1st of 27. May I respond to, you know, some of the other comments
Please do.
that Mr. Brader made?
Need help.
So, right, I mean, I'm sympathetic with the issue because the gap here is the Bureau's notice, right? The Bureau, frankly, didn't have notice prior to the April 16th deadline in which to reissue a redetermination memo. So there is an argument that this is not eligible for the election in November of 24. I think that's outside the scope of this board's authority to determine based on what we have here. That's probably going to be something for a court to determine. But in the alternative, you are certifying the list of candidates today. To suggest that an incumbent judge, in order to be elected, must run as a write-in candidate violates her constitutional requirements to have the incumbency designation on the ballot. In our mind, it is really that simple. In his response to our letter, Mr. Brader indicated this is an issue between ballot access and incumbency designation. And she had no opportunity to access the ballot until the appointment was made.
So she is sitting now and she will be sitting through?
She will be sitting through January 1st, 2025, as it's currently proposed.
And if,
Can I just 2027, if it's on the ballot for a partial term in November, the term will expire in 2027.
If there is an election in November and she's successful, this term that the governor appointed her to, right, expires January 1st, 2025.
so if she's not on the ballot, then she's just, she continues to sit.
So according to the advice that I think that Jonathan and the AG may provide is that they are going to put this on the ballot as a non-incumbent position for the remainder of the term, January 1st, 2027. She would be forced to run as a write-in candidate under that scenario, which we believe violates her constitutional rights.
That I'm just struggling to formulate this. So if there was no notice of this, then why is the position on the ballot this year? Would the alternative be that she serves through this term and then it's vacant and we have an election in 26 on this?
That would be the argument that she, because the timing did not hit that April 16th deadline for the Bureau. I don't have the section at the tip of my fingertips, but you have 7 days prior to the filing deadline. If a vacancy occurs prior to that date, then it's up for election this year. After April 16th, 2023, it would be up for election in November of 26, the remainder of the term, if there is one, or a full term.
Risking is either we get them.
My
push
request,
the
of,
election off
my
until
request, my
26.
request of the board is that she be listed as a candidate. She filed the appropriate affidavit of candidacy. She'd be listed as a candidate for the November 24 election as an incumbent judge for the remainder of the term.
Do we have, is that an authority within our purview as this board?
That seems to me like a legal question that we really don't have the authority to decide. Heather, we can't hear you.
Yeah, well, all right. I was trying to get Jonathan to take the lead. I think I agree that this is not the question of how or whether or what designation, you know, that if she gets on the ballot is not a board question. Because the Secretary of State's the filing official for the affidavit of candidacy, and that was rejected. So that was, so as of right now, the Secretary of State has sort of rejected.
So pardon me, Heather.
Let me finish. So it really is, and as far as slotting and how it would be designated on the ballot, all of those things are, I believe, Secretary of State, Bureau of Elections questions. So the only authority the board has is she's either on the big list or she's not on the big list. But how and why if she belongs on the list, I don't believe is a board question. It is, you know, a secretary question, or it really is a legal question, right? Because we're in limbo land because this isn't governed really by any statute. You know, there's no fault of the Bureau's part, the Secretary's part, that they did not get notice of this vacancy. And, you know, the candidate really is not at fault either. So this is, I think, one of those prime questions of a legal question that would need court resolution. And our advice to Director Brader and to Bureau staff is, in this situation, just follow our statutes and the law as closely as we can. And I believe that's what they have been attempting to do as far as getting, and Jonathan, if I've said anything incorrectly, or Adam, please feel free to step in, because this is a one-off situation.
So, so if I hear you correctly, what you're saying is if we could put her on the list, that would be the limits of what we can do today with our mandate. And then it would go to a court to determine whether incumbency status.
My question is, do we have the authority to entertain this based on the steps that have occurred to this point? And I don't want us, we get enough random stuff that we deal with here to not take on something new. So that's my addition to your question. Mr. Rudell shook his head at one point when Heather was speaking. And so I'm just curious what you were going to say, Peter, because that might help answer some of this.
So the Bureau did accept the affidavit of candidacy, and they have provided the judge instructions on compliance with the Michigan Campaign Finance Act. So that happened on Tuesday, I believe. And then the letter I received from Mr. Brader was yesterday.
Yeah, so we physically took the affidavit of candidacy, but we rejected it to the extent that it was attempting to put the candidate's name on the ballot for this election for the reasons explained in the letter. And in terms of what, I mean, I don't think I can advise the board on what the board has authority to do with respect to this list. The Secretary of State is the filing official. So, our determination with respect to whether the candidate's name will appear on the ballot and how is under the Secretary's authority as a filing official. I assume anybody who disagrees with us on that will sue us, and then a court will decide the answer. But I cannot tell, I don't think I can advise the board on whether, understanding all that, the board can add the judge's name to this list.
Seems like, so I'm trying to liken this to something like a state representative candidate whose AOI is rejected. That we don't deal with that. So if they were to come here and say, oh, they improperly rejected my AOI, put me on the ballot, we wouldn't have the authority to do that. That's my understanding, which this seems to be the same type of situation. So I'm thinking it makes, like, let's just pass on this, and then Peter can go down the street or wherever he needs to go to file his challenge in the legal system.
Can I respond?
That makes sense to me as well.
I mean, with all due respect, Mr. Don, your action today is certifying the list of candidates, right? That's the action that you are taking today and have taken by and large for 390 or 700 candidates, whatever the number Mr. Brader read off. I think it's patently unfair that my client is forced to resort to court action and forced to undergo all that expense for really a fairly simple question that is a legal gray area. And I think it's patently unfair that she's being forced to do so when you have an opportunity to certify her for the ballot. And frankly, those who don't want her on the ballot could have that burden as opposed to my client.
We have the opportunity, but our question is whether we have the authority to take it, to do that. And I don't.
But we can certainly gamble with it. We'd find out very quickly if we had the authority, depending on what happened.
Exactly.
That's true.
Forgiveness is always easier to ask for than permission.
Do you want to make a motion?
Sure. We have a motion. We have wording for one.
I'm happy to draft one for you.
Member Hauskamp, are you suggesting that the board make a motion to place her on the ballot?
I am. You think it's a bad move?
I do not think that the board has the authority to put her on the ballot.
Okay, that was.
Where the Secretary of State is the filing official and has rejected her affidavit of candidacy.
That got an answer.
So you're not.
Under the circumstances and what we have, what our knowledge today and what our law is today. I mean, that's my best.
I'm just trying to break the impasse on whether or not we can move ahead and
if
we have
there
the authority or whether we have to figure it out the hard way.
That's my recommendation.
I completely agree. This is a really unique situation. It is patently unfair, but I'm loath to strike out on a new path on this when it seems pretty clear from our legal counsel we don't have that authority. And we lots of these situations over the years that I've been on this board where you're like, well, that's really ridiculous that that's costing this person a slot, but it's the rules, it's the law. And I'm more comfortable falling back on that and, creating more work for you, unfortunately, but I think it's ultimately the right thing to do within statute and authority.
May I reiterate one question that we identified in both of our letters? At what point in time did this vacancy occur? And I think the question is, right, the vacancy was announced on February 29th, effective April 1st. The Bureau took no action to reissue the redesignation memo or provide an opportunity for those interested candidates to circulate petitions for this position. And so, right, I would argue that this should not be on the ballot. Again, this is not your position, not necessarily your authority, but one thing that I am very interested in is when did the Bureau learn that the vacancies occurred and why was a redesignation memo never issued? And if appropriate, Jonathan and I can continue our love letter exchange in order to resolve that question.
Right. Yeah, I
I don't
think
know if we
this
can
issue
answer
will
that
have to be
specifically,
addressed
but yeah.
in a form other than ours. Thank you. I believe we're ready to move on to agenda item 3.
Yes, thank you, Chair Gerwitz. So we're now on to the individual staff reports. The first one we have for you is regarding Nasser Beydoun, who is a candidate for U.S. Senate. In this instance, the staff on face review of the sample, but it also applies to the entire petition, identified that the street address or rural route included a PO box as opposed to a street address or rural route. That is not permitted as a street address or rural route on the nominating petition. So based on that fact, we determined that all of the signatures were invalid because of the header issue. There is a case that we pointed to in the staff report, Morgan versus Board of State Canvassers, that was on this issue that found that the PO box could not be used for that purpose. I believe we perhaps have, do we have someone who wants to speak on this?
So we have a request from Mr. Beydoun. Can you spell your name for the reporter, please? And who is with you?
There's a little small button.
There we go. Good morning.
Good morning.
My name is Nasser Beydoun, Nasser Beydoun. Shall I start? First of all, thank you for giving me the opportunity. I decided to run for U.S. Senate because I felt that people like me were disenfranchised from the political system. Our voices weren't being heard. This is my first time that I ever ran for a political office. I never wanted to be a politician, but I wanted to make a political difference. We did fill out the petition, and it does have a PO box on it. There's several reasons. First of all, if you look at your petition forms supplied by the Secretary of State or whoever supplies them, it clearly states that in the signature area where the people sign for your signatures, you cannot use a PO box. It also states that the canvasser who gathers the signatures cannot use a PO box. It doesn't state that the header cannot have a PO box in it. The statute also is kind of ambivalent as it comes to that. So for the staff to basically disenfranchise 24,000 signatures, Michiganians who wanted to see my name on the ballot, I find that an egregious to my rights as a candidate and as a citizen. I mean, I believe that we should always err on the side of democracy. Earlier, we had 2 high-priced lawyers battling it out for Mike Rogers and Alyssa Slotkin. People are always trying to find a technicality when it comes to elections. They're hiding from the voters. I say, let the voters decide. I did nothing wrong in my petitions and my filings. I did everything that I thought was right underneath the law. The question is, I am probably the only candidate on this ballot that actually from Michigan, lives in Michigan, makes his money in Michigan, educated his kids in Michigan. So there is no material breach with the PO box. It doesn't affect the outcome of the signatures. The other question I have is, if you look at, the statute is a little bit ambivalent, but it says you need to substantially complete the petition form, which I believe we did achieve that. One question I have to the staff is, can a candidate that's homeless run for office? And if you wanted a home address on the sheet, why does it not state that, or state on the back that you cannot use a PO box in the header? That would have solved the issue right away and no mistakes would have been made. We have tried to do everything right. And for you to remove us from the ballot because of an issue on an address that has no material bearing whatsoever on the outcome of the petitions, I find that unjust and does not support democracy and allowing the citizens of the state of Michigan to, choose when the primary comes on August 6th.
Questions for Mr. Beydoun? Or for Director Brader?
Okay, I can address the issue of why a PO box is not allowed. I mean, it's just based on the language of the statute, which requires a residential address. And again, that's not a rule that we created, it's in statute. And that's the determination that a court made in the Morgan case on the same set of circumstances. So based on that, we don't think we have authority to accept a PO box as an address in this instance.
I believe my attorney did send a letter to the board addressing the issue of the statute and why we think that our petitions should be. And in the end, it boils down to you, the board, to decide. I mean, does that minor error, which is technically an address, as defined by Webster and every other legal, a PO box is an address. Does that change the outcome? On the affidavit we signed, we put in our street address. The other thing is there's a security issue involved here. With today's political environment, do we, do us as politicians, especially people who sometimes have opposing point of view of a lot of people, and who have children, who has a wife, do you want everybody in the state to know where you live? Can I put my office address or my campaign office? Does it have to be a residence? And why, if it is a residence, why is it not stated on the petition form, which states street address or rural route, and does not state your home address or dwelling? And why does it state on the rules that a PO box is not required, as it does in the signature part and the circulator part? That would have clarified everything, and we wouldn't be here today.
And also just I think one of the things we were wondering or wanted to add is he's running
Could you
for the
state your
US.
name, please?
Yes, Lexis, Lexis, Zaydan, Zeidan. I think one of the things that we discussed that we're curious to know about is it seems like a very minor technicality, inclusive of the Morgan versus Board State of Canvassers, where it states in there 2 different times a candidate's address. And then the second time it states a candidate's street address, which creates a lot of ambiguity to the candidate. But I think furthermore, he's running for the US Senate seat. And from my understanding, you address your street address to understand which district you're serving, if you're actually living in the district that you reside in. As someone who's running for the US Senate seat, he's running for the entire state. And he provided a PO box, which was his candidate's PO box. And so just trying to understand how this specific decision is being made. Because if it's based on a technicality and you all have the decision to make, to allow him to be on the ballot, what we're trying to like elevate here is, well, maybe not your choice or your decision or your intent. It's actually suppressing voter choice, because we achieved over 24,000 signatures, which clearly is not the issue in terms of validating signatures, but rather a minor error, which for someone who's running for office for the first time, it's not very clear in rules and what you all provided or what's stated here for us to understand.
Director Bader, could I just ask one short question? Am I understanding correctly that the PO box issue is solely resting on the 2018 appellate court decision?
Well, that decision interprets the statute. Statute says street address or rural route. And so, as I understand it, the decision there was that a PO box is not a street address or a rural route. It's a PO box. So that's the language in the statute, and I believe that was the basis for the decision. I would invite Adam or Heather if there's more on that decision that needs to be elaborated, but that's how I understand the court decided that language needed interpreted.
What happens if somebody's homeless?
I'm sorry.
This, what happens if somebody's homeless and decides to run for office?
I don't know if we've had that case before us. I mean, when it comes to voter registration, for example, an individual can put a location, a physical location as their residence address. That might be what would be done in this instance, but I'm not sure whether we've had that before us. I don't know if there's any cases like that.
But I don't think for voter registration, they can put a PO box. I think they have to have a physical location so that one knows where they in fact vote. The problem is that the election law is very technical, and it specifically says the petition must be in the following form, and it calls for street address or rural route.
Yeah, but
And
if you look at your petition form, and these are the ones that everybody uses, it clearly states complete the heading and petition before circulating, which we did, and nowhere does it say that a PO box is not required or that you need to put in your home address. But make sure all signers complete the petition. It does say that a PO box provided in lieu of a residential address is not acceptable. It does say on the circulators that do not enter a PO box. So why is it not on the header part also?
It just goes back to the idea that it's very ambiguous, like the ambiguity for the candidate is it's a disservice to us, and it's a disservice to the 24,000 plus signatures that we've collected.
Could I ask a question? Sir, I've got your FEC filing. I just pulled it as a curiosity.
Right.
You list your campaign headquarters at 4 Cornell Court, Dearborn.
Correct.
Is that also your residence?
That's my residence.
So you have a reason for not wanting to use that on a petition form, is what I'm hearing you say.
Because the petition form goes out to the public and everybody has a chance, anybody can know where you live. And it's just a security issue more than anything, because I'm not a typical, candidate. First of all, I'm the first Muslim in the history of the state to get to the point where I'm at. In today's environment, there is a legitimate threat. I get threats all the time. Just go look at my social media. I get threatened, my wife gets threatened, the kids get threatened. So you don't want to make it easy for people to find you. It's not that I was hiding anything or trying to circumvent the law. The law is not 100% clear. So if it's not 100% clear, then I say that the board has a duty to err on the side of the 24,000 Michiganians who signed my petitions, not the one line that's, basically not an intentional misleading or anything like that. It was just a minor error.
Madam Chair, if I may ask a question to Director Brader and also to Heather from the AG's office. Our board is under our own rules that we have to follow. And I want to make sure that what I want is kind of explained again. I've sat on this board for over 10 years and we are under strict compliance. In strict compliance, if I want to make sure that that is what we are under today, we are still under strict compliance.
That's correct, Ms. Bishop.
And unfortunately, I've sat in this position and I've had to look candidates eye to eye, like I'm to you today, and say, I'm very sorry. But strict compliance means that each item on the form has to be correct.
Okay.
And so what the question, I know that we've been asking the question of whether or not the PO box can be on there. But I just want it known that that's the rules we have to be under. Is it strict? Does it meet the form or does it not meet the form?
Well, I mean, I read the statute, my attorney has read the statute. It's ambivalent. It says in two areas address and one area street address. So, you know, I think that you do have the discretionary ability to choose, you know, the 24,000 Michiganians who signed our petition, because it does not have any impact whatsoever on our candidacy, the PO box. It's not like we're living in a different district. We're running a statewide race. So any address in Michigan qualifies us for the ballot. And by definition, a PO box is an address.
I guess that I would like some clarity on strict compliance, because when you keep referring to strict compliance, it's not stated on your petition paper. And then per the document that our lawyers sent, in one area you have address, and then in another area you have street address. So are you strict compliance with street address, or are you strict compliance with address? Because that's where it becomes unclear to us, where as people running for office, we're assuming that address can be any address. And then in another area, you specify street address, and it's not very clear. So I'm just curious to know where are we referring to strict compliance?
What the statute says, the statute very specifically defines the language that has to be on the nominating petition. And it says street address or rural route. And clearly it doesn't, there's no direction that says don't use a PO box, but it says use street address or rural route. And we are bound not only by the words of the statute, but by the judicial interpretation. Which, as Director Brader said that PO box on a petition form is not adequate. Unfortunately, and I'm very sympathetic to your plight, but and I think we probably all are, and this is a very difficult circumstance, but it is what it is. I hate that expression, so I'll take it back. But we are bound by both the statute, by the interpretation given to us by the Attorney General and by the judicial.
But the dissent
interpretation.
in that case by Judge Shapiro does state that a PO box is sufficient.
But that was a dissent.
Yeah. So I mean, basically, what you're forcing us to do is go. You know, as soon as if you deny our claim, and you're denying our democratic rights, and you're denying the rights of 24,000 people who have signed our signatures, to go and then have to file a lawsuit to have a judge decide on what happens next.
There's another issue here that you raised earlier on, which I'll be careful how I put this so I don't state it the wrong way, but the times have changed. 2018 was a long time ago. And I understand the statute and I understand our limitations. And I guess I'm saying to you, sir, as a candidate, maybe you need to be the poster child to go to the appellate court, to go to the court and explain that, explain your position. I totally am in sympathy with your concerns about the safety of your family. That maybe that is the recourse that you have to take, and maybe that's precisely what you need to do.
Well, I was hoping I wouldn't have to be the
I know.
poster child for a PO box, but
Think of the publicity.
yeah, free publicity. Yeah, of course.
Do we have a motion? Do we have any further discussion or questions? Do we have a motion with regard to the staff report?
Madam Chair, I'm sorry. Can I ask a clarifying question on the statute? Because I'm assuming you all read it, but I just want to elevate because it's still not clear for me. Where it says the Board of Canvassers does not argue that a PO box is not an address. Rather, the board argues that the statute required plaintiff to enter a street address. However, the statute has an introductory paragraph which states that the nominating petition shall provide the name, address, and party affiliation of the candidate. Then there's another paragraph after that that states street address. So again, there's still ambiguity in the statute where in your introductory paragraph, it says to write an address and then it says to write a street address, which creates very unclear circumstances for
I
us.
understand your argument and I understood the argument that was presented by your counsel, but as I said, we are bound by the judicial decision as well as by the very strict language in
But the language isn't strict, so what's the-
544C, subparagraph 1. I think it's time.
So it sounds like the strict compliance is the one language, but not the other. I think we just needed some clarity. So it's street address, but not address, even though you all put address in, there's address in the
Form says
statute.
street address.
Okay.
And it says address.
Just to clarify, it's not us putting it on the form. This is in the Michigan election law. So this is
Sure.
this is the language that the Michigan legislature requires us to put on the form. And that language, street address, has been interpreted by a court to mean not a PO box. So it's not a definition that we're providing. It's a definition that's in the law that we are obligated to follow.
Yeah, I think I knew that. It was more of you guys deciding what the strict compliance was. So that's what I wanted some clarity on.
But if we take the action that we need to take, the assumption here is that your next stop is going to be across the street, right?
It's already there.
Do we have a motion?
Yes. I move that the board accept the staff recommendation and find the nominating petition filed by Nasser Beydoun insufficient.
I'll support. Sorry, I'll support. All in favor?
Aye.
Aye. Reluctantly, we vote aye.
Thank you.
Please know that is reluctantly. That is very reluctantly. That's,
My agenda.
I can start the next one if it helps.
Oh, that would.
So the next one is the other Senate candidate, US Senate candidate that we have a staff report for, which is Alyssa Slotkin. In this case, the candidate submitted 29,992 signatures. So we drew a sample of 750. Out of that 750, she needed 375 or more. Similar to Rogers, as we discussed, you needed about half of them to be valid to recommend certification. We found that the total number of valid signatures in the sample was 626. So similar to Rogers, she had well over the number needed. We did get a challenge from Hill Harper, but the challenges were mostly to signatures outside of the sample. And the challenge didn't bring enough signatures within the sample into question that even if we processed it and found all of them invalid, it would have taken her below the number. So based on that, we're recommending certification.
Nobody has asked to speak to this. Oh, I'm sorry. You don't want to miss an opportunity to be heard. Oh, here you are.
See? And remember Don, I'm offended that he just got up and left and is going to miss these valid points. What's that? Yeah, you got a better offer? Yeah. Just a couple of brief comments. This was, I think, and it's important to note, largely a volunteer effort. And so when you look at the validity rate of 84% of the signatures within the sample, I think that's a direct result of a largely volunteer effort as opposed to a paid circulator effort that you've seen by other candidates. The second thing I would note is that as you are reviewing legislation or other rules, I think challenges such as this and others, that perhaps language that would authorize either the Bureau or this board, similar to frivolous complaints and lawsuits, that that when you submit them, you certify that there is a valid reason in fact or law for the challenge. And that if the board finds that it's not, and it's designed to annoy or harass, that there can be some sanctions imposed for those. You see it with the campaign finance complaints that have been found frivolous. And I think in these days, as you're examining 39 or 40 challenges, that some of those, whether or not they're valid, and in this case, you look at them, and when there's actually, I think I came up with 10, the Bureau came up with 8 signatures within the sample that are being challenged. I think it wouldn't pass muster as in terms of being filed. So we'd recommend to file that. The last thing I just want to note on the Senate candidates, I'm very pleased and to provide some of the clarity that Chair Garowitz was wondering about is, let me just state clearly what I was saying, if apparently I didn't before. One is, I do think that in an investigation into the entirety of the canvas of this universe of GOP circulators for fraud or forgery is required. I guess my point was that the deadline for the canvas is June 4th. And so if it was possible to do that prior to June 4th, great. But I think what the board has indicated that I'm very pleased to hear and applaud their efforts is to review and root out circulator fraud and have a report by staff for this board to consider and consider what actions are appropriate to take in response to that report. And I would, as I wrap up here, I'll provide a list for Bureau staff of the crossover of circulators that have been identified by the Bureau of who also circulated in the Amash and Penzler sheets, and what sheets, Bates numbers those are, and the number of lines on those for their benefit to make their review more efficient. Happy to answer any questions.
Thank you. I think you're trying to impose upon us an additional obligation to decide whether challenges are meritorious or frivolous and to impose sanctions.
I'm saying legislative.
A lot of time talking about that, Mr. Wilcox.
No, I'm just saying legislatively, I think it's an efficiency, and I think it's an issue that too often these challenges are being submitted. I mean, we were accused of an opponent of pulling a political stunt. Bureau staff identified fraud and forgery in the letters that we submitted. And what I'm saying is too often that there are challenges that aren't meritorious. And for example, the one submitted against the candidate I'm representing, Slotkin, where there's only 8 in there, there ought to be repercussions and there ought to be ways to dispel of those and not waste the staff's time, waste your time, or waste candidates' time.
Well, you can take that to the legislature.
Absolutely. I'm not saying you, and that's what I started with, legislation to address that.
Do we have a motion with regard to agenda item 4?
I move that the board accept the staff recommendation and find that the nominating petition filed by Alyssa Slotkin sufficient.
All in favor?
Aye.
Aye. Motion carries. Agenda item 5, consideration of the sufficiency of the nominating petition submitted by Bob Lorinser for the office of United States Representative, 1st District.
Thanks, Chair Gerwitz. So this is the first of several we have for U.S. Representative in Congress. In this instance, the candidates need to submit 1,000 valid signatures. In this instance, our face review found that 1,415 were facially valid signatures. We then got a challenge from Cali Bar challenging signatures in these petitions. The bulk of them, they challenged a bit over 1,000. The bulk of them, 727, were challenged on the basis that the signature on the petition sheet was more than 180 days old. However, that 180-day limitation does not apply to nominating petitions. That's for initiative petitions. So that's not a valid basis for a challenge. When we took those 727 out, they were not calling in enough signatures into question that would overcome the cushion. So we didn't process the remaining challenge. So based on that, we're recommending that this be determined to be sufficient.
Mr. Trebilcock, you've indicated you wish to speak to this. Please do so briefly.
Thank you for the recommendation and recognition. I think Director Brader and the staff correctly hit it, that it's a difference in a confusion over qualifying petitions and nominating petitions. They also cited a concern based on a Facebook post of collecting more signatures. There were actually fewer than the maximum permitted that were actually turned in to Bureau staff. So again, an invalid reason. And even though the Bureau staff determined not to review the individual challenges of 313, as identified in our response, the vast majority of those were invalid challenges. And even if they were valid, Dr. Bob had submitted over 600 more than is required. So again, we would urge the board to certify Dr. Bob to the ballot. Thank you.
Any questions? We have a motion.
Need to hit the button on the mic.
Oh.
I move that the board accept the staff recommendation and find the nominating petition filed by Bob Lorinser sufficient.
Support.
All in favor? Aye. Motion carries. The next item on the agenda is consideration of the sufficiency of the nominating petitions submitted by Josh Saul for the office of United States Representative First District.
Thank you, Chair Gerwitz. So in this instance, the staff, based on face review, found that all of the signatures were invalid because of a heading error. The issue in this petition is that the office is listed as House of Representatives and the district is listed as first. So it doesn't say U.S. House of Representatives or Congress or something that from the face of the petition distinguishes this from the Michigan House of Representatives. And there is a first district in the Michigan House of Representatives. So in this instance, based on the petition, it's not clear that the candidate is seeking election to the office of a U.S. Representative in Congress First District as opposed to Michigan House of Representatives First District. I don't believe we've had this exact scenario before. The closest analog comparison that we could find was an instance involving a judicial candidate. Judicial candidate, in that case, we determined that it was okay that they did not include the district number because in that case, there was only one race there was only one office it could have been because there was only one Court of Appeals office on the ballot, and the Court of Appeals agreed with us on that. So we think the logic applies here, but for the opposite result, which is that because there is ambiguity from the face of this about which office it is, that the office is not adequately stated here. We did get some information in response. I think we're about to hear more about it. We got some affidavits from individuals who said that they knew that Mr. Saul was running for Congress when they signed the petition, and I have no doubt that's true. But we are making this recommendation based on what's written on the petition and the ambiguity of the first district as it relates to two potential different bodies.
And Mr. Saul has asked to speak.
Yes,
Would you spell your name for the reporter, please?
Yes, it is JOSHSAUL. And I'm coming to speak today. I would like to appreciate I appreciate the opportunity to come and speak with you and discuss this case this morning. I think that this is a case where common sense should play hold because as the gentleman mentioned, there is a first House congressional seat, but that is 200 miles away from the address that I listed on the petition, which would make me ineligible to run for that office. Additionally, there's not even a House district within the first congressional district, which is the largest district congressionally in the state.
that ends in a 1. So there could have been no confusion for anybody who was in Michigan's 1st congressional district that they were signing for anything other but than the US House of Representatives, because there's no state house that ends in a 1, and the 1st congressional district is on the other side of the state, about as far away as you can get. So this is a case where I accept the fact that there was a minor error and on the heading. That is my responsibility, but per the precedent that was point there, it is not, the precedent wasn't that there wasn't another Court of Appeals candidate that was running within the state. It was that there was not another Court of Appeals candidate that was running within the county. And as far as every single county that I collected signatures, there is no 1st District House of Representatives race that applies to any of those counties. So appropriately, I think the right thing to do would be to allow the people of Northern Michigan who heard my story and wanted to support me to be on the ballot to allow their voices to be heard.
See our attorneys conferring on this and would appreciate their input.
I'll filibuster for a second if you have this some time. So, I mean, I as I said, we have not had this exact scenario before, and I understand, what Mr. Saul is saying. In the past, when there has been ambiguity about the office sought based on the office identified and the district number or circuit number, if it's a court case, the precedent, as far as we can discern, is that if there could be multiple different offices that this could be slotted as on the ballot based on what's written on the petition, then it needs to be rejected. And so in this case, certainly I agree that the 1st State House district is very far away from the 1st congressional district. But based on the petition, it's not apparent from the petition heading how this would be slotted on the ballot as Michigan House of Representatives or US House of Representatives.
But it does list the district as the 1st, and to accept your conclusion, you would have to believe that everybody in Northern Michigan doesn't know what House district they is representing them. And I don't think that is something that stands up to logic or scrutiny. Because this ends up being exactly like the judge's case, where there was a minor part of the jurisdiction that was missing from the header of the thing. But because in that county, you could not assume that they were running for another office based on the information available, you accepted that determination. And that's exactly what's going on here. There's a minor ambiguity in the jurisdiction, but based on having the district number available, it would be impossible to conclude I was running for any other office than the United States.
Questions for each?
I mean, do you have? Did you?
So I remember something close to this coming in front of us, but it was a judicial candidate.
Mhm.
And that judicial candidate was running for a district office, a district judgeship for 46 in Oakland County. And there are 2 District 46 in Oakland County.
Mhm.
So yes, I made the motion
Mhm.
to take her off. So the question I have for Heather, maybe, or to, is
Putting Eric on this.
an Eric, well, I could put Eric on the spot because Eric has not spoken today. It goes back to the strict compliance that we talk about. And you're saying it's House of Representatives. And yes, I know where the 1st district is because it's in an area near where I live.
Mhm.
But where this,
And I can understand where there could be some confusion, but there's not even a district that ends in 1. in the US first congressional district. We cover the
I'm
nine.
not talking about conditional, you have House of Representatives.
Yes, I understand that,
there's-
but there is no House of Representatives, State House Representatives district that ends in one in the first congressional district area.
You
So,
have House of Representatives.
yes,
And the question for me is, and I know if I look at that, and I'm looking at all of where all the cities are, they are not in Wayne County.
Yep.
Okay, I know that. But if we are held to strict compliance, there has to be clarification. This is why I'm
well, and I think the
that's-
strict compliance would be to look to the court precedent, which said that because there was no other
Like-
case that this could be, that you should allow it.
you can understand, like, the four of us are now, and you can
Yep.
even hear it, we're all trying to.
Yep.
So this is why I'm looking towards
I
our
understand.
legal
I'm-
representation from the AG.
Yep, and I'm
to-
presenting what our argument is because
I-
it's not even like the state house districts are the 99th, and then the 103rd through the 110th. So there's not even one that ends in one that somebody could claim that I was trying to forge.
I don't think anyone is thinking you're trying to forge anything.
I
I
know,
think where the
or
question is
confuse.
for us is the clarification of compliance, our
Well-
requirement under strict compliance. This is where.
My
this
understanding
where-
is that for this, it's a reasonable person standard. That is what's held to this. And would a reasonable person in northern Michigan understand what they were reading?
You don't have to make your argument. If what I'm trying to say is
Okay.
I am trying to figure out for us on this board that are held under strict compliance, what is that standard that we
Okay.
have to be held to? That's.
Yep.
I completely, I sympathize completely. Do you,
I feel your pain.
yes.
You mentioned common sense at the beginning. This is a government function, so throw that out the window. There is, we operate under strict compliance. I think where the frustration for us and for candidates is, yes, we have strict compliance, but there are also, throughout my time on this board, numerous instances where, yes, it's strict compliance, but this is okay under strict compliance.
Mhm.
So how strict is it?
Yep.
In instances like that, I look at precedent and what have we done in the past. And the fact that House of Representatives is ambiguous in terms of federal versus state. And there are two first districts as a result of that. Precedent of what we have done would require us or would suggest to us that we unfortunately need to deny. I think a court case would certainly be helpful for us to get some clarity on things like that. I'm sorry I'm giving you that task.
No,
But
there is the
that's-
court case that the staff cited with the judicial nominee. They weren't making the claim that there wasn't another circuit court race that was potentially on the ballot in the state. They were making the argument that that was the only circuit court race in that county. So when you take the information as a whole, there could have been no other seat that I was running for other than the United States, because there was no state House of Representatives seat that I could have been running for based on my address and based on where I was collecting signatures.
I see what you're saying. Could our attorneys provide some guidance on that?
Certainly. Just to be clear, what is the question you're asking me?
So what he has pointed out is in the judicial case that is cited, the reasoning was there was no other district up for election in that county. So therefore it could be the only race that was being discussed. He's likening that to the fact that the House of Representatives first district that he has circulated for is in an area of the state where there is no House of Representatives first district in the state legislature. So therefore, applying that same logic of, well, yeah, obviously, he's talking about this one up here. That's a compelling argument. And I'm curious what advice or what precedent exists related to that for us to interpret and take into consideration?
So the statute, and by which I'm referring to, MCL 168-544C subsection 1, lays out the form of the petition, and it calls for the petition to include the identity of the candidate of the blank party for the office of blank, and then district, if any. So it does not appear that this is an issue so much of strict compliance, because the petition as written includes office, which would be House of Representative, and District 1. The question in the issue, and certainly it's a supportable position in the staff recommendation to say that there is some ambiguity or some uncertainty that could lead to confusion as to whether that's the U.S. House of Representatives or the Michigan House of Representatives. That is, however, not the only conclusion that could be arrived at, and so the board could make its own determination.
Yeah, and I think that based off the precedent of the judicial case, this falls directly in line with that precedent. This is the closest case that you could come to without having the exact same fact pattern, because it was a jurisdiction that was not included in the header of the petition, that in those counties, there was only one office that any reasonable person could conclude that you were trying to seek nomination for. And based off of that precedent in the court case, that should give us the ability to allow this board to allow us on the ballot and allow the voters to make their decision in August.
Saul and Member Daunt both stated the issue pretty clearly, that the question is whether there could be any confusion, because that's essentially what the court
and there's
is
not
looking
even
for in the Freeman case.
Yep, and there's not even any district that ends in one.
Right.
And the fact that I identified it being the first district means you couldn't have confused it with any state house district. If you thought you were in the 101st, I didn't collect a signature in that county.
Said, I don't see that there could be confusion here.
Can I ask Director Brader a question? Director Brader, if we take a road other than what the board or what the Bureau has recommended, we still have the issue here of there are no signatures because they haven't been reviewed. I wasn't here last time you guys went through this, so I'm just asking you a question. What happens in that case?
Let me just look at the staff report for a second. There's 1,221 signatures.
Out of that total, 273 were challenged, and one of the most common challenges was that we didn't have addresses in the right county. I have 31 addresses that were on our petitions that I have printed off copies for each of you that prove that they were in every county, or that they were in the correct, signed and placed in the correct county. And I also have documentation with affidavits from people who were challenged by saying that they were not in the GOP database. And those people included my campaign manager, Todd Smallenberg, and a candidate for the 106th House seat. And also the other thing that for this board, I think, to consider with that is the challenges against my petition would assume that I was committing fraud at the rate of the Senate candidates or higher. Based on the number of signatures that were challenged, if you just take the addresses and the average number of signatures that have been thrown out for every other candidate during this election cycle, then that would put me below the threshold of what the challenge was to my signatures. So it was not like they were trying to throw out half of my signatures. There was, if you can find 51 of them if you can find 51 signatures that they challenge that do not meet the threshold, then we would be eligible to make the ballot and have enough signatures.
So in this instance, if the board believes that the House of Representatives first district is not reason to determine that the sheets are facially invalid, then we would need to review the petition. So we'd have to do two things. One, we would have to do the face review again to identify any sheets that might have been facially invalid for other reasons. And then two, we would have to process the challenge. I understand that there's been information introduced in response to the challenge, and so we would review that as well. But we would need to review the challenge because it does call, at least on its face, it calls into more signatures than the cushion, even before we do the rest of the face review. I think we could try to do that today. I mean, with only one petition and the staff we have available, we probably could dig into this one and possibly get it done in a few hours and come back to you this afternoon. If not, we'd have to look at something on a later date.
Well, so a question, for the chair. What if we took this item and put it at the end of the agenda? Or do we, or we, you, I'm sorry, we would actually have to overrule you, or we would have to make our motion and go forward in order to get you to do the phase review and the verification, is that?
Well, I don't think you'd have to make any motion. I think you could just tell us you're not voting on this right now and we'll conduct a review of the signatures and the sheets right now and try to get it done by the end of the day.
If I need to be here today, all day, I plan to be here all day. I think that it would be appropriate for this board to make a determination on this item, so that way the staff can move forward with full knowledge of what this board's intention are for this, and that would give them a good reason to be able to go and do that work and not feel like you're wasting their time.
Thank you to them. They're throwing you a bone.
Oh, I'm more than willing to, like I said, I'm more than willing to stay all day. I will wait until the end of the agenda if I need to be. That is not an issue.
Okay, so we're gonna table agenda item 6. And thank you, Mr. Saul. And move on to agenda item number 7. Consideration of the sufficiency of the nominating petitions submitted by J.D. Wilson for the office of United States Representative, First District.
Thank you. I'm just gonna give Adam 1 second because I might need him for this one. And do they have what they need to get started? Okay. Okay, so this petition, also for the same district, consisted of, again, 1,000 signatures required. We had 1,240 signatures submitted. In this case, the face review found that all the signatures were invalid because the petition sheets did not require comply with the statutory requirements of 544C. The issues were, number one, the 24-point boldface requirement for nominating petition. Number 2, the 12-point boldface type requirement for warning, and the language in the warning. Number 3, the 12-point boldface requirement for the circular warning. So those are the issues we identified, and because none of the sheets met those statutory requirements, we determined that all of the signatures were facially invalid. Okay, Adam's going to get the original sheets. Okay.
Yeah.
I don't need them. They can.
We'll share.
We can share if you want to.
Okay, would you take a seat and give your name to the court reporter and spell it for her?
J.D. Wilson, representing J.D. Wilson for Michigan. Okay, so first of all, I gave each of you a copy of what we had. It includes the report. That's because our response was not 100% clear. It was out of order from the complaint, or from the report rather. So in the handwritten version of the report, I put notes into which one we were applying, just so there wasn't any confusion. We are a grassroots campaign. And when I say grassroots, my 22-year-old son is my campaign manager. My 19-year-old son is my graphics artist guy. And we made a horrible decision to create our own petitions. Now, when we made that decision, though, we were relying on a guide that the Secretary of State provides to us that I wasn't able to give you a copy of. It's a 64-page guide. It appears it's only intended to be reviewed online because there are no page numbers. So it's going to be difficult for me to reference what we've got going on here. But if we go through the listed items, out of order, there are 2 paragraphs that refer to where we placed our paragraphs. And I didn't hear those listed just now. So are we only concerned with the bullet points? Can I back off of the 2 observations at the end, sir?
I was summarizing the staff report, but I mean, the staff report includes all the reasons we think it's not compliant.
Okay, fair enough. The staff report then, as we reply, if you look at my responses, the first, and again, they're out of order from the report. So the first one that we reply to is a notice to us that the warning to circulator must be placed in the lower left-hand corner of the sheet immediately beneath the circulator statement. The petitions that I gave didn't do that. Our response is that that doesn't really make sense, and it doesn't require it in the law. The law does not tell us that we need to put the paragraph in the lower right-hand corner. The guide does, but you'll notice in the paragraph, I've highlighted the words above certificate. We put the paragraph below the values that were put in by the circulator, which is where it would make sense to be. If we put it in the location the Secretary of State is asking us to put it in, the paragraph doesn't make sense. And again, the law doesn't require that paragraph to be in that location. Moving on to item 2. Finding the circulator to sign a certificate after circulating a petition must be in the lower right-hand corner of the petition sheet right above the circulator's signature in the residential box. Again, they reference law 168482. It doesn't, law 168482, I'm told, does not apply to nominating petitions. It applies to legislative items. So we're quoting laws in the guide that don't apply to the petitions that we submitted. So our response in that example is, again, the sheet follows the requirements provided in 544C, and it is not being defined properly by the report. So those were the last 2 findings in the report. Now we start to get to the ones that had bullet points. Item 3, the statute requires 12-point bold face for the warning and language accordingly. Upon review, and much to my dismay, we found out that we're not in compliance there. But it's a little frustrating because the guide, while we were immediately quoted a decision, a case decision that indicates that we should be in compliance, that decision also revolves around nominating petitions. Revolves around legislative petitions. It could very well be argued that that same rule would apply to nominating petitions, and that's the way we're looking at it. But in the guide, there's no reference whatsoever to that. Yet it's the first thing that was put in, in the response that we got, the first thing we got was that legislation. Now, on my way here this morning, and again, we only had 3 days to respond to this because we couldn't get an attorney on the phone until Tuesday. We didn't find out till Friday night, right? On my way here, I did find language that does talk about type size and font and the fact that it doesn't always match what's in a digital application. But that reference is in the legislative petition portion of this recommendation and nowhere else in the document. So under the nominating petition, there is no language to warn us that we should have used a font compliant. What's more, those laws are 70 years old, the font compliance laws. Decisions were made in 2012, which is the case that you're giving us, but those references weren't attached to the law. So if there was an impact to the law, typically those would be referenced in the law and there would be language accordingly. None of that is available to us. So in good faith, we circulated petitions that we thought were great, perfect, right? And now in retrospect, we're basically being told there are a bunch of rules that we violated, but none of those were supplied to us by what's supposed to be the defining document of how we're supposed to create these petitions. I go one more. There's a page in here that talks about nominating petition format requirements. See if I can find it here. And basically says it's Appendix B, countywide partisan nominating petitions. And it describes a bunch of information, but goes way out of its way to not give us a petition blank. Why don't we just supply me a petition blank? I'm told that I could have gone to the clerk's office and gotten one, but I didn't want to have the problem that my colleague had and not have the right office in. So by creating our own petitions, we were able to fill those blanks in advance. And that was what we intended to do. So I understand the strict compliance concept, but I feel very misled in the process. And I feel like what is supposed to be the authority document is essentially misleading us. In fact, to the point that I would argue that if we'd done some of the things that we're being asked to comply with, our petitions could have been thrown out for those very reasons because they essentially ask us to violate the law. It's very difficult to be sitting here today.
Do we have questions for Mr. Wilson? Director Brader. Just acknowledge that you could have gone to the clerk's office and gotten the petition forms.
I didn't get that knowledge until very late in the game.
I'm
And
sorry.
I said, we did not get that knowledge until literally when I got this complaint, somebody said to me, hey, idiot, how come you didn't go do that? And it was because we were led to believe that there would be no problem with us creating our own petition. Again, my son is a graphic artist. We followed all the rules that we could find. And in fact, when the law started to argue with the guide, I said, listen, guys, you got to follow the law. In fact, we found old versions of the SOS guide that essentially has a disclaimer in it. It's not our fault if we tell you to do it wrong, which I got to tell you is very disconcerting. Part of the reason that I'm in this game is because of the frustrations and the lack of common sense that my colleague brought up earlier. We're trying to bring some common sense to this world. Again, we went and I used volunteer circulators. The ones that I hired in the UP did something similar to what you've described. We threw 30 sheets out before we ever brought them to you because we suspected there were problems with them. And that's why I only have the 1240 that we submitted. In good faith, we used volunteers for all of those. I could put every one of them in front of you if I had to. They all understood the warnings. So the notion, we're not really here discussing whether the warnings were followed, we're discussing the type size. And again, you know, I feel almost intentionally misled on these topics.
Director Brader, do you want to?
Well, so there's a lot there. The font sizes described are all in our manual. We produced the manual to try to provide as much assistance as we can to candidates. The suggestion that we're intentionally trying to mislead candidates after the amount of effort and time we put into trying to summarize most of the issues they might face and also offering to review and consult on copies of forms that candidates have the option to send us to review is just not accurate. We are trying to help candidates as much as we can. In this case, you know, we always, I'm sure there's always ways that we could make the manual better. We made a lot of improvements to the manual in 2023 as a result of issues that we encountered and candidates encountered in past elections, and I'm sure we'll do that again this cycle. But ultimately, we try to flag as many issues as we can for candidates, but ultimately, they do need to, they do have their own responsibility to ensure that their petition sheets comply with the statute.
I'm sorry, just to clarify, the language about the fonts is not in the part of the document that defines our petition, just to be clear.
I want to just address that.
But it is in the statute.
I'm looking at our manual. It's posted online. It's also starts on page 30 and it specifically says warning to the circulator. A warning to the circulators of the petition must be printed in 12-point boldface font type as specified below and cites 482.6, which is the initiative. And it also cites 544C, which is in the nominating petition part. And it goes on and has every circulator warning that needs to be there and says must be printed in 12-point boldface type, provides the warning. So it all starts on page 30 of the manual. Okay. That was posted online on October 20th of 2023.
It does have page numbers on it, just for record.
My printed out version for some reason doesn't. Oh, I see them now. I apologize. They are there. My apologies. They're in different spots on each page. That's why I'm not seeing them. Okay, just to clarify what I'm saying here, on page 24, you go out of your way to say that there is a difference, that we're strongly encouraged to use particular fonts, and that the fact that there is a discrepancy between the digital fonts that we choose and the fonts that are outlined in the statute is essentially outlined here in the legislative petition portion of the document. That same language I'm not seeing on page 30. So it's omitted from the portion where I'm trying to get my direction on how to create these documents. It's omitted.
Mr. Wilson.
Yes, sir.
You want to run for the United States House of Representatives.
Yes, sir.
You've done your petitions. with either total disregard or no research at all in terms of what the state of Michigan requires those petitions to be. And then you come in front of us and it's our problem because you don't like the way the manual was put together. I guess I've got a hard time here because everybody in this room that's dealing with a petition had to fill out forms, they had to get advice, they had to do research, they had to do homework. But apparently you didn't. You just did it the way you wanted to, and then it's our manual or it's the manual of the state of Michigan that's wrong.
I'm sorry, sir. I didn't mean to offend, and if I have, I
You're not offending.
apologize to
I'm just
all
puzzled.
involved. But what I'm suggesting is that I got a manual here that says petition manual. How to create essentially statewide initiative referendum and constitutional petitions. Basically, this is from the Board of Elections, the Bureau of Elections. So I would have assumed that it would have directed us in the right direction. When you say I need to do my research, that's what I thought we were doing.
I think it did put you in the right direction. I think you just didn't follow it.
Well, I'm arguing that not only did we follow it, okay. So again, if we talk about the paragraph locations, they actually conflict with the law. So they misdirect us, just so that we're clear. They don't agree with what the law says. One of them is it's arguing that they're arguing about laws and they're applying them to our nominating petitions that are actually legislative petition rules that they're applying. So that's the part that we're taking exception with. I appreciate that everybody works very hard at this process. That's not at all what I'm up to. We're just trying to get our documents completed and created properly. So when we used 12-point font to comply, we thought we were in compliance. What a objective person would think. We were then faced with the decision that basically says that 12-point font is defined in the 1954 definition. The only thing that was troubling for me again is that in one part of the document, it's there for us to see that when we're building if we were building a legislative petition, but because when we're building the nominating petition, it isn't there. So where would I have looked for that information? And that was the problem. That's basically what I'm outlining.
Yeah. You did obviously recognize that the font size was important because you have the title in 14-point bold type, but you say your title says nominating position instead of nominating petition.
We didn't get to that part. That was what I honestly thought that I was going to be here standing in front of you to discuss, which is a typo.
You were saving it.
And what I thought we were going to do is basically I didn't realize I had the other 4 items, right? When we got to those. The other 4 items, the only 2 that I believe that we have any conversation over is the last statement that you made and then the font size. Those are the 2 that we're arguing.
I do not want to be rude, but I feel like we're spinning our wheels here. And so like I would think a motion is probably in order. Unfortunate, but these are decisions we have to make here.
Thank you for your time. We were hoping that because they were treated as nominating petitions, circulated as nominating petitions, and even the canvassers went beyond the title and looked at the rest of the documents, they were essentially treated as nominating petitions. If it acts like a duck, walks like a duck, swims like a duck, we would ask you to see the words nominating petitions there. And thank you for your time.
I move that the board accept the staff recommendation and find the nominating petition filed by J.D. Wilson insufficient.
Support. All in favor?
Aye.
Aye. Motion carries. Next item on our agenda, excuse me, is consideration of the sufficiency of the nominating petitions submitted by Curtis Hertel for the office of United States Representative, 7th District.
Thank you, Chair Gerwitz. So this is a different district. Now we're in the 7th District, U.S. Representative of Congress. Curtis Hertel submitted 1,687 signatures. After face review, staff determined there were 1,589 facially valid signatures. We did get a challenge from our esteemed former board member, Norman Schinkel, that was alleging that the title of the office had to say, the challenge alleged that the title of the office was incorrect because it said U.S. Congress instead of U.S. Representative in Congress, and also that it should have said 7th as opposed to 7. So this obviously, because it was based on the heading, it called the entire petition into question. In this case, we did not find, with all due respect to our esteemed former board member, we did not find that Congress was inappropriate here. It is clear what office is being referred to with U.S. Congress and a district number, because there are no, the only office that theoretically could be is U.S. Senate, but of course that doesn't have district numbers. And we do have examples in the staff report for you of candidates from past years that the board did approve with the same listings. So we had Donovan, James, Markinowicz, I'm sorry if I said that wrong, McLean and Miller and Seeley from past years that wrote U.S. Congress, and the board certified. So we think the board's practice here is pretty consistent, that Congress is okay, and that the lack of the TH after the 7 was not an issue either. So we recommend certification based on that.
Any questions for Director Breer? Robert Avers has requested to speak. I'm sorry? Well, do we need 2 people to speak to this? I mean,
We're happy to keep it on file.
I'm sorry? Oh, okay, there.
You want them both at the same time.
Okay, Mr. Schinkel can join you if is he still here?
He's still here.
Oh, there he is. Okay.
Are we ready to start?
Yes.
Okay. Well, it's good to be back, Madam Chair, members of the board. As I said, some parts about the board I don't miss after sitting in this room for this long. But the reason we're here is that the petition in front of us doesn't mention the office sought. And I went back and looked at all the minutes and agendas when I was on the board, and this never came up specifically. He mentioned a branch of government as the office sought. And we're using the circuit court case that we did about 10 years ago, where it had the office sought was correct, the district was wrong. This is a totally different thing. The circuit court case didn't put down the Michigan judiciary, a branch of government like this is doing. U.S. Congress is Senate and House. Look it up anywhere you want to go. It's both the Senate and the House. It's not the House. So it's just wrong. And if one thing we've learned today is strict compliance is our rule. Strict compliance, everything we've done today is under the notion of strict compliance. We got rid of a fake Tea Party because they didn't use the word "the" correctly. That was strict compliance. And strict compliance should be used today. This petition should be disallowed.
So let's talk about the staff report.
Thank you. Sorry about that. Let's talk about the staff report. As Norm and as Director Brader sketched out for you, there is no office. There is no title of office on Mr. Hertel's petition, okay? The staff report, they sort of acknowledge that he failed to list an office, but I'm going to summarize their conclusion. They say it's harmless error, okay? The Bureau claims that Hertel's petitions are not ambiguous because he included a district number on the petitions. So from their perspective, his campaign for the U.S. House can't possibly be confused with the campaign for the U.S. Senate. But there's a problem with that, and I'd like to direct your attention to MCL 168.93, which requires that candidates for the United States Senate must have nominating petitions, and I'm quoting, signed by at least 100 qualified and registered electors in each of at least half of the congressional districts of this state, okay? And it also provides that those petitions shall be in the form prescribed in MCL 168.544C, which, by the way, is the same form of petition that someone running for the United States House of Representatives uses. So it is not at all accurate to say that congressional districts are, or districts generally speaking, are irrelevant to a nominating petition for a candidate for U.S. Senate, okay? I mean, even, I don't want to belabor the point here, but the secretary has guidance on this, filing for office, U.S. Senator. If you look at page 2, pretty much parrots the statute, right? The petition must be signed by at least 100 registered electors in each of at least half the congressional districts in the state. You're like, Bob, why does this matter, right? Well, I'll tell you why it matters. If you're presented with Mr. Hertel's nominating petition in a parking lot and you look down and it says U.S. Congress, District number 7, and your feet are standing in the 7th congressional district, I think that's pretty confusing. I don't think it's at all unreasonable for someone to look at that instance and say, boy, this guy's running for Senate or he's running for House. It's wide open for interpretation. And that's why Mr. Tom Barrett, who is also a candidate for the U.S. House of Representatives, he's running for the 7th district against Mr. Hertel. It's come to our attention that Mr. Barrett submitted his nominating petition to the Bureau for pre-circulation approval. And at the time, Mr. Barrett's petition, which I've handed out to the board and to Mr. Hertel's counsel, stated that the office he sought was United States Congress, same as Mr. Hertel's now. It also listed a number 7 in the district field. Again, same as Mr. Hertel. But here's the thing. The Bureau, as you can see in that email, it told Mr. Barrett to change the title of the office sought. In fact, it told him, quote, be more specific with the office title. So there's a bit of a hole in the Bureau in the Bureau's analysis here. I mean, we've heard all morning about strict compliance and opportunities for confusion. I have a hard time seeing how this case is any different than some of the candidates who were reluctantly sent home today based on similar issues in their petition. I do just have one thing I want to say about the 2022 petitions, if I may. I promise I'll take 15 seconds. I mean, I appreciate the Bureau's position that is somehow precedent for allowing this to happen again. But the difference is in 2022, there were no ingredients for confusion because there was no U.S. Senator, no U.S. Senate race on the ballot. So it's not really precedent. It's not an example because the facts are different now than they were then.
Thank you. Questions?
I actually have a question for Mr. Schenkel. Mr. Schenkel.
Seconds, Norm.
Yeah, here we go. So I'm looking at the staff report, and the staff report in their recommendation shows me 5 nominating petitions from other campaigns. Stay with me a sec on this. I'm just going to give you a couple of them. So here's one from Lisa McLean for the primary in 22. And her description was U.S. Congress, 9th District. I have one for Candace Miller for the primary for the election in 22. And she listed U.S. Congress, 8th District. And of course, I've got Matthew Seeley here, U.S. Congress, 8th District, August of 22. Now, I wasn't on the board at that point when those three were all approved.
They weren't challenged.
These three folks were on the
Right.
board.
It's never been challenged.
The point is that you also were on the board.
Mhm.
So these are all three that you voted for.
They weren't challenged. So we were voted for them, and number one on your agenda, everything gets passed for number two on your agenda. No one challenged the petition.
And if I may, there was no US Senate race in 2022. So the ingredients for confusion were not present in 2022, but they are now.
I'm not sure I buy that argument, but I'm asking, so
appreciate
Mr. Schenkel, so even though they weren't challenged, they were no issue for you.
I mean, are you going through all the petitions to see if there's a problem? No, you look at the challenges.
Any more questions for Mr. Schenkel or Mr. Avers? Okay. Jody Jas Rosaria has requested to speak. And would you spell your name for the reporter, please?
Yes, absolutely. My name is Jyoti, Jyoti, Jasrasaria, Jasrasaria, and I'm here representing Mr. Hertel. I'll keep my comments very brief. As has been made clear, Mr. Schenkel's challenge is just another game of gotcha, and Director Brader and the Bureau staff have confirmed that this board has never failed to certify a congressional candidate that used U.S. Congress as the title of their office. And to our knowledge, no other candidate that has used that title has even faced a challenge, as Mr. Schenkel confirmed as well. And as the board has referenced, Mr. Schenkel himself voted to certify several candidates that used U.S. Congress as their office name as recently as 2022. And I'll add that, as we mentioned in our response letter, the same was true in 2020 when there was a Senate seat on the ballot. So not only is this the first and only time this issue has come before the board, it appears to be the first and only time that this issue has occurred to Mr. Schenkel. And that's for good reason. Mr. Hertel's petition sheets clearly state that he is running for the U.S. Congress in Michigan's 7th District, which is an accurate description of the office that he seeks. The recommendation of the Bureau that Mr. Avers referenced simply says that another title could be better, but here, there's no title listed in the actual statute that requires any candidate to list something other than something that's accurate, which here again, as earlier discussions today have made clear, U.S. Congress is actually a more reasonable and clear title than some others that could have been used. And here again, there's no dispute that Mr. Hertel has submitted more than 1,000 valid signatures. And so this should be an open and shut case. The board has a clear legal duty to determine that the petitions are sufficient and certify Mr. Hertel. Thank you.
Just a very brief comment that kind of came to light during this discussion is, and I apologize for perhaps directing more work at Adam and his team in future cycles, but the opportunity is there to ask the Bureau to take a look at these. And this isn't to just strictly Mr. Hertel or anybody that we've discussed today, but everybody. Have them look at this so that we don't have these issues moving forward. Have a basic understanding of that and avail yourself of it so that you don't put all the time and effort into this only to be rejected on what some would call a technicality, but what frankly is the law. in procedure. So anybody that's listening that participates in this process, have the folks who are in charge of this stuff take a look at what you're putting together before you go through all that work.
A motion?
I apologize for any delays. We all now have laptops and sometimes finding all of this information is a little difficult.
Okay, Norm.
It's a little easy. I know. Wow. And it was me who said it. I move that the board accept the staff recommendation and find the nominating petition filed by Curtis Hertel sufficient.
Support.
All in favor? Aye. Motion carries. At some point, we're going to break for lunch and,
So food is here. We do have a lot still to get through, so I maybe would recommend we do one or two more and then break.
Okay.
But whatever the board wants to do, obviously it's up to you. We're gonna have to get through about 20 more, and then we do have to revisit Mr. Saul. So I think we have time, but we do have to be out of here by 4:30. They will not
I expect to
indulge us.
become less patient as the
Yes.
afternoon wears on.
So I can, do you want to just do one more and then break,
Okay,
or?
sure.
Okay.
Consider agenda item number 9, consideration of the sufficiency of the nominating petitions submitted by Nikki Snyder for the office of United States Representative 8th District.
So this was another congressional candidate or U.S. representative of Congress, depending on your preference of specificity. So this candidate submitted 1,779 signatures. So they did not have much wiggle room. They just barely had over. So our face review showed after face review that they had 1,055. There was a challenge to the Snyder petition from Jaden Rittenberry that called into question 179 signatures. We processed the challenge because it called into question more than the cushion, which was at that point 55. After we processed the challenge, we did find that there were 30 not registered, 11 where the signature didn't match, 28 duplicates, and a couple other issues. And all told, that did bring Snyder below 980 or below 1,000 to a total of 980. I will note that there was some dispute about duplicate signatures and when they should be disqualified. We didn't accept all of the challenges duplicate signatures here because some of the duplicates, the Snyder signature was the first, so it was acceptable to keep it on the Snyder petition. But even accounting for that, she ended up with 980, and so based on that, we're recommending the board determine the petition insufficient.
Nobody has asked to speak on this matter. Do we have any discussion? With a motion?
I move that the board accept the staff recommendation and find the nominating petition filed by Nikki Snyder insufficient.
Support.
All in favor?
Aye.
Motion carries. The next one might take a little.
Yeah.
Okay, so why don't we break for lunch and try to be back at 1 o'clock. I think we can do that.
We'll be as quick as possible.
So we are
Yeah, we'll
in recess until 1 o'clock.
Yeah, that's usually a good idea.
Let's see.
Just put in my work.
Yeah, don't say it out loud.
No.
We lost Richard. I think he went out for a walk.
Thank you.
Welcome.
Are we ready?
Ready?
Oh, okay.
You guys ready?
Yeah.
Ready?
Okay.
I think we're ready.
Okay. It is 1:06 and we are back on the record. The next item on our agenda is consideration of the sufficiency of the nominating petition submitted by Anil Kumar for the office of United States Representative 10th District.
Thank you.
Director Brader.
Thank you, Chair Gerwitz. So this is a candidate for U.S. Representative of Congress, 10th District. Our face review did identify some signatures of dubious authenticity, and following review, we did identify after a total filing of 1,901, we did identify 951 that were invalid. Some for facial reasons. That the biggest reason was an invalid signature either being omitted or not agreeing sufficiently with the signature on file. We did get a challenge to this petition. Some of that challenge involved allegations of fraud by petition circulators. But in any case, we reviewed the signatures individually. And based on our determination, the candidate did not have enough. They had Kumar had 950 signatures. So our recommendation is to determine it's insufficient. We did get some additional information from Kumar campaign yesterday and then I think the day before, in which they provided some information for us that they said indicated that some of the individuals that we claimed were not registered or that the signature didn't match were in fact registered. We did review those, but it didn't change our overall numbers. I would defer to Adam for the details, but basically I think we found that in some of these cases, it was a registered voter, but the signature didn't match. So I think that was the main thing we found. But Adam, if you want to add anything to that.
Yes, I think that's what Director Brader said is accurate. So the biggest issue with the information that was provided to us, attempting to rehabilitate some of the signatures, was that when we use the not registered code, what it means is that you're not registered in the jurisdiction listed on the petition. So if the signer, for example, put on the petition 123 Main Street, Lansing, Michigan, and then we look them up in the qualified voter file and they're actually registered in Grand Rapids, that is an invalid signature. So we code it as not registered. So with several of the attempted rehabilitations that were provided, it is correct to say that the voter is registered, but the voter was not registered in the jurisdiction listed on the petition at the time of signing. And if we did find the information based on the information provided, when we looked them up in the qualified voter file, as is typical, we look up registration status, check the status, and then verify the signature. Several of the individuals that signed the signature did not match. So we at best would change the code from not registered to invalid signature, which otherwise is still an invalid signature, rejected signature for our purposes. And so even based on the information that was provided yesterday, if we were to assume that every affidavit that was submitted to us is valid, Kumar is still under by 31.
Sarah DiGiglio has asked to speak to this as a representative of Mr. Kumar. If you could spell your name for the reporter and let me remind you that you have 5 minutes. I'm sorry.
There we go. My name is Sarah DiGiglio, SARADIGIGLIO. Good afternoon, Madam Chairperson and Board. Hopefully everybody had a good lunch. My name is Sarah DiGiglio. I'm an authorized representative for Dr. Kumar for Congress. While the initial report from the board showed that Dr. Kumar with an insufficient number of petition signatures, we believe we have sufficient evidence that he does have sufficient signatures. Unlike other cases here today, we have 2 simple buckets of cut and dry signatures that we believe should be counted. I'd love to explain this simple case to you. Bucket 1, we have 24 affidavits that have been signed and notarized by voters whose signatures were marked as invalid. We have copies that I provided, and we can also direct you to the sheet and page number of the signatures in question. The voters have attested that it is their signature in the presence of the notary. And to not count these signatures would be to disenfranchise these voters. We have spoken with more voters who are ready to similarly sign affidavits, but we could not connect with them in time for today. Bucket 2, in our own review of the signatures, we identified 193 signatures that were disqualified by the board as either not registered or registered at other address that we believe are in fact valid signatures. We've provided the QVF number to the board, and we have copies of our spreadsheet here that I've provided. Our ask is at a minimum that you review a representative sample of the signatures that we've brought forward, as this is a determinative amount for qualification in our race. For example, on page 37, line 2, Kevin Lamont Dace, QVF is 119-500-9531, wrote the address of 18350 Ash Avenue, East Point. Same address is in database on our end. And so we wonder what would make this signature invalid, marked as NR by the BOE. In needing only 50 additional signatures, we believe that we have sufficient evidence to merit, at the very least, further investigation by the board of our claims. We've provided this information to the board in advance so that you may consider these fully. Thank you.
Can I ask, is this information that you provided to the Bureau previously?
Yes, I believe that they did provide that. They should have emailed it to the Bureau, I believe.
So what you're giving us here has been given to the Bureau for their review? Am I correct?
I believe that has been provided. I know that we did find more yesterday, and the attorney had an emergency at the last minute he was not able to be here with us. So I'm not 100% certain that you got all of these names.
Excuse me.
It is different and more updated. I'm sorry. I'm reading on here. Pardon me. I'm not an attorney and I didn't have a lot of time to prepare. I'm just a representative for Dr. Kumar. So Bear with me, I'm sorry. But yes, it is more updated and more complete than what was sent to you by the attorney.
Okay, so we have a response from Kumar dated 5/9 and a response to Kumar's staff report stated 5/30. An additional affidavits dated 5/30 or provided to us by 5/30. But this is additional information that you're giving us today. Is that correct? I mean, it's very hard for us to.
Yes, so these are
review
the
this.
affidavits that were signed and dated 5/30. I'm not sure that you got all of them because, pardon me, I don't know what was sent to you in terms of the affidavits, but these were all signed and notarized yesterday.
But these, okay, these are all dated either the 29th or the 30th.
Yeah, so
And so these would have been provided to the Bureau of Elections for their review.
they
Am I
should have
correct?
been.
We received a total of 19.
Okay, so
between-
these are updated.
And it
There-
seems like there's
there's
more,
more.
but there's duplicative from what we had yesterday. It's just my quick
Yes.
look at least.
Yes, so there's 26 in there, I believe. And I think 19 were sent to you yesterday.
Which means there's 7 more that we have not seen or that the Bureau has not had an opportunity to see.
To review, correct? Correct.
Mr. Fracassi or?
Yes.
Yeah.
There's a couple of things. So, it seems to me at least that the spreadsheet that's been given is some duplicative as well from what has already been received in process. But one of the things I want to note is that the specific, there's a column in here that says BOE error code. And there's a number of, there's like about 2.5 pages of R on there. We don't reject a signature. That means registered. So that means that's a valid signature that we did not reject. That means that we looked that voter up. We found whether it was initially part of the challenge or even part of something else that may have been provided. If it's marked as an R, it means that that person that signed the petition is registered in the jurisdiction that they listed. Again, remember, you could be registered at a different address within the same jurisdiction that's listed. That counts as a valid signature still. And that we compared that signature to the qualified voter file and determined that it was a match. So those are not rejected. Those again are valid signatures. The rest of them, I'm looking quickly, so it's the first 2.5 pages seems to be, just looking quickly, duplicative of what was given to me yesterday as well. And we did process everything that was given to me yesterday as well. And we did not flip anything for the reasons that I already explained when we started. But I don't know if there's.
I believe there are about 100 more on this page than we had submitted prior.
Does that include everybody that's marked as R? Because
That I'm not positive on that. I can't speak to that for certain.
So I don't know if further review is necessary because you indicated, Mr. Fracassi, that having reviewed all of the material that was submitted by yesterday, he was still 30 signatures short.
31, presuming that every affidavit was accepted.
Okay.
Which we have not, that's a board decision, but presuming, so I'm gonna back up, 31, presuming the 19 affidavits I received yesterday were accepted. I don't know how many are in this packet.
And I think that you said there are 26 in this packet. So
I believe so, yes.
There were 7 additional ones which were not previously considered by you, Mr. Fracassi, apparently, which would still not change the outcome. Am I correct?
Yes, correct.
And I believe that there were about 54 coded NR that we searched in our database. And I know it's not the same database, that you use, it is a pretty reliable database. And so, you know, doing our research, we did come up with more than what was initially presented to you. And so that could make a difference in the 31 votes or the 31 signatures, I'm sorry, needed on that petition. And so our main ask of you today is just to reconsider, not reconsider, I'm sorry, to, you know, to look back over it, to review it again, further review. Because it is such a small amount that we are looking for. And we feel that we do have these numbers. And while we know that everything that you all do to look into these things is very appropriate, we aren't questioning that or saying that you guys are wrong in what you do, obviously. We just have questions, and with such a narrow number, we would like a further review.
There are some in this, I'm just going through and comparing, and it does seem like there are some in here that were not provided until, like, that there's some in this sheet that were not provided to me yesterday. Correct. That's what it seems like.
Adam, but the ones where they claim that they were registered, but we found they were not registered in the jurisdiction, have we found any that so far that were actually registered in the jurisdiction?
No. Okay. If there are any that were marked as not registered that were attempted to be rehabilitated, they either were not registered in the address that was provided on the petition sheet itself. Like a lot of, for example, wrote down Warren, but they're registered in St. Clair Shores, like that type of issue, or the signature did not match. I'm sorry, I didn't hear you. In the.
So there were a couple of names that were similar, like Manish Patel and Manisha, because I went back through. Yes, I saw the same thing, so I wanted to be certain. Sure. Yes. Mm-hmm. We traveled to people, a lot of them were close friends of the doctor, and we had a notary accessible to us. And so we went to make sure, because these people want their signatures counted. They don't want to be disenfranchised. They want Dr. Kumar on the ballot. You know, he's their representative. They want him as their representative. And so they were more than willing to sign. We still have some people that are willing to sign affidavits. And, you know, between the number of discrepancies that we found, you know, and the significant number of affidavits that we were able to collect in only a few days, we believe there's not enough clarity to disqualify us at this point. We just feel like a further review would be warranted.
Right. It's very difficult for us to engage in that at this time. And I'm just trying to figure out okay, so you provided 19 affidavits to the Bureau yesterday, which they reviewed. And you said that there are 7 additional ones. I don't know if there's anything on the spreadsheets that you have given to us that has not previously been considered. I think that's something that Mr. Fracassi is looking at right now.
Yeah, I think that there were some that were not included in what was previously sent. I think he might have said, I don't know, I'm not sure if he said that. And we still have many more that are willing to sign affidavits.
Yeah, well,
I know,
right.
I understand.
The time is now. So Mr. Fracassi is looking through your spreadsheet. So while he does that, if you would, you know, take your seat in the audience again, and we will go forward because we are really pressed for time.
Sure thing.
And we'll see what he finds out.
Okay, thank you.
Thank you.
Thank you for your time.
Okay, so
Madam Chair, we're tabling this one.
yes. So next item on the agenda is number 11, consideration of the sufficiency of the nominating petition submitted by Rhonda Powell for the office of United States Rep 10th District.
Yes, so
Okay, and Rhonda Powell is here.
yes, so this is another US Representative Congress petition. In this instance, we found that the total filing consisted of 964 signatures, which is short of the 1,000 that's required. Couple notes on this. So first, in Powell's response, she indicates that she submitted 1,044 signatures as opposed to 964, which we counted. It's not clear what the basis is for her different count than ours. We have 120 sheets. The affidavit of identity that she submitted had 120 sheets listed in the receipt portion. So we seem to agree on the number of sheets. The only thing I can think of is perhaps she's counting lines with crossed out signatures or things like that, but we count 964. The other issue is that she asserted that she submitted 77 more signatures as a supplemental filing on April 23rd. We don't have those. We asked if the campaign had a receipt, which they provided when they submit the supplemental filing. They did not have that. So I'm not sure what occurred exactly, but one possibility is that there was a circulator, Wendell Thomas, who was in the building that had a large number of petition sheets and was not able to actually submit them all by the 4 p.m. deadline. So that could be the explanation, but I'm not sure. Regardless, it doesn't affect our recommendation because I noted that the total number of signatures filed was 964, not including the 77 claimed supplemental ones. But of those, our face reviews show that 907 were valid. So even adding the 77, even if we assume that those were submitted and they were all valid, it wouldn't be enough to reach 1,000. So based on that, we are recommending finding the petition insufficient.
Ms. Powell. Spell your name for the record, please.
Sure thing. Good afternoon. My name is Rhonda Powell, RHONDA POWELL. So thank you for the opportunity to just address the board. In this case, I think that there for me were really two primary issues. I reviewed and responded to the challenge because I never received notice from the Bureau that there was less than 1,000 signatures. It was my understanding that we had, that Mr. Thomas, the paid consultant, had made a supplemental filing on the 23rd that should have been, in our estimation, our expectation was that it was much more than 77 signatures. But we later learned there were a bunch of other issues going on with that particular consultant. And so the 77 is what we had in our possession that, I submitted, that we had acquired from him. So what I wanted to speak to is just the process, because as was stated, with the signatures, the challenge, we did not receive anything from the board. I will reiterate, even though it says, not the board, I'm sorry, from the staff stating that there was less than 1,000 signatures. And at this time, we didn't know there was an issue with this particular consultant and or the filing of our additional signatures. So part of the challenge is without that notification, then we were kind of shooting in the dark until. So what it appears is that we received notice, I think, May 1st via challenge that we had been challenged. The petitions had been challenged, which I did not think at that point that would be a problem, that a challenge in and of itself is not a problem. But when the staff, I'm not sure when the staff came about the review of 964, because it seems like from the rules that we should have been notified that we were, that is the staff's responsibility. according to the statute.
Can I just interrupt? And now your petitions were filed on April 23rd?
22nd and
22nd.
supplemental
And then you said a supplemental on the 23rd.
Mhm.
So if the staff had notified you either on the 23rd or the 24th, it wouldn't have made any difference, would it? Because that was the filing deadline.
I'm guessing we will never know.
I'm sorry?
I'm guessing we will never know. We know for a fact that we had plenty of volunteers in the community that were working with this consultant. And the last problem this campaign has is with community support.
Right. So your consultant may have failed you, but the question that, I mean, I don't know what you're asking us to do, because the board Bureau has concluded that you have an insufficient number of signatures. And I don't think you're disputing that, are you?
Well, what I spoke to is the challenge, because that is what the staff responded to. The staff, I don't see where our petitions were even reviewed until there was a challenge, which is problematic in and of itself. So what I responded to is the fact that the 1,044 signatures, the challenge stated that regardless of validity, we submitted fewer than 1,000 signatures. And that is not the case. When you add validity, when you go through and verify, and I'm not saying I agree with all of that, the ones that were discounted, then that could put us under 1,000. But the challenge stated regardless of validity. In addition to that, that is just not true. In addition to that, there were 17 signatures that were disputed. And those 17 signatures, not all of that was correct, which I put in our response. So part of the challenge is, I think that just having that process and not having that initial review by the staff, it really subjects the candidates. If the staff is only responding to challenges, then it subjects myself and probably others to an unequal level of scrutiny. Because there are other candidates in the 10th who have problematic signatures on their ballots, on their petitions, but just because they weren't challenged, they weren't scrutinized the same way. So I think that in and of itself is problematic and definitely subjects us to unequal treatment. The other thing is, there is a consideration for me, or at least it should be a consideration where fraud and sabotage is clearly at play. This person,
We can't do anything about that, and that doesn't rehabilitate your petitions, nor does it. If he didn't file them in a timely manner, that's your problem, not ours. Quite
well,
frankly.
we don't know. According to the response that we received about the filing, it's not clear if he was unable to file them and was not there. He was clearly there, but wasn't allowed to file because the clock struck 4. I don't know.
Except that the Bureau of Elections never received 1,000 signatures. So even without a challenge, the point being, without a challenge, you still would have been on this list as being insufficient signatures, regardless of the challenge. You didn't have enough signatures to meet the requirement.
So that I don't know because we never received anything from the Bureau staff stating that we were below 1,000 when clearly other candidates who hadn't reached their minimum number of petition signatures, they were notified.
I don't know that that is the case, but you did not have, when you file at the last minute, whether the board notifies you that your signatures are inadequate or not, you've done what you can do. You have turned in the number of signatures that you could turn in. You couldn't have turned in any more. So when the Bureau concludes that you have an insufficient number, as Vice Chair Hauskamp says, it didn't matter even whether there was a challenge. So I think I don't hear anything that suggests that the board's conclusion or that the Bureau's recommendation is not sound. There's nothing, you have given
Well-
us nothing to reject that recommendation.
Well, that's because we received this on Friday, that we had 907 signatures is what the staff, versus the, 964, which the supplemental filing that we thought would have remedied that.
Would have, but it didn't. It might have, but it didn't. And so, I'm sorry, but
So we don't know how they went from 964 to 907.
we do. It's right there in the staff report. It's the conclusion that they reached regarding,
The numbers are there, but not the petitions.
I'm sorry.
The numbers of their calculations, how they came to that, the numbers, but not the petitions for us to look at to say,
but it doesn't matter because you didn't have enough. You had 964. So
we
I-
would have
I
had
think-
enough if the supplemental it is considered, because they state that Mr. Thomas was there and filing petitions.
But they have said that they looked and they find nothing from him supplementing your petition. So
If I had propellers, I'd be an airplane. I mean, it sounds like you've been victimized in terms of the signature issue by Mr. Thomas,
Right.
who is the subject of a lengthy free press profile in the last couple of weeks for work that, or lack of work that he's done for others. And we genuinely sympathize with you on this, but unfortunately, we're working with the data as it was presented, and there's simply no reason for us to overturn the decision by staff. And I'm sorry about that, but
Yeah.
that's ultimately kind of where we are.
Which, I completely understand that. I just think it's important to put it on record. And I also think that, the process, a clear review needs to be done of all the petitions, because like I said, just because a candidate is not challenged, it's still not equitable if you're only scrutinizing petitions based on challenges. That is unequal treatment and unfair. And I also think that,
But
the
your
process.
petition would have been brought up here in this part of the meeting as insufficient, regardless of any challenges filed. You didn't have enough signatures. And so the Bureau of Elections would have come up and put you in this list saying, no, not enough signatures. The challenge is completely irrelevant.
I disagree with that, because there is no one who hasn't been challenged who is, we're only talking about petitions that have been challenged. Nothing
but you
that
didn't have
just,
enough
that just
signatures,
based on the
so, right.
Bureau staff.
So, yeah. I
So
think-
that creates a challenge for me. And I think that,
Yeah.
ultimately, especially the process needs to be reviewed, because it is clear that the rules and the statutes are being bastardized
Well,
in order
wait
to
a second.
disenfranchise.
As the candidate and as somebody who's passionate about winning an election, wouldn't you think that one of those passionate action points would be for you to look at your signatures and verify what you're putting into the Bureau of Elections?
It sounds very simple,
And you're
doesn't
telling
it?
us that you didn't know whether there was 1,000 or 900 or how many were there. So I'm not, I guess I'm putting that back
And
in
I'll
your
leave my,
court.
I'll leave my statement, the written statement on record, but I was back and forth. And this is the problem with the clear sabotage that some of the candidates are facing, is because we had an appointment scheduled and time to meet, and the Bureau staff can attest to the fact that we were there back and forth because this person deliberately, by the time we got there, all we could do, like 3 hours went by, but that's a separate issue. So it was not that we didn't have time set aside to go through and review them, but because of how they did things and showed up deliberately 3 hours late, we ended up just having to submit them.
Just a parenthetical for you, because I think it's important that you keep this in mind too. These folks you see from the Bureau here
Mhm.
and the team that they have, Jessica in the back and the rest of these folks,
Mhm.
this is the best customer service in the state of Michigan. It's the best customer service in the country. These people work really hard to make sure that everything is accounted for, everything is properly done, okay? If you didn't turn in enough signatures, not one of those people is responsible for not trying to help make everything come together.
Oh, and that certainly isn't my
Okay.
assertion.
I'm sorry?
That's not what I'm asserting, that it was
Okay.
their responsibility.
Because these folks.
But I
do
mean,
it
just
right.
from all of the conversation today, it's clear we have some process problems.
And we're always looking at the process.
We are,
but It is
yep.
time for us to move on. Do we have a
Make a
motion?
Yes.
Thank you, Ms. Powell.
Thank you. No, I'll take yours if you've got it. That's perfect. Thank you. I move that the board accept the staff recommendations and find the nominating petitions filed by Rhonda Powell insufficient.
Support. All in favor?
Aye.
Aye. Motion carries.
Madam Chair, can I just get a clarification from Director Brader very quickly?
Sure.
Because I think that there's some comments and things that are being made. And maybe it's to Director Brader, maybe it's to Adam. The process of when petitions, you knew I was coming with this question.
I don't know, maybe.
The process of petitions when they are submitted to the Bureau. And I'm specifically going to state nominating petitions. What happens once that what,
Yeah.
could you explain that
Sure.
process, please?
Sure. So when we get them, first of all, we give the person, when they file an affidavit of identity, we give them an estimate, or we give them the number of sheets they submitted. We write that on their affidavit of identity. Of course, we're not able to like count the signatures out right in front of them because that takes up time. But when we get them, when we get the sheets, we start by scanning them, and then we conduct a face review as soon as we can. We do face review every sheet for every petition, except for the Senate where we do the sample. So we do review every sheet regardless of whether there's a challenge. And also if we see sheets that show clear indications of fraud during the face review, we do review those more carefully regardless of whether there was a challenge. It is true that that we will look at other things that are challenged in addition to that. So it is true that if a challenge is filed, we will look at those carefully because we're required to, but we do look at every sheet regardless of whether there's a challenge. And also the other thing I'll just mention in terms of the count estimate, we can't count in real time. One, because we have to scan them in first, and two, because we have to look for things like crossed out lines and missing lines. We can't very quickly, like in real time, instantaneously come up with a total count of signatures. But we're usually able to get that count within a few days. So when possible, like as a courtesy, if somebody comes in well before the deadline and our initial count does show them short of signatures, we will let them know. But that's not something that's possible to do the day before the filing deadline or the day of the filing deadline when we're getting dozens of petitions and we have, over 400,000 signatures filed. So we just can't do that when people come in at the deadline.
The next item on the agenda is number 12, consideration of the sufficiency of the nominating petition submitted by Stephen Elliott for the office of United States Rep 12th District.
This is another U.S. representative in Congress petition. In this case, the candidate Elliott submitted 1,358 signatures. After face review, there were 1,261 facially valid signatures. There was a challenge that was submitted. Well, actually, I should say before the challenge, we even get to the challenge, there was we did find during face review, this is what I was just talking about. We did find face review 71 sheets that did have clear indications of fraud. So we looked at those more carefully. We also did get a challenge, and the challenge was calling into question a lot of signatures as well. So following our review, we determined that 361 of the signatures were not registered. Another 108 were invalid, and a couple other issues. And all told, that left the candidate with 784 valid signatures. So we are recommending determining the petition insufficient.
Okay. Nobody has asked to speak to this matter, so do we have a motion?
I'll move that, sorry. I move that the Board of I move that the board accept the staff recommendation and find the nominating petition filed by Stephen Elliott insufficient.
Support.
All in favor?
Aye.
Aye. The next item on the agenda is consideration of the sufficiency of the nominating petition submitted by Ryan Foster for the office of United States Representative, 12th District. Director Brader?
Sure, thanks, Chair Gerwitz. So additional candidate for U.S. Rep in Congress. This filing by Foster consisted of 1,181 signatures. After face review, we found 1,102 facially valid signatures. There was a challenge to the petition that was calling into question 266 signatures based on various issues. We processed that challenge. And after reviewing the challenge, we found that 113 were not registered. And then there were some additional issues such as invalid signatures, duplicate signatures, and a few other things. And all told, that left the candidate with 926 valid signatures. So based on that, we are recommending determining the petition insufficient.
How you doing? Ryan Foster, RYAN-FOSTR. I started
Can you identify? I'm sorry.
Ryan Foster,
Okay.
RYAN-FOSTR, running for U.S. Congress 12. We have 13 cities. When I started this campaign, I got the signatures myself. I didn't pay nobody to get any signatures. At the bottom of the sheet, I signed every date, my name. And so the discrepancy on there, I looked at the challenge. The challenge is from my the person that's going against me is her staff, which is Rashida Tlaib, because her and Tanadar know they don't want any Black candidates to run in Detroit area. They've been doing this for years. So when a person signs the sheet, they sign their name, they put the date. And then if there's any spots open on the sheet, I'll leave it open to the next day. And then once that sheet is done, then I'll sign it at the bottom, the date that I finished it. They're saying that the dates don't match. And so I didn't get 10 signatures one day. I might got 5 signatures one day. But all the signatures I got it myself. Another thing, it's saying that 113 signatures is not registered. I walked those neighborhoods. I knocked on the door. A lot of people that I signed were young. If they were over 18, they're American citizen, they lived at that address, they showed me their driver's license ID. I said, you know, when you go to vote in the primary or go to vote in the general, they're going to vote for me because they were new voters. They were new. And then another thing, it says that some of the signatures I got were not in the district. Most of the signatures I got was Inkster. All of the city of Inkster is in the district. Redford, all of Redford is in the district, and Sawfield. All of the Sawfield is in the district. So I'm just asking if you could, the person that challenged my signatures works for Rashida Tlaib. And they were systematically, purposely, because I turned this stuff in March 17th. They said I was fine. Until May 2nd, they sent me this challenge. And remember, I did this myself in 2 months, in the snow, in the rain, walking around. I don't walk very fast. And if you could just review those signatures, those 206 signatures, and see if they stay in the district, if they're over 18, because they're going to vote. Because I'm very short, but I turned in 1,200 signatures almost, and I didn't pay anybody. I signed those sheets. I did everything the right way. In America, this system is falling apart because the only time you can run for a race is if you have money or you have name recognition or you are the right color. I did everything right. And then I have some incumbent with a lot of money to pay somebody to challenge my signatures makes me very upset. And it's sad that the person is not here. If they was here, they'll be sitting right here. I'll tell them exactly how I feel. Hopefully they are here. But to sit there and challenge somebody when the other candidates, they pay people to get signatures for them. I did this myself. I took time off of work. I got people signed up. I gave everybody a flyer that signed for me. I mean, it was $2 a flyer. I spent a lot of effort and a lot of money doing this, and I didn't pay anybody. I did it myself. And I got a lot of young people signed up. And they were American citizens. They lived at that address. I seen the address. It wasn't apartment complexes, it wasn't Kroger. I went to their house. They signed. I looked at it. I looked at their ID, their driving license, and that was it. And so I did everything right. And just to have some incumbent pay somebody that works for her to challenge my signatures when I did everything the right way, this system is messed up. It's basically saying if you don't have a lot of money, if you're not the right color, and if you're an incumbent, you can do what you want. So if you could just review those 266 signatures, because I did everything the right way. And then if the only way you're going to get by in this system is have money and pay people and then challenge all the people that don't have name recognition, the system is badly broken.
Thank you, Mr. Foster. I appreciate what you're saying. And I really appreciate the work that you put into this. And I'm sorry that it appears that it might not work out, but we have one person, Luke Swankowski, who was asked to speak to this.
Oh, so he's here. Okay. All right.
Mr. Zwank. Oh, I'm sorry. Okay. That's right.
Can I ask one quick question?
Sure.
Mr. Turner? Foster, I'm sorry. You're asking them to review those signatures
266
that were challenged.
Yes.
Am I mistaken that you did review these?
Right, we did review.
Okay.
You know, it is typically the case, challenges often do come from the so in this case, we did independently all of the challenges. That did show that 113 folks signed it not registered. So that was the predominant. And the majority of the signatures collected were valid, but you know, there was a pretty small cushion, and because 113 were not registered, that was the predominant reason we found that.
And then it was also 60. It says the dates don't match. I signed the bottom of those pages. The dates that they put on there was the date they signed it. Sometimes people will skip a line, but the date that I finished it, I put on the bottom.
Oh, I see. Yeah, so those 50 were ones we identified in phase review. The issue there was that the circulator signature, right, is before the voter signature, or what's the issue there?
It could be a variety of issues. So it could be that the date is blank. The signer put their birthday is another one that's common. The circ date would be before the date listed at the top. So I mean, it's the invalid date category is like the just general category that says the date on the petition. There was an error with that.
Do they throw signatures out if they're missing part of the city? Because I had a lot of people that put Redford, but they didn't put Township. And then I had a lot of people that put Sawfield, but they didn't write out Sawfield. They put SLVD.
We typically don't reject for abbreviations as long as it's clear when we're reviewing what the jurisdiction is. So like, I think Southfield SLFD is already approved, even in the board's manual already. So
the question I have is, I don't want to waste too much time if other people want to talk. If they could review those 266 again, you think they could do that before, if I stay here? Because I know one candidate, they're doing that, but like I said, I put a lot of work into this, and everybody I talked to, I didn't pay nobody to do this. I seen their address. A lot of people were young, and they said they're going to vote.
The candidate that they're reviewing, they're reviewing two, but one is because they'd not previously been reviewed and there was a different question. Okay. And then Mr. Fracassi is looking, but I think that there was a review already, a careful review. So I'm really sorry about that, but okay. And I do appreciate what you're saying about how difficult it is for a person without resources to compete.
So I submitted 1,200 and they didn't say anything to me until this challenge. And then the first challenge, they threw out 100. And then they challenged again for the second time and they threw out another 100. He challenged 2 times in a couple of days. That's what it looks like. It's look like it's 2 things they was trying to throw out.
Do we get the challenge in two parts or not? I don't know if that's actually.
No, I think
Okay.
what he's referring to is the
Okay.
first part of the staff report
see,
is
okay.
our
So
fate.
the process we followed is the same process that we follow every petition. First, we do a face review. And our face review determined that about 79 were facially invalid. Then we got the challenge from the other candidate, and we processed that challenge. And based on reviewing the challenge signatures, that's when we identified another 100 some that were invalid. And that's what brought the candidate under 1,000.
And there has been a careful review.
Okay.
Thank you, Mr. Foster. So Mr. Swankowski has asked for accommodation and to appear by Zoom. Please make it brief. Mr. Swankowski?
Thank you. I apologize for not being there in person. I tested positive for COVID earlier this week. I don't have any comment beyond just wanting to make myself available to the board if anyone does have any questions about the challenge I filed on April 29th. But that's all. Thank you.
I can ask a question. No,
Yeah, you can. Go ahead.
he's there?
Yeah.
Okay, the question I have is, I hope you're proud of yourself that you've helped a candidate that got people chanting death to America to get another person that loves America off the ballot.
Thank you, Mr. Mustard. The next item on the agenda, number 14. Oh, I'm sorry. Oh, a motion. I'm worried about getting everything done. Do we have a motion?
Excuse me, I move. I want to make sure I get the name ready because I messed it up once. I move that the board accept the staff recommendation and find the nominating petition by Ryan Foster insufficient.
Support. All in favor? Aye. Motion carries. Okay, now, number 14, consideration of the sufficiency of the nominating petition submitted by Hassan H. Nemi for the Office of the United States Rep 12th District.
So this candidate is US Rep 12th District. We got a total filing of 1,119 signatures, conducted phase review. We did find in phase review that there were 317 that had invalid date. I think the biggest issue was that the signature of the signers were signing after the circulator date. That was the dominant issue. But in total, that knocked off 317, which brought the candidate below 1,000. So based on that, we are recommending determining the petition insufficient.
No one has asked to speak. Oh, I'm sorry. I don't have anything, but okay.
I came up and asked.
Okay.
Hello, guys. Hassan Nemi.
You spell your name for the
HASSANNEHME. And essentially, we were gathering the signatures and went to go turn them in. As you guys know, I'm from Dearborn, and a lot of our community is not proficient in the English language. We also have a ballot in Dearborn that's translated to Arabic for the people. When we were gathering our signatures, I had my family helping me gather these with our community. A lot of them are not proficient or well spoken in English. So they grabbed their clipboards the night before they were due, and we all gathered at my house to kind of sign the corners of the signature gatherers, where they sign at it. My little brother was translating the rules on the back to the family members that were signing them all off on there, and he mistakenly told them to backdate them all. We emailed over an affidavit stating that. So everybody kind of went through the night before we turned them in, but went and backdated to the first date on each sheet, thinking they were following the rules, though they weren't. And it's kind of where we're at right now.
That's a really sad.
I know.
I
know. Yeah, that's why when I sent that email and I asked earlier, I was just wondering if we received the affidavit as well. Should have been sent this morning.
I mean, I would say, I don't think we got that, but I mean, we can only go on what's on the petition.
Okay.
Right.
Yeah, just to clarify, so you kind of batch dated them at the last, but
Yeah, after he was reading the rules and seeing he misread it, I'm assuming, and kind of told everybody to date them that way. So they're all dated as the first signature that's signed on the form, but they were all signed the night before we submitted. They were up till like 4 a.m. organizing them, getting them all done.
they dated them the day they started instead of the day they ended, right?
Some
Yeah,
of them,
yeah.
right. That's not all I'm looking through, but
Well, you'll see some of them too that
yeah,
are
I
dated
know, I
because
did
the
see
whole
that.
date is the
You
same.
know, I'm afraid we can't help that situation. I hope you don't give up. Try
No.
again.
No,
You and
no,
Mr. Foster are both.
appreciate it.
Okay. Do we have a motion?
I can do it. I got it. I move that the board accept staff recommendations and find the nominating petition filed by Hassan Nema insufficient.
Support.
And one question, sir, did I get your name right? Nimi? Forgive me. Perfect.
All in favor?
Aye.
Aye. Motion carries. The next item, consideration of the sufficiency of the nominating petitions submitted by Lisa Marie Nielsen for the office of Second District Judge of Court of Appeals, non-incumbent position. We have 2 people who have asked to speak. I think the first will be Philip Seltzer.
Yeah, I can. I'll give a brief summary.
Oh, I'm
of that
sorry.
report. I think we're going to hear all about it from both sides, so I'll try to be brief. But essentially, our face review, so this is a Court of Appeals candidate needing to submit 6,200. We did face review. We ended up with 7,999 facially valid signatures. We then got an extensive challenge that called thousands of signatures into question. Some of those were based on allegations from the challenger that signatures were forged, some other reasons. In any case, we conducted our own review of all the signatures. Based on that, we did find that about 1,048 were not registered of the signers, 698 had invalid signatures and several other issues. And then in total, after processing the challenge, we found that there were 6,098 valid signatures, which is below the 6,200. We then, so based on that, we recommend not determining the petition as insufficient. We subsequently got some additional information from the Nielsen campaign. We were looking at that. A lot of it came in late in the day yesterday, so we've done our best to look through it. And I think we have some findings based on that that Adam can share either before or after we hear from the, I don't know if it matters, but Adam can let you know what we found. I guess you might as well just tell him now.
So we received an Excel sheet yesterday around late afternoon. But we went through and processed the Excel sheet. It provided additional information about signers with registration, et cetera. So in total, there are 3 tabs to the Excel sheet. We flipped 11 in tab 1, 25 in tab 2, and 39 in tab 3. I believe this is also in your packets as well. It should be the last thing. So for a total, we flipped an additional 75, and then so the new number would put the candidate under still by 27 instead of 102.
Consider the other facial challenges. Did you consider the other facial challenges? That were in the objections that were filed yesterday at 4 o'clock. There was about I think another 46 or so facial challenges.
So we look.
I'm coming to
Okay, you want to come forward and identify yourself?
My name is Philip Seltzer. I'm an attorney. I represent Lisa Marie Nielsen.
Can you spell your name for the reporter?
Seltzer is Seltzer, Philip with 2 L's. It's a pleasure to be here. As you know, we got the line by line analysis from the BOA on the 28th of May, had about 48 hours to review it and look at it. During that time period, the candidate did retain the Mark Rebner group to run an analysis of the registration lists of those who the BOA identified as not registered. His report, which we attached as exhibit 2 and 3, show that 123 were properly registered. And there was a number that was registered at the address listed on the petition, and that there was another, this is exhibit 3, another 70 voters that were not registered at that address, but they were registered in the city or township that they signed in. So jurisdictionally, it was correct. That's 123 registered voters that I believe the BOA just missed. And of course, if you add that to the, and we've given you the spreadsheets, the exhibits, the HVF numbers, and the names of the voter. I'm not too sure why that 123 number is not being accepted, but if it is, that would put her over the 102 deficit. Also, there was, I think on exhibit 10 that's attached and discussed, there was some objections to alleged circulator errors, and on 13 petitions we identified and attached, we note that there's no errors at all in those particular petitions. And of those petitions, Mr. Grebner's group found 88 registered voters that weren't even looked at because there was a determination that there was circulator errors. If you add those, that's 211 registered voters, properly registered, who signed, that have counted, clearly puts Lisa Marie Nielsen over the number to be certified as a candidate for the Michigan Court of Appeals. There was also a number of facial challenges that we outlined in detail. You know, and this is a smaller number, but it adds to the number. And I'm sure we can get more. We had more than the 48-hour period to look at this. But things like 2 signatures were crossed out as being duplicate. They were the same names, but they were father and son, and the son signed his name with Junior, both properly registered voters. Those should be reinstated. There was claims that there was not unmatching signatures regard to a number of circulated nominating petitions. We got affidavits and email confirmations from the circulator saying, well, I know that these people are true because they're my spouse, they're my sister, they're close personal acquaintances, are our family. One guy was, he's in a bowling league. It was his buddy at the bowling league because he got signed the events at a bowling alley. And we've outlined all those in detail. I'm not going to, for purposes of brevity, not have to go through it. You have it in front of you. Those should also be counted. If you add all of those up, then I think you're over, I think it's like 6,309 would be the number. So I believe that you have before you the evidence.
There's 2 duplicates. Yeah. She was 27 short. There's 2 duplicates, which makes her 25 short, and the rehabs are 26. And there's other challenges.
Right. And which we've
So
outlined.
Let me just interrupt for a minute.
Sure.
The information that you're summarizing here is information that you provided.
Yes, we
to the
provided
Bureau.
it yesterday at 4 o'clock because we got the line by line analysis of the BOA's report, just 48 hours before that. But we put it together. We worked really hard, got it together for you, and presented that evidence, including affidavits from circulators about that. Yes, there's a number of people that you claim the signatures don't match. Well, one's my husband, one's my sister. They're legitimate. And like I said, 211 valid registered voters, 123 that were not looked at, and another 88 on petition on a claim that there were circulator errors on the petitions, but we could not find any errors. We've identified the 13 petitions, we've attached them. And we also attached Mr. Grebner's report out of that. Of those petitions, 116 signatures, 88 are validly registered. So when you add those up, she clearly exceeds the number that you need to be certified as a candidate to the Michigan Court of Appeals. And I would think under these circumstances, you should do so.
Before we ask you further questions, Mark Brewer has asked to speak to this matter.
Thank you, Madam Chair, members of the board. Mark, Brewer on behalf of the challenger, Brenda Bovee. The staff report was entirely accurate, and in any event, in our view, it really undercounts the amount of forgery that is found throughout this petition, and we detail that in our complaint. This petition is riddled with forgery. This candidate or whoever worked for her did not take responsibility for making sure that those forgeries did not exist. And it's a serious problem here. This candidate now has had 2 chances to try to rehabilitate signatures. Like every other candidate, they had notice when the challenge was filed, and they had 7 days to respond. And the response was insufficient. Staff reviewed it. It did not rebut the challenges that were made by not only my client, but somebody else. And then late yesterday, they tried to take a second bite of the apple with all the information they now claim rehabilitates these signatures. Based on what I've heard from the staff, they're still short. I've not seen any of the information that they allegedly provided yesterday afternoon, but this morning we learned that deadlines mean something before this board. They had 7 days to respond to the challenge and not sandbag the board and the challengers by waiting until 4 o'clock the day before this board meets to file all this alleged evidence. There's not enough evidence to rebut the staff report, and frankly, it should be rejected as untimely. This petition is riddled with forgery, and this candidate has no place beyond the ballot, let alone sitting on the Court of Appeals.
I believe that, if I could respond, that the BOA did, I think, address almost all of his somewhat defamatory allegations, and I won't have to repeat it. The BOA worked diligently and worked very hard to review these. We, of course, didn't get the line-by-line analysis of how they were, who they disqualified and how until the 28th. And it was only then that we could actually evaluate and assess the basis for the conclusions in the BOA report on the 24th. Within 48 hours, we produced, before this hearing, our response and objections to the BOA report and filed it yesterday at 4 o'clock. I think that shows pretty clearly that there's at least 211 registered voters, properly registered voters that were on the petitions that were missed. I don't know how they were missed, but they were missed by the BOA. Mistakes happen. I think people work very hard. You have a lot of responsibilities. But if you include those numbers, plus I think the additional 46 facial challenges that we rebut in materials, even just the 211 is enough. Even the 123 is enough. Forget the ones on the 88 that were on the petitions that the BOA for some reason determined weren't proper. We present all those petitions. We didn't know which ones they were until we saw the line by line what they did. We presented them. They've attached. We've shown that there's no irregularities on, I think, 13 of these petitions, and there's 88 registered voters on those petitions. That gives you the 211. But before you get to there, they found that there was 1,098 that were not registered. Mr. Grebner's group determined, well, no, there's actually 122 that are properly registered on the list that the BOA decided were not included. So when you add all those up, she clearly exceeds the number of 6,200, and I believe should be certified. I think that information is in front of you, and if you need more time to look at it, obviously you can do that, but you have that information now. It's all there. And it would be, given the fact that the signatures were properly collected, they're certified registered voters, and for some reason, again, human error, whatever, they were missed, that would put her over the top needed for her candidacy to be certified. Under these circumstances, we request that you would certify it, or at least take the time to review the materials that were timely given to you yesterday.
Madam Chair, may I ask a question of Director Brader, please? What is the process for rehabilitating a signature? Because I'm looking at affidavits from another candidate, and then I'm looking at the material that you sent yesterday in the evening. Believe me, I know, I was here in Lansing going through these.
I bet.
But the question I have is that on these affidavits that we're currently looking at for another another campaign, another candidate, that's the individual signing that they signed it. On these that I've been looking for is, it's my husband, it's my friend, I saw them. But I guess that's my question. What is that look like? What is accepted as a rehabilitation? I mean, I could,
Well, I'm sorry.
I wasn't for, I'm asking it to Director Brader. I mean, you're going to give me your answer. I would like to understand where the Bureau stance is and how you rehabilitate for an affidavit such as that.
So I probably need Adam to help me on this a bit, but I'll just sort of generally say it depends on what is being rehabilitated. But if if we determine, or if a challenger argues that the voter is not registered and the campaign can provide information indicating that the voter is registered in the jurisdiction, and also where they indicated on the petition form, that is likely going to be sufficient if we determine that independently. When it comes to signatures, if we find a signature doesn't match, that's where we would be looking for something individual to the voter that says, I sign petition sheet 17, line 4, and that is my signature. If we get an affidavit that says that, then, that's, I guess I couldn't say for sure, but that's likely going to compel us to reverse our determination that the signature didn't match. But Adam, I don't know if you want to add anything to that.
No, I think that's.
Okay, and Mr. Percassi, you had time to review the material that was submitted yesterday at 4 o'clock.
So I reviewed the Excel sheet that was submitted. I'm looking now, trying to understand what is the additional part of the challenge. It was a 100-page document that was submitted, and then PDF, and then plus an Excel sheet. And there's 3 tabs within the Excel sheet. So we processed this morning all of the attempted rehabilitations in the Excel sheet. And there's 2 different things. There was the Excel sheet that was submitted last night, and then there was also an Excel sheet submitted in response to the challenge. And so we processed all of those. So to the extent that there's some other facial challenge, I'm not 100% sure where, or like, I would need to spend a little bit more time to figure out exactly what's being challenged, to be frank.
Seems like there's 3 categories of things that they're disputing the staff report. So there's voters that we said were not registered, that they said actually were registered. We've looked at those, I believe, and we determined that some of them were in fact registered, but not enough to make up the difference. They seem to also be submitting, or attempting to submit affidavits or other evidence that shows that signatures that we say do not match actually did match. And then they also seem to be disputing some of our determinations that sheets were invalid because of facial reasons. And it sounds like from what Adam's saying is that we've looked at the registrations, but we haven't had time to review the attempted disputing of the signature matching or the attempted disputes of the facial issues.
I believe the signature matching was part of the Excel as well.
Okay, so it may just be the facial issues that we haven't had a chance to look at.
Well, I believe the materials and exhibits attached last night regarding the registered voters is the same in the Excel sheets. And yes, and like I said, according to Mr. Grebner's group, they determined there's 211 registered voters. Either they were registered on the signatures on the list, or they were registered in the city or township where this was signed, even though the registration address is different, but in the same city or township. And they're, like I said, they're what is it? The qualified voter file number is attached to each one of those, disclosed to you along with their name. I think that's on the Excel sheets and on the exhibits that we produced yesterday. So I'm not too sure why there's a discrepancy in terms of determining the registered voters, either they're registered or they're not. In terms of the other 46 or so, that's the materials last night, which may, and I understand, they were submitted at 4 o'clock yesterday. You may not have had time to fully look at those, but I think when you're looking at it all together, I think she exceeds the threshold number here, and we just want to make sure that you carefully review those materials before you make a decision.
But to the extent that any Excel sheet has been provided to us, we have reviewed whether it was provided before yesterday or yesterday. We have reviewed every single Excel sheet and we have verified the registration status for every single person on every Excel sheet that was given to us. Either
That's what
as part of the challenge, like in the response to the challenge, or that was provided at 4 o'clock. So I just want to make sure that that is clear because I'm struggling and I want to just make sure it's clear exactly.
Numbers are reflected in.
That number is reflected in what I read. So we ended up reversing from the staff report. We added in an additional 73, putting the candidate down 29. The staff report and the staff report that we put out had her down, I believe, 102. Then we got the Excel sheet last night, yesterday, processed it, and she is now down by 29. We did reverse 73 at the end of the original calls.
So
29 short.
Correct.
So all of these registrations disputes have been reviewed by you and your team. There's no outstanding disputes that this gentleman is referring to.
Well, other than the facial issues that we've also referenced, I think it was, it's about 46 other people. And again, it was, like I said, we couldn't do the line by line comparison and the analysis until the 28th when we got the detail, which was exceedingly helpful. I suspect if we had a little more time, we could find some more. And I would note that this is not a case where this is a primary. There's no primary here. This is.
Know what the facial issues are.
Things like, let's see. Let me get to them. For example, they invalidated 10 for the wrong city or township. But on the ones that they identified, one of them was exactly the correct city or township. So that one gets back. That's exhibit 12. And exhibit 13, they invalidated 14 for the wrong address. We pointed out that 4 of them actually were the correct address. 2 of them, for example, they lived on a street called Georgia. They inverted 2 letters in the word Georgia. One other guy lived on a street called, I think it was Passamore. And the way he wrote it, the A in Passamore seems a little bit hard to read, but it's his address. It's the registered address. So those kind of facial, very small, detailed kind of things that we've pointed out. I've already talked about the invalidated 2 signatures because they claimed they were duplicates when in fact they're a father and his son with the same name and the son signed as junior. They're registered. Those kind of items are what I'm talking about. Like I said, I think there's.
Information was provided to the Bureau when?
Yesterday at 4 o'clock. And that would be, if that's counted, obviously. I'm sorry.
In what format did you provide that information?
It was to Bureau of Elections. It's called Objections to May 24th Staff Report with exhibits, and it was emailed to the Bureau last night at 4 o'clock. I don't know when all of you were able to get a copy of it. And I appreciate that you might need a little bit more time to evaluate it, given the circumstances. And I've just pointed out again, there's no primary in this election. So there's more time here.
That out to us that there's plenty of time.
Yes.
And
Just saying.
Pointed out to Mr. Brewer that this is the time. So there's, and that was something we struggled with, but we're not continuing at this point to evaluate.
Well, I'm saying you have the material, and if it's an issue of I haven't reviewed it yet to assess it, to look at the extra 46, then I'm just asking that you have it. It was timely provided to you, and that we ask that you review it before you make a decision, at least table it until then. Happy to come back whenever you want, June 4th, later today, however you want to do it. I just think it needs to be looked at. And I think the candidate deserves that be looked at since we've pointed it out.
Madam Chair, may I respond to a couple of these points?
Yeah.
First of all, the candidate has to take some responsibility here. She had 7 days after the challenge was filed to do all the analysis and all the rebuttal that she chose to do. And she gave the staff what she gave the staff. Now they're asking for a second and sounds like even a third bite at the apple to continue to try to rehabilitate signatures. You know, no other candidate is provided that opportunity. You rejected my party challenge this morning because it was 7 days late. And now they're asking here 14, 23, or several weeks after the filing deadline to all of a sudden be allowed apparently an endless opportunity to rebut the staff's findings. The staff has the superior database here. They have the database on registered voters, far superior than any lawyer or private vendor in this state. They've done the analysis. I would also remind people that a number of the examples that we've heard here today, which I have not seen, that there is a rule of strict compliance here in terms of filling out these petitions. And so what may be characterized as innocent mistakes or otherwise run afoul of strict compliance. And I know the staff has applied that rule in its analysis. They've gone through this. This candidate has had 2 significant bites at the apple. She is short of signatures and should not be certified for the ballot.
Brief response. First of all, the challenge they filed was a pretty general blanket challenge that lacked specificity. We answered based on what they provided. We got the report on the 24th from the BOA. We got the detail of the report that supported their conclusions. And based on that, we were able to prepare the objections to that report and send them to you that show that in fact, she did beat the threshold. Things get missed. And again, I have nothing but respect for the BOA, but I think they missed a few things that we pointed out. The idea, you know, I believe it's all timely under these circumstances. I don't think there's anything that was untimely. When I'm asking for a third bite of the apple, I'm asking to the material that was sent before today's hearing that you have the opportunity to evaluate it if you haven't had that chance yet, especially if we're talking about 29, right now 29 votes, and there's another 46 facial challenges that have been pointed out on things like somebody writing down that they live on Georgia Street and they actually accidentally invert 2 letters. I don't know if that's a strict compliance issue is just opposed of, you know, somebody's running out of a grocery store, they're rushed, they're signing their petition and writing down their address and, you know, they invert a letter. I think things like that is something that you guys can consider and determine whether or not that meets substantially, you know, meets the requirement here that we can determine the address.
I know that Mr. Brewer is holding up his challenge, which in fact was exceedingly detailed.
There were 2 challenges and they were both detailed. Thousands of signatures were challenged and they chose to ignore that in their first response. And now here they are at this late hour begging for mercy. You have turned down candidates here today who came up a few signatures short on their petitions because the rule is strict compliance. This candidate deserves similar treatment to what you've been doing today. It's too bad that the candidate is short, but she is short and she's out of time.
I think we timely submitted the materials yesterday for today's review. If you haven't had a chance to review them, we just ask that you do before you make your motion and make a decision. I think that was the fairest thing, because if she in fact did get the appropriate number of signatures, and we believe she did, then that needs to be considered before a vote.
What? Sure. So in your exhibit 10, you list objections to alleged circulator errors, and you're calling into question about 12 sheets, give or take, that comprise 116 signatures, and you're disputing the terminations on some of those. So that seems to total 116 signatures.
No, we're saying 88 of those on 116, which I think if I understand it, these petitions those signatures weren't evaluated by the BOA because of what they thought were circulator errors. Okay. And we're saying we don't think on these particular petitions there's any circulator errors. There is, and out of that 116, 88 are in fact registered voters of the addresses listed according to the Grubner group and we produce his information there. Which
so I understood.
Okay.
So you're saying that those ones are valid?
Yes.
We've already talked about the voter registration. What's the number of additional signatures that you're claiming should be included based on facial errors?
I'll tell you, that's on, I think it's the last page of our document. Let me see here. It's 26. The total number that we come up with, including the facials, is 6,356. The 211 are the registered voters that we found, and then in addition to that, there is whatever this is the subtracting the numbers, that would be 26, 36, 40, 41, 45, 47 more. And right now, I'm told there's 29 short, but I can only hope that the Grubner material for what he identified as the registered voters is correct and was properly properly
Mr.
reviewed.
Grubner is not the.
Oh, no. Of course he's not. You guys are. You
Right,
are.
but
Absolutely.
we rely upon, I have respect for Mr. Grubner,
Yeah.
but the Bureau of Election staff has worked very hard
I'm
to
sure they have.
review every detail of the challenge and to review what is provided to us in any kind of timely fashion in rebuttal. And it's really impossible for us, when you come at this very late moment, for us to evaluate what you say you have provided.
Well, you're all I can say is that, like I said, given the fact that this is not a situation where there's a primary on this case in August. There is some time, and there has been cases where we've tabled something here to consider the material that you have in front of you. And I'm given the fact that we're talking about 29 votes, that you would
us to do something that Mr. Brewer asked us to do. His was with regard to perhaps a late challenge, and yours is a late response. But it puts us in an impossible position. And to say that because there's no primary, we should just keep going forward is something that we've already decided not to do.
Ask a question on the timeliness issue. What's the procedure in terms of this quote unquote deadline for responses to items as opposed to challenges? Because I think there's a difference there in terms of the timing. I'm just I don't have an opinion one way or the other. I'm just curious what that process is.
I don't think the board has a specific date or time that's set for information that campaigns submit that dispute the staff reports. Practically speaking, I mean, we need to have some time to actually evaluate them. And so in this case, I mean, I think what I'm trying to figure out is there something that's contained that would decide the issue that we could look at in the time we have available? And I'm just not sure that there is at this moment.
But if I understand, you're saying they're under the rules, you would have the time available to just look at that. I don't think it would take a lot of time, but we're talking 29 votes. And I think there's, if one accepts your determination of the registered voters, there's still 46 other facial issues that have been raised and have been documented and provided to you. And I would hope that would be looked at before a final motion is determined.
That this exhibit 4, something from Jeffrey Nielsen? Some affidavit?
Exhibit 4 is an affidavit regarding
Saying, okay,
about signatures that he knows that he got these signatures from these people at these times at these places. So that's his evidence.
These are signatures that have been invalidated by the Bureau. Is that correct?
Yes, I believe so.
I'm sorry?
I think yes, that they didn't match. And he's saying, well, actually, I got these signatures from these voters at this, at these times, at these dates, at these places.
That doesn't mean anything. I mean, he says, I got this at the Royal Oak Farmers Market. That doesn't make it valid. I mean, I'm just trying to,
I guess what I could say is we can't look at all these today. We can certainly review we could review. I was asking about these sheets where they say there were circular errors. So we could review those, and if we determine that there was not a circular error, we would still need to look up each signature.
Sure.
So that's not something we could do this afternoon.
So I'm not sure why, what are you suggesting, Mr. Brader, with regard to? I mean, this has to be done, right? I'm seeing a grimace on the face of our attorney who knows what our time label is, but this does not.
I think at this point, part of the issue is that I'm not sure we're going to be able to finish all these in the next 2 hours anyway.
Well, I'm not sure we should.
Question for you.
Yeah.
Jonathan or Mr. Brader,
You can say Jonathan, it's okay.
I know, but you had that look.
There.
So here's the deal. I mean, we're at item number 18 on an agenda with 32 pieces and 2 hours to go. And so my question to you is, what is the game? We kind of talked before about what the game plan is if we don't make it through today.
We'll have to come back. I mean, I think, so I guess what I would suggest at this point is tabling this one, at least to the end of today. We'll get through the rest of the petitions. We're going to revisit Saul and Kumar already. And then if we have time and we're able to review this, we'll review this at the end of the day today. If not, we're going to have to come back anyway. So I think that's what I would suggest at the moment, unless you have a better idea, Adam.
Mr. Brewer, does that work for you?
Madam Chair, if I may. Today, you have turned down pleas for mercy from candidates who said, if I could just have a few more days, I can bring you affidavits, I can rehabilitate signatures. You turned them down. You expressed concern for their dilemma, but you said no. Why is this candidate being granted an exception and being treated better than all these other candidates who said, if I have more time, I can rehabilitate? So this is not fair. This candidate has had more than enough opportunity to deal with the challenges, address the staff report, and now they're getting a third bite at the apple to try to rehabilitate their signatures. This is manifestly unfair to the rest of the candidates before the board.
This is not a third bite at the apple. This is material, I think, under the rules that was timely filed. And again, if there is going to be an adjournment because you're not going to get through the thing, we're just asking that you review what you have, that's in front of you, that we could only respond to and object to some of the stuff. We haven't seen all the signatures, for example. What you're saying is not mismatched. We don't exactly know what those are, but
you
the material that we have
had the opportunity in the past, and there has been the challenge was filed, I believe, by what date was it, Mr. Brewer?
April 30th.
April 30th. That was
30th. They've had a month.
No, we didn't know.
In a month.
We didn't know who the invalid signatures were until Tuesday.
But you could have asked.
We got the detail on Tuesday. That's when we asked for it. We got it on the 28th. And so in 48 hours, we prepared this response to these objections to the report for your consideration to say, hey, there's additional issues here that just need to be reviewed. And we're just asking that you review them. You have it, it's in front of you, the material's in front of you. I think these are valid objections that just need to be assessed. And if we're right, then she should be certified, which we think she should be.
By this affidavit from Mr. Nielsen, who says petition number 824, line 10. I do not have a specific recollection of the circumstances of obtaining this signature. Is this a response?
Can I speak? Because I'm Mr. Nelson. Yeah. I collected over 1,160 signatures for the candidate. To have 21. Okay. Yeah. Good afternoon, Mark. Hi. Thank you for allowing me to speak to this. I collected over 1,600 signatures for my wife. 21 signatures out of those over 1,600 were questioned as to validity. Some of the ones I remember the specific instances where I collected them, and it addresses the issue of genuineness of the signatures. I stood out at the Pleasant Ridge polling location on the presidential election day and collected 145 signatures. Many of those signatures whose genuineness is being questioned, I obtained them when they went in and voted. I was also at the Waterford Public Library during early voting. Number of those signatures were challenged. So I remember that they were going in to vote. So to have their signature disregarded when they were exercising the franchise, and I have a specific merit, is unjust. It's disenfranchisement. Elizabeth Hardy, a former member of the Wayne State Board of Governors, I got her election signature when she was going to vote at the last November election. I'd known her for 30 years. I think my word of knowing somebody who voted should mean something, both as an attorney, officer of the court, and otherwise. There are other signatures in there of people that I personally knew or events. I happen to have a decent memory, not as good as it once was, but a decent memory. And I remember the circumstances of when those signatures were being obtained. So I think as an officer of the court, my affidavit should count for something, particularly when out of 1,600 signatures, 21 are called into question. I didn't have to fabricate anything. And the same goes for other people who have signed affidavit. Elizabeth Lukenbach sits on the State Bar Judicial Qualifications Committee. I think she is an officer of a court and says that, yeah, my husband signed the petition, should count for something. And I think another attorney, Anthony Urbani, who's an officer of the court, says, yes, I was collecting signatures. My sister signed it. I think that has a high incidence of reliability. Yes, unfortunately, there were a couple of real bad apples among the circulators here. Most of them were not. But the fact of the matter is, I am not a bad circulator. I didn't have to fabricate anything. And there should be a very strong public policy inference that when someone goes out and gets 1,600 signatures that are matched up, except for 21, I think that affidavit should count for something and identifying that. And these are people that were known to me, or they were going in to vote, or they were in an event. I remember when I was at the Southfield Winter Festival. So these aren't being made up. And
no one is suggesting they're being made up.
I understand.
The question is whether this rehabilitates them.
Madam,
well,
yes.
Can if you have more, go ahead, but I have a
I can
comment.
answer your question first.
It's more a comment about the timing issue that Mr. Brewer has brought up, because I think the fairness issue is important. And I asked that question about a challenge versus response to various items.
This is a fundamental matter of due process.
Well,
we
let
had
me
no
finish.
idea until Tuesday, late morning. And let me say this. I think the election staff did a fabulous job. A fabulous job. They went through and basically rejected over 2,400 nonsense challenges that were set forth.
Well,
they were rejected. The point is,
Member Dawn has a question.
trying to help
He
you.
has the floor.
Thank you. Thank you.
So I looked through the items we've been through, because I was curious where we may have had a similar situation and said, nope, too bad, too late. And thus far, we've said, okay, we've got a little time, let's address this with Mr. Saul and Mr. Kumar. The other folks we've been through, there was not any issue of rehabilitation that was being attempted. These people were rejected for a variety of reasons, header, incorrect, not enough signatures, that type of thing. So my thinking would be, as this is a response, that we follow the path we've laid forward today. And if the Bureau, as Jonathan laid out, thinks we've got the time, let's review this last piece of it, then I don't think that flies in the face of what we've done thus far today. And I'm sympathetic to what Mr. Brewer is saying, but I think we have allowed some leeway for other people in similar situations.
Thank you. I'll make one final comment. Until Tuesday, when the very capable, highly cooperative Bureau of Election staff provided us their line-by-line assessment, that was the first instance where the campaign and its advisors had the opportunity to know what signatures, 700 of them, were being invalidated on the basis that they didn't match up. We didn't have the resources to go out and match up every signature. We became aware of that Tuesday morning, and we had to focus on registration. And that was the first time we had, from the preparation, not of a challenger, but from the official Bureau of Election staff, knew the report was very comprehensive. But that was the first time we knew what signatures weren't being counted because they weren't registered, or there was a facial error, or there was a problem that the signature didn't match up. And candidly, I think it's a fundamental denial of due process of law to strike a candidate from the ballot without being given adequate time to look in and provide rehabilitative evidence satisfactory to the Board of Canvassers, that out of these 700 signatures that were being invalidated, that we can't go out and get other exemplars from them to rehabilitate them to make up the shortfall that might exist based upon where these numbers are now. And I'm going to let the attorney, who's better than me, make further comments if necessary. Thank you.
No, we're going to table it.
I feel like we're spinning our wheels again on just going over the same thing over and over. I've stated where I am on this in terms of the timing issue. And I would think.
And I think the timing issue, let's be honest, when something is submitted to the Bureau at 4 o'clock, that means those of us on the board don't get it till closer to 8 or 9 o'clock last night. So I would probably go to whatever the decision of the Bureau would be of what they want to do with this one at this point.
Yeah,
I've been honestly looking through this challenge, and I'm looking at what is, well, these are here. What I'm seeing is what happens with every petition. You're standing out in front of a library, you're standing out wherever you are. People already have their mind on something else. You have put a petition in front of them. They hastily put their name on it. They hastily put their signature on a legal document. It is not the best handwriting. It is not in a form. And I'm looking at here, and I know that there are 3 of us who sat in 2022 and looked at actual dates, and we had someone tell us what the date was. But what I'm physically looking at, I have one I can't read because of the scan. It's really light. That's why I want to just, I'd rather just go to what the Bureau at this point wants with this one. Because you're talking about timing for you. I'm talking about timing for this board to actually look through this information. So, yeah, that's where I'm at.
Now, ordinarily, we rely upon the board to review the information, or the Bureau to review the information and make a recommendation to us. And that is the system that works. And when the Bureau is not timely provided information, and people come and expect the board to process information which is not timely presented to the Bureau, that puts us in a really difficult position.
That's why I'm saying I would like to yield to whatever the Bureau's decision is on this, so that we can move forward as we know where we are.
Mr. Brader, if we push this to the end of the line,
I think as a start, it would make sense to push this behind the other petitions so we can get through more of those. I think we are close to or almost completely done looking at the Kumar and Saul ones, so we could bring those back up. We can get through the remaining ones. It's possible we can give you at least more information at the end of the day today. And then the board can decide based on the information we have if they want to act on this one or not. I mean, the reality here is that this, we sometimes get a lot of information at the last minute. We can't always tell you everything about it. And that's the case here. We have not had time to analyze all this.
Madam Chair, can we just push this to the end?
Okay. Table agenda item 15.
Yeah.
While we look at other matters without making a decision about what we're going to do on 15.
Thank you very much.
We take a margarita break.
We are not.
Need a break.
Can we, if you want to, can we take a quick recess after the next one?
Yeah, no, I was just kidding.
Okay.
Unless somebody has a margarita.
Okay.
Okay.
You know what? We've got a couple of them here that
So,
should be pretty straight.
The next one should be
next-
very brief.
The next one is very short. Okay.
Yeah.
consideration of the sufficiency of the nominating petition submitted by Charles Longstreet II for the office of Third Circuit Court Judge, incumbent position. Director Brader, make it quick.
This
I know.
candidate didn't submit enough signatures. He informed us that he had been the victim of circulator fraud. So he doesn't have enough signatures, but it was too late for him to withdraw. So we do have to consider his petition, but we recommend deeming it insufficient.
Madam Chair, I'd like to make a motion that we move the board to accept the staff recommendation and find that the nominating petition filed by, hold on, right there, Charles Longstreet II is insufficient.
Now I'll second.
Okay, thank you.
Okay, all in favor?
Aye.
The motion carries. Do we want to do one more?
Yeah, I can do this one without Adam.
Consideration of the sufficiency of the nominating petition submitted by Nadine Renee Hatton for the office of Sixth Circuit Court Judge, non-incumbent position. Director Brader.
This candidate needed to submit 4,000 signatures that were valid for this office. She submitted 4,140. It was a very small cushion. After facial review was down to 4,043. We did get a challenge. We processed the challenge. And 128 were not registered. And for that and other reasons, she was under 4,000. So based on that, we recommend determining the petition insufficient.
Nobody has asked to speak to this. Do we have a motion?
Yeah. I'll move. Put my space here. I move that the board accept the staff recommendation and find the nominating petition filed by Nadine Renee Hatton insufficient.
All in favor?
Aye.
Aye. The motion carries. Do we need a break? Okay. I can see that Sarah Howard is anxious to do this one. So why don't we? Okay, so this is consideration of the sufficiency of the nominating petitions submitted by Angelique Camfield Kyper for the office of Ninth Circuit Court Judge, new judgeship. And Sarah Howard is appearing on behalf of Angelique Camfield.
I'll briefly summarize. So there's a challenge here. There were enough facially valid signatures. There's a challenge here that was based on two things. One, the fact that the candidate put, this is a new judgeship, but on some of them, the candidate put, sorry.
Family court.
Family court one. This, sorry, I had the wrong thing in front of me. So yeah, so one of the challenges, basically the challenge was there was not a district in the heading. But in this case, she was running for a new judgeship in the Ninth Circuit Court. There's no other relevant district there. Beyond what's already, so she wrote Ninth Circuit Judge as opposed to Circuit Judge, Ninth Circuit in the, by putting the 9 in the district. So we didn't view that as an issue that was missing required information. And then there was also a challenge that was based on the circulator putting an address other than where they're registered. It was a minor discrepancy, and in any case, it doesn't invalidate the signatures by the circulator in that case. So based on that, when we took those two out, there weren't enough questions to take the candidate under the limit. So we recommend finding the petition sufficient.
Good afternoon, Madam Chair. Thank you for hearing from me. I'll be brief. My name is Sarah Howard. I'm the attorney for Angelique Camfield. My client wanted to be here this afternoon, but she is still working in addition to running a campaign, so she had court herself this afternoon. We agree with the staff report that there's no validity. We feel to the vast majority of the challenges, and the remaining challenges aren't worth looking at because they don't take us out of the cushion that my client has when she submitted. So we would respectfully request that you accept the staff report and you determine the petition sufficient.
Questions from the board? Any questions for Director Brader? Do we have a motion?
I'll do it. I move that the board accept the staff recommendation and find the nominating petition filed by Angelique Camfield Kyper sufficient.
All in favor?
There we go.
Aye.
Aye.
The motion carries.
Thank you.
Thank you, Ms. Howard.
Want to do a couple more?
We're really on a roll, so let's go. Number 19. Yeah, consideration of the sufficiency of the nominating petition submitted by Jennifer Johnson for the office of 17th Circuit Court Judge, non-incumbent position. Director Brader?
Sure. So this one, just to warn you, may be more complex. I know we had some legal argument here, but this candidate had to submit 2,000 valid signatures. They submitted 2,197. After face review, we determined there was 2,146 facially valid signatures. There was a challenge that the main issue in the challenge was that in 641 of the signatures, the date of the signature was pre-written in someone else's hands. And the challenger argued that that's not allowed, that each person who signs it has to put the date in their own hand, that it can't be pre-filled. We disagreed with that. We don't believe that the statute of the board's practice has been to require that the date of the signature be pre-written in the signer's hands, just the signature. However, we did so based on that, there weren't enough being called into question to otherwise call it into question, so we didn't process the remaining ones, and we recommend terminate sufficient. We did get some additional argumentation on this, I think citing a case and arguing that actually the signature does need to be, or the date does need to be written by the signer's hand. So I think we may have a speaker on this. I'm not sure.
We do. Mitchell Zajac?
Good afternoon, board. My name is Mitch Zajac from Butzel Long. I'm an attorney, P number 82498. Here on behalf of the challenger, and I appreciate the good introduction.
Could you spell your name for the?
Yeah, absolutely. Mitch, M-I-T-C-H, last name Zajac, Z-A-J-A-C. So this challenge, plain and simply, hinges on statutory interpretation. And what does the meaning of the words of 544C say? And as was pointed out, the Court of Appeals requires interpretation to statutory meaning of the legislative intent on a question of strict compliance. And in this case, strict compliance is the issue. It's the language of the statute. It's very clear. It's very unambiguous. That says that the printed names and zip codes, they don't have to be in necessarily the person's hand. They can be issues with the printed name as well as the zip codes. However, the statute says the elector must write their name or must sign their name, must put their address and date their signature. Otherwise, as the statute says, the line is invalid and therefore can't be counted under 544C. As was pointed out, the Court of Appeals has addressed this issue in multiple occasions. Most recently, two cases, the Sutika, I knew I was going to struggle with that, versus Roscommon Clerk, as well as Schmidt versus Genesee County. In both of those cases, the court made it clear when the legislature says they want something done by the signer, it needs to be done by the signer. In the Roscommon case, it says MCL 168-554C plainly requires electors to personally affix their signature, street address, and date of signing of their signature in order for it to be valid. And in fact, the Board of Elections petition manual agrees. Page 37 and 38 says the signer must write the day, month, and year that they signed. And why? Should we listen to this legislative intent? Schmidt makes that issue clear. Absent this requirement, an accurate factual determination of the signatures might be impossible. And the court says it's reasonable to require the date to be written by the signer. This requirement directly eliminates serious potential for fraud. And the court goes on, where some circulators date and before and some circulators date after, this invites fraud. Imagine the board trying to manage duplicates when a campaign could be allowed to backdate every signature. And actually, we heard an issue of that earlier today. What's worse, it'd be impossible to determine which were legitimate and which were not. Or trying to enforce the requirements of a circulator certificate. Also, we heard about that today. it would be impossible to tell which were legitimate and which were not. Here, the circulators admit, in fact, that the signers did not date their signatures 641 times. There's affidavits that accompanied the response to the challenge to this effect. Plus, it's obvious. Some are computer typed, some have dates that have blank lines associated with those dates that are pre-written in, and some have identical handwriting to each and every line in the date column. So based on the law, based on the Court of Appeals interpretation, the instruction from the board in their manual and petition, admission and review of the 641 signatures, this board should find those signatures invalid and the number of signatures insufficient. I'm happy to answer any questions.
Or Director Brader, just to reiterate, position of elections is that there is no legal authority based on pretty much based on what's in 544C.
Well, I defer to the AG on the interpretation of 544C and the applicability of this court case to your determination. I will say, though, that the Bureau staff have not previously applied a requirement that the person who signs a nominating petition under 544C has to personally handwrite the date. I understand the manual says that the signer needs to write that, but that's meant, as I understand it, to mean they have to include it. Not that it can't be pre-written for them, but that it has to be included. The statute that specifically talks about in one's own hand, I think, is the recall 940 something, as opposed to 544C. But I do understand that there's an argument being made about this other case that may reference 544C as well. So our practice has been, and our understanding of the applicable laws has been, that having a pre-filled date for the signer is okay as long as the signer signs their own signature. But you know, just in light of the additional legal arguments, I just want to make sure that the AG's office doesn't want to add anything. Or Adam, either one of you.
Is my guess?
Thank you, Chair Hurwitz. So Director Bader is correct. So the two cases that our speaker referenced were both in connection with the recall statute, which does specifically state that the petition signer must affix their signature. So both of those decisions were in the context of that statute that very clearly requires the signer to affix their signature and date. So there really isn't any dispute in the recall context. The Schmidt case that he references, that was a 1983 decision, I think it is published. That one doesn't make any reference that I can recall to the 544C. So he also referenced the something like that.
Roscommon.
The Roscommon case, that's right. So that is an unpublished decision from 2017. That is also a recall petition case. So that same statute that says that you must, that there's affix your signature and the date. In that decision, at the end of the decision, it then sort of lumps in and makes a reference to the 554C, which is applicable here to nominating petitions, and then does suggest that that statute also requires the signer to affix the date. As Director Brader indicated, that's not how we have interpreted 544C in the nominating petition context, or probably in initiative petition context either. Neither of these decisions are binding. They weren't decisions as to us, and they're not binding precedent. So they're not, so they are out there. The recent decision that's unpublished does lump 544C into its discussion of the recall statute. I'm not sure it's persuasive in that respect, because it didn't seem to wrestle with language in 544C that I don't think is quite as, it certainly doesn't say affix, right? There's not a matching of language between the statutes. So, but there is an argument to be made under that unpublished decision that 544C also requires a petition signer to be the person who affixes their own date. These decisions, they're not binding. It's hard to say what would happen in
another case in front of the court. But it's not been the board's practice to reject signatures for this. So I think it is probably a decision that you can make to stick with board practice in the event that because these decisions are not really binding us to the court. But they are out there, and it does suggest that in the one case. I don't know how helpful that was, but here we are.
Us lawyers, we always circle. Just would like to respond to a couple of things. Of course, counsel is right. The first case does not reference 544C. The second case does, and the quote that I read comes from the Ross Common case, and it says very clearly, it's the intention of the legislature, we, the Court of Appeals, believe that those three items have to be in the signer's hand. And in whether or not there's the precedent of this board is, not my argument to make today, but the law is clear. And I'd also like to point out that this board in other reports is relying on unpublished cases. And in fact, I'll probably not get up. I'll be here for the next challenge as well. The basis for that challenge cited by the Board of Elections is in fact based on an unpublished case. So it's very instructive. It's clear to the point, and correct me if I'm wrong, counsel, but I don't believe there's another case that actually addresses this question. It appears no one has gone after the challenges we have here. So there isn't any direct precedent, but very clear, very instructive Court of Appeals opinion references that it has these three elements, including the date, must be in the signer's hand. And I would just point the board to the issues of potential fraud. And whether or not that occurred here, that's not what we've investigated, but the issue is it could have. We have a very hardworking candidate that came up, and there was an issue with interpretation, I believe, of the family language, and it caused issues with the date. Well, someone may intentionally game the system that way. If in fact, I instruct every signer to leave this date blank, I'll go back at the end and I'll sign it for you. We know these will be valid because the board doesn't say that we have to have you sign these. That potential exists, and it's a very real potential. And we've talked a lot about the environment today and how that could become a factor. So for those reasons, for the fact that there's clear instructive precedent, at least on this issue that addresses the statute in play, for the issues as I've addressed in the challenge in more detail, we'd ask that the board find these insufficient.
Do you have anyone else to speak?
Oh, no.
There's nobody from the Johnson campaign that wants to speak.
No, nobody has.
The case that you referenced, second case.
Yes.
Does it specifically mention dates?
Yes, the quote, and counsel can keep me honest here. The quote says, I quote, MCL 1685444C plainly requires electors to personally affix their signatures, street address, and dates of signing for the signature to be valid, end quote.
And that case arose in what context? Was it a recall? Is that what?
Yes. So the underlying issue is a recall case, and I forget offhand why they delved into the 544C section for a couple of instances throughout the case. At the end, as counsel said, last paragraph or two is where they make this very clear statement about the dates needing to be in the signer's hand.
But it sounds like that's dicta.
It's not. It's part of the case ruling. It's not a footnote or anything like this. It's part of the judge's ruling in this case.
But the interpretation of 544C was not an issue that was presented in the case.
Well, I don't know that we could say that. The opinion's not, 14 pages long or anything like this. They certainly reference it more than just this one time. Again, counsel can keep me honest on that, but there's more references than just this one out of the blue reference. They delve into relating the two statutes throughout the opinion. And then again, make this very clear statement about both statutes. And I care because 544C.
When it comes to nominating petitions, you're interpolating.
No, I mean, nominating petitions are expressly covered by 544C. And so for the court, yeah, I know you know, but for the court to say expressly 544C applies, there's no interpolation. It is, the statute means this, we, the Court of Appeals find.
They didn't want to address it, they wouldn't have said anything.
I agree.
If I may, I think, it's hard to say whether, the Roscommon case would have come to the same decision if it hadn't been addressing the recall statute. I think that's because it clearly sort of combined its analysis of the recall statute with 544C. So it's difficult to say whether it was just a nominating petition, whether the same decision would have come to, because you wouldn't have been looking at the recall statute at all, which requires the signer to affix their signature and their date. So it's hard to say. The other thing that's interesting is also in the Roscommon County case, it refers to the Families Against Incinerator Risk versus Haynes case, which then also concludes that you can use ditto marks for dates. So it's interesting. So what what I'm trying to articulate is it's difficult to say what an analysis would be. And we were just looking at 544C, and with the knowledge that a ditto mark can be included with not even a date and things like that. So I think we're still in the realm of, we can't clearly advise you, that your position is wrong because we don't have binding precedent.
If I may,
Thanks.
back to the strict compliance. I've heard obviously this mentioned a lot. The statute says the elector must. If the legislature didn't intend the elector to do something, it wouldn't have said the elector must do these three things. And so the Schmidt rationale for and then Roscommon interpreting it as the same rationale for why those three elements were required in the recall is because the legislature had the same kind of language. The elector, I believe it says signer differently in that statute, but they must do these three things. And so from this strict compliance perspective, and also from the clear legislative language, if the elector must do something, we can't interpret some sort of substantial compliance requirement to that. It must be those three things, as the legislature said.
I would just note again that, so this language that we're looking at, it's not a must really. It's if an elector does not include his or her signature, his or her street address or rural route, or the date of signing on the petition is required under subsection 1, the elector's signature is invalid. I don't read that language as necessarily saying only the signer can affix the date. But that's essentially what his argument is, and it is what the unpublished decision also suggested as well. But if you look at, it's not clear to me that that's exactly what that language has to mean.
It's not clear that that's the intent of what they meant.
And it's not clear that another court would agree, right? These aren't binding. A court could find this persuasive. Another court could say, well, that was in the context of a recall case. So
What section are you reading?
it's 544C subsection 2. And it's at the end of 2.
Okay.
And so the front half of that section sort of lets you know when an error or mistake won't be counted against the signature. And then that last sentence says, these are the things that would invalidate a signature. But it certainly doesn't have language like the recall statute says affix, right? It doesn't have that.
But to be clear, it does say if the elector does not do something, the signature will be invalid.
It doesn't include his or her signature. It doesn't say write, or I mean, you have to write your signature, but
I don't know who else can
what does
include it for the elector, but for the elector, I guess is, in this case, it goes into many details about 544. It does just speak about fraud issues. I think that has to be a consideration. Again, not saying that occurred here, but if we change the law from what it's written, it opens the door very clearly. If anyone can write the date for the circulator and for the campaign, that means, practically speaking, the circulator can get a bunch of signatures at any point in time. And then the other part of the statute, which requires circulators sign after the collection of signatures, is superfluous. it means nothing because this, in that case,
They can make it whatever they want.
they can pick the date. It opens the door to Pandora's box. I think much further than this board would like to see, especially because of the many issues of fraud and forgery that we've been discussing today and our last go around with the Johnson case in particular.
Question for Mr. Brader. Would interpreting this so that the elector is not, does not have to put in the date, would that also have kind of a zipper effect that the elector doesn't have to put in the city or the township or the address? I mean, it's not just really the date we're talking about here, is it? It's anything other than the name and the signature?
Yeah, that's how we've interpreted it, is that the only thing that the signer has to actually include is their signature. The other things can be written by somebody else for them.
Here's where I think I am. Yeah, I don't know where I am. We've spent a tremendous amount of time talking about fraud, potential fraud over the last 6 hours, but also the last several years. And I understand the position of the previous, the process or the practice is to allow this. I think Mr. Brader's last answer kind of pushed me over the edge. Not anything that he did, not over the edge like I'm gonna go crazy, but just like kind of helped my decision making. We're worried about fraud, and one of the key things that people look for is consistent type of handwriting or evidence of round tabling. If you've got, whether it's one of these fields or two of these fields or three, all in the same handwriting, that's going to draw your attention. You go, oh, this is fraud. So you could have two adverse effects. One is it's bringing into question valid signatures as potentially fraudulent. The other is it could be making it easier for bad actors to commit fraud because they're only having to fake handwriting in one instance or two instances of the signature. So I think given this has been brought to our attention, it makes sense to follow the challenge and deem these insufficient, but that's, I'm open to continued discussion on this, but that's where I'm coming down on this.
Just one other thing. I mean, I understand that, and I'm not unsympathetic to that concern. The other effect of that will be, like, for example, husband and wife, somebody fills out both lines, signs it, and then gives it to their spouse, and then the spouse signs it. We're going to have to invalidate one of those, I guess. So there's going to be other effects too, if that's the principle we apply. But I understand what you're saying in terms of the fraud concern. Yeah,
I think it might be easier, as Member Daunt suggests, to evaluate whether there's fraud if you're insisting that every part of the petition form signed by the elector is in the elector's own handwriting, but that isn't what it says. And this section is not a model of clarity. I think you would agree.
That's why I'm here.
Zajac.
Yeah.
But the only thing that it specifically requires of the elector is that they sign the petition. And that section 2. So to the extent that that's the beginning of the section, the petition must be in a form providing a space for the circulator and each elector who signs the petition to print his or her name. So they want everybody who signs to also be able to print their name, although it doesn't say that they have to print the name. It just says there has to be a space.
Madam Chair, in fact, that statute says they don't have to print their name.
Sorry?
That statute actually says they don't have to be the ones that print their name. Later on, it makes clear that printing your name and
It goes on.
Right.
And it goes on in a couple of different
That's right.
ways.
That's right.
The secretary shall prescribe the location of the space for the printed name. The failure of the elector who signs the petition to print his or her name, to print the zip code, or the correct zip code does not affect the validity of the signature.
That's right. So if I may, the legislator took an active step to say, if you don't do these two things, it's still okay. But
Right.
they knew the other three things were still requirements. So again, legislative intent, if they wanted everything to not matter but the signature, they should have said all four things don't matter except the signature. And actually, if I may, one more time, I don't read this statute anywhere to say the signer must sign, which is kind of counterintuitive. But that statute or that portion of the statute that I pointed to is the only thing that suggests that the signer must be the one who signs their name. Nowhere else does it say the signer must sign or the signer must affix. Nothing like this. The closest is if the signer does not put this, if the elector does not have the signature, the date and the address in their own hand, invalidity applies. So again, there's no, that's the most direct instruction in the legislative history of this statute. And the legislative could have said expressly, we don't mind if these other things are done. They only did that for two things. The other three things remain.
One thing we've learned about election law is that it is not always expressed as clearly as we might hope. Member Daunt would like to point out that attorneys are always finding something that's unclear and something to argue about. But so the last sentence, which is the one upon which you're relying, if an elector does not include his or her signature, his or her street address or rural route or the date of signing, the elector's signature is invalid. But as Ms. Meingas pointed out, that does not necessarily say it says it has to be included, but not that the elector is the one who has to include it. So I don't find it particularly clarifying to try to pick this apart. And my inclination would be to rely upon the practice that the Bureau and the board presumably have been following for some period of time, and not throw another monkey wrench into it, as Director Brader suggests could occur if we start requiring everything to be in the hand of the elector.
Another question for you. This one might
Yes,
be
sir.
a little bit of a one-off. The bulk of the challenge, 641 signatures, is premised on the allegation that the signature dates on the petition sheet lines were completed by non-signers. So that's an allegation. Where's that coming from?
Yeah, there's clear evidence in the exhibits, and I attached it and actually a couple of screenshots in both the comments as well as the exhibits. The exhibit to the challenge itself had every single signature and every single 40 of the 49 petitions attached to it, showing three different key things. One, in some instances, it's typed in. So it's, computer writing. It's not even handwriting. It's printed, pre-printed in the form or post-printed, I suppose. It's printed from a computer or a typewriter of some kind. In other instances, there are examples where only half a petition sheet is completed, yet all of the dates are completed all by the same handwriting. In other instances, they're all the same handwriting, and it's kind of a hodgepodge combination of all of those. So we provided highlights and showed exactly where those kind of three main issues popped up. And that's the case for all 49 petitions. And I believe the most persuasive point of that is the candidate, as well, the respondent, I should say, as well as the affidavits attached to the challenge response, admitted that's what they did. So it's really not a question of did it happen. It's just a question of what does the law say is allowed to happen. And I think it's very, very clear the way that the legislature said include, when they said include signature, that must mean the signer is the person who writes their signature. Because if we interpret that not to mean this, it kind of means that anybody can sign. And we know that's not what we want. So thank you for the question.
I decided anything with December branch.
Would it make Can we take a,
Yeah, why don't we?
can we take a break and then, and like make the vote?
Right.
Is that okay?
Yes.
Okay.
Yeah.
Or we can do it now.
The brand is.
Why don't we take a break?
Are we taking a break?
Yeah.
Sorry, I started a trend.
Let me take a stab at this one, and say that because our counsel has said that the law does not clearly provide that the date has to be written by the elector, and because the practice of the board has been not to require the date to be in the handwriting of the elector, I move that the board accept the staff recommendation and find the nominating petition filed by Jennifer Johnson to be sufficient.
I'll support.
Okay. Further discussion?
I kind of already said it. I understand the issue of this having been practice up till now. But
Clean up the process.
we're, you know, if something's brought to, you know, to my attention and it's a method that I'm like, oh, that doesn't make sense, we should correct that. I don't feel comfortable saying, well, we've been doing it this way, we should keep doing it this way until like the next time. So for that reason, this is a tough call. But ultimately, I think the discussion we've had and the issue of fraud and similar handwriting pushes me to a no. So I'm just laying out kind of my reasoning.
Mr. Brader, your comments about, you know, negating husband, wife, one signing for both, or one filling information out for both, or one filling it out for a child or whatever. No, child's probably not right. Yeah, well, at my age, you know, the kids are all voting age.
Oh, I see. An adult child.
I fill out for the grandkids, they voting age. Well, but the point being is that certainly is a consideration, but in the same token, as we're moving ahead here, we're trying to figure out how to, in an age when this is getting easier to commit fraud, we're trying to figure out how to tighten it down. And it just seems like if there wasn't a court case in place here, if it wasn't in the statute the way it's written, and if I trust you two ladies are both going to vote yes, you'll vote aye.
Yeah.
I'm guessing you will. If this deadlocks,
If it deadlocks, the candidate doesn't go on the ballot unless.
and the candidate's option then is to go to court and get the court to interpret it.
Right. If she chooses to do so.
Say again, sir?
If she chooses to do so.
Correct.
No, she's not here, so. But yeah, she would, to get on the ballot, she would need to file a lawsuit if the board deadlocks.
Madam Chair, I have one more good example that may tip the scale in general. We talked about duplicates earlier, and we talked about the circulator having a time of signing issue. Imagine a world where the candidate wants to be the first duplicate, right? Because the first duplicate stays and everybody else gets knocked off. Imagine a world where they say, okay, don't have the dates applied. We're going to apply it at the earliest possible date of circulation. That is a real world. That is a real world that will happen for desperate candidates to get on the ballot to beat their competitors in hardworking situations and money is an issue situations. How do we game the system? You game the system now if we don't implement this by not dating, not having the signer date, and then having the earliest possible date applied by somebody else who sees the big picture, the campaign office, the paid money makers who are circulating petitions, whatever. Somebody who has an incentive to get the most valid signatures will game the system by undating or not dating and then backdating to the earliest possible date to beat any duplicate challenge in the future.
Creative.
But real.
Right, but true, right. Sneaky, like.
I think we need to vote on this foregone conclusion.
Yeah.
Unless I've persuaded one of the two ladies.
You have to say all in favor.
Okay, yeah,
There you go.
okay. Okay, so it's been moved and seconded to accept the staff recommendation. All in favor? Aye.
Aye.
Opposed?
Nay.
Hey,
Okay, so we deadlocked and Jennifer Jensen is left to her devices.
Go ahead, Adam.
Can I just clarify? I want to make sure, the motion was to accept the staff recommendation. Got it. Okay, thank you.
We deadlocked, right?
I wanted to make sure I was making it.
Don't go away, Mr. Zajac, you're next.
I'm not going anywhere.
Okay. The next one, number 20, consideration of the sufficiency of the nominating petition submitted by Julia Kelly for the office of 17th Circuit Court Judge, non-incumbent position.
So I'm going to request that we do this quickly, if possible. We have, and then I would suggest we go back to Saul and Kumar, do those, and then get through as many as we can of the remaining. But the Kelly issue involved two things. So she had to submit 2,000 signatures. She had 2435 that were facially valid. We got a challenge that was based on a couple of things. One was challenging the fact that she wrote family court on the petition, which is extraneous. The family court is, or the family division is not something that is required. And you don't really know whether it's going to be the family division, but she's actually running for circuit court. The other issue were some allegations of illegal activity that was based on a picture that was taken that appeared to show some signatures that were taken before the heading was filled out. So so I guess I'll take the family division thing first. We looked at this as excess information that was not accurate, but because it was excess information, it was not information that would result in invalidation. So she did need to write circuit court. She did need to write that part. Family division was not necessary. It was extraneous, but we didn't think it was extraneous in a way that would cause a slotting issue on the ballot or make it so that voters didn't know that they were filling out something for circuit court. It was somewhat similar, we thought, to the issue involving Tudor Dixon in 2022, where she had put a term end date on there that I think was technically not accurate, but we decided, we recommended that didn't matter. It was extraneous information, and she did go on the ballot. And then the other issue was just involving the photo, basically of the blank header. We didn't think that there was enough evidence just based on that one photo to assume that additional petitions were improperly gathered. And even if we threw out that one page, assuming that it was improperly gathered, that wouldn't have been enough to knock her off. So those were the challenges. But based on that, there weren't enough remaining in question. And so we recommend determining the petition to be sufficient.
Thank you again, Mitch Zajac, MITCH, ZAJAC from Butzel, P82498, on behalf of Ms. Mollegraf. Yes, the two issues are one of improper heading and one of improper circulation. The statute makes very clear if the candidate is involved in improper circulation, that an opportunity or an action of disqualification is warranted. There's pictures of a circulated petition with signatures, clearly shows, and this is attached both to our comments as well as to our challenge, clearly shows the number of the petition, the names on the petition of some that have already signed the petition, I think 7 total, and a blank heading. And then later, the filed version shows, again, those same 7 entries with a heading included and 3 additional signatures applied. And so that's the first issue. The second issue with the heading is an issue of strict compliance. To address very quickly, and then I'll get into my spiel. The term end date issue is very different than this issue, as are the 2 cases. One, an unpublished opinion related to a section of the statute that has ballot initiative language. A separate statute does not apply to 544C. And then the other issue dealing with the raise the wage issue versus Board of Commissioners, where the court talks about adding a stamp. The circulating company adds a stamp, and there's some specific language that the court uses. Again, doesn't apply to our issue here. So as the first point, as briefly mentioned in the staff report, the candidate knowingly circulated at least one petition, and this is a candidate for judge, in violation of MCL 168-544C, which warrants disqualification under subsection 11, subsection B. If the board is not willing to disqualify the candidate for this reason, the board must follow strict compliance as it relates to the header issue and invalidate 478 signatures, which is above the cushion stated in the staff report. The court in Delaney is clear. It's a case cited in the materials provided. The doctrine of substantial compliance is not applicable to the mandatory portions of the header that are identified in 544C: name, address, and title of office. The challenge presents issues where the name of the candidate is illegible. There we go. Illegible such that a person in the public signing a petition doesn't even know the petition they're signing for. The challenge also puts forward the referenced family division challenge, which is an incorrect and non-existent title of office. And there's been some discussion on the Facebook, actually, I saw this morning, where there's a candidate supporter very excited that her candidate will be the next family law judge, and that's just not accurate. So this is the easiest of the issues to address under the substantial compliance doctrine. The 478 signatures bring the candidate below the 428 cushion. The staff report relies incorrectly on the community to ban fracking in Michigan versus Secretary of State case. This case has no relation to strict compliance under 544C. The issue in ban fracking is whether an initiative date, so a very separate statute, 471, 168, 471, whether this initiative date was required under the law. And the court in that decision said under 471, there's no mandatory language that addresses the end of the date at which an initiative will be placed on the ballot. And the court found that in its ruling. But here, the courts have decided strict compliance applies. Strict compliance is required under Christensen, one of the cases I cited, Stand Up, Delaney, as well as Aiello, which I'll get into more detail about here briefly. The statute, as well as Appendix B of the Judicial Manual, all have clear language about the potential offices for title. Family division is not one of those offices. The staff report also relies on Raise the Wage versus the Board of State Canvassers incorrectly. In that case, the court said, as to the label included in the heading, they said, quote, it is neither expressly or implicitly precluded from inclusion. Here, the statute of 544C expressly precludes any title of office other than the options listed in the statute and in Appendix B of the board's judicial manual. So whether the statute either expressly or implicitly precludes something is flexible when there is no language. Here, the law is strict compliance must be applied because of the mandatory language of the statute. The staff report we'll see later today in the Rugello challenge cites the Lyons case, and it's for nominating petitions. The case stands for the proposition that nominating petitions are valid, and this is a quote, valid only if they clearly indicate which office is being filed for. The judicial manual at page 7 says the same thing. Any petition sheets filed by candidates using improper designations are invalid. So the 49 petitions listing 478 signatures under the incorrect and, as we see, misleading family division designation are invalid. There is no family division. Very briefly, imagine a scenario in my home county where our chief judge was age limited and he didn't run for office. I decide through coercion of my friends, which I probably wouldn't do, to run for office, and I place chief judge on the petition. It's misleading. I would be telling members of the public that are signing my petitions, I'm running for chief judge, and that should not be allowed. I would not do that because it's against the statute. So for those reasons, and again, rely on the other elements for improper name, improper designation of office in the papers that were submitted for the proposition, as Board Member Bradshaw, you said earlier, we're here operating under strict compliance. Strict compliance means that each item of the form must be correct. If it doesn't meet the form, and then it does not get applied. And Chairwoman, you said we're bound by the judicial interpretation. We're bound by the judicial decision. Those 4 cases I mentioned very clearly indicates strict compliance applies. To allow a misleading title of office would undo that strict compliance guidance.
Thank you, Mr. Sajak. Do we have questions? Mistaken sheet. Any questions for Mr. Brader, for Mr. Zajac? Got a pretty long staff report here, which recommends finding sufficiency, advising that the inclusion of family law, family court is not disqualifying.
And Madam Chair, I didn't point out, if I may, really quickly, the basis for that recommendation was on those two unrelated cases. So one case that doesn't even apply the same statute, and another case that has clear, and the court said, there's no language that says you can do it or not do it. So there is actually no support in the staff report for this family division reference. And so I would just like to highlight that for the board.
You know, the strict compliance, I mean, we're all on board with that. But I have to tell you, some of the things you're looking at here is strict compliance. The way she wrote her name, the description of the office. You haven't sold me on this one.
So
and by the way, I'll qualify with you. I don't think there's anyone here from Kelly's campaign there's no one here to support her. Is that correct? But when I read the document that was written refuting your challenge, I lean more that way.
If I may, that's why I only spent my 5 minutes speaking of the family division. Of course, whether or not it's a scribble in court or a scribble in non, of course, reasonable minds will differ on this. However, that's why I spent all the time speaking about only the 478 signatures, which are sufficient to knock us below the cushion, because I think that is the clearest issue for without further asking our very busy friends at the Board of Elections to do more. I'm not asking for that. What I'm pointing at is a very clear, as it's written, no interpretation required in terms of what's there. Just to say strict compliance says you can't write that, not whether it's scribbly or something else. So I would just like to point you to that's why I didn't waste our time.
You know, I know, and I get that part, but I also, on this knife blade of strict compliance, there's also just simple humanity. And sometimes that's a tough one, right?
Absolutely. Which I think is important because this Facebook post I mentioned, it's a woman very excited about the potential candidate being the family law judge. I understand the candidate's a very successful family law attorney. So there, interest in drawing up the elector's support for this position of being family law judge, but that's not what the office is. There's 5 open seats. Any one of those 5 could be the family law judge after it's all shaken out and the chief judge makes their decision. So I very much appreciate and respect the humanity aspect. I think we're misleading voters if we allow for extraneous, really campaigning materials to be inside of our very important election petition documents.
There's from where we sit, we're not here to try to come up with reasons to kill petitions, okay? I think if we're going to err, we're going to try to err on the side of encouraging people to get the petitions done right always, but we're also going to try to help them get those petitions through. I had a particular issue with the last one and voted nay, and that was because I was afraid it was setting something that was going to go further. I don't feel that here. I think you've pointed out a lot of items, but I think that a lot of these are items that are simply somebody trying to legitimately circulate petitions.
I understand that. There's actually cases, one of the cases I cited addresses not the name or not the office, but the address issue. The court examined a situation where a candidate put just the name or the number of their street address and a few letters of the street name. And they said, that's not strict compliance. They had the office right. They had the name right. All those issues were fine, but they had all those clear things that people care about when they're voting. Nobody cares really about the candidate's address other than to make sure they're within the district. But voters don't look at that. They look at what's the name and what's the position. one of those key elements that voters look at was not done correctly. And the court has found a less significant, but referenced the same in the statute, a less significant item was not complying strictly, and therefore was enough to remove the candidate from the ballot. So I totally agree on the humanity piece and the encouraging piece. I was once an elected official. I will never do that again. But I am here, advocating now under the rule of law, which is strict compliance is required on those. It's 4 items, but I'm only referencing 3, one being the name, one being the title of office, and I referenced the address. So strict compliance is the rule, unfortunately, or fortunately, to ensure that the voters are well informed, so that I can't write chief judge in my election papers and try to drum up more support. So I think it's a matter of following the law that's important here.
Mr. Brader, you see things a little differently.
Well, I mean, the court is the circuit court. So that's the office that she has to include. She has to include circuit court, or, for a court of appeals, district court. She did that. It's true that I agree that it's not really accurate to say family division, because we don't know. Nobody knows what division she's going to be assigned to. Apparently that's up to the judge or to the court, which I learned recently. Good to know. But so we don't really know that, whether that's accurate or not. But the statutory requirement is to include the court that she's running for, which we think she did by writing circuit court. So we think the additional information, although not accurate, is also extraneous and not incorrectly listing the office that she's running for.
Would this be analogous to an example like from 2 years ago? I think it was Tom Barrett had put too much info in the address line. Is this analogous to that? Because on one hand, I think it is, because it was extra information that's not truly strict compliance, but we determine practice allows it. On the other hand, they're both correct pieces of his address, and this is like a speculation piece, the family court division.
Yeah, so what you're in the Tom Barrett petition, if I'm remembering correctly, he included both his mailing address, his post office city, and the specific township. So it was like a Lansing, and then in parentheses Delta Township, like that idea. I think what's even more analogous from 2022 though is with Tudor Dixon. She included the term of office on there. Statute doesn't require the term of office at the top of a petition for a gubernatorial candidate. And not only was it included, but it was also wrong. And our recommendation there was the same as it is here, that it's extraneous information.
But unfortunately, it has a misleading effect, though. And the ILO case talks about that. And it says that the intention of this language is to inform the voter. And also, respectfully, the term of date, it really applies to that miscited case in the staff report, which has nothing to do with 544C. The case referencing, if I may just flip to it, the case referencing ban fracking. It says that the date is a date issue, and the initiative language under 471 does not have a requirement for date. That's true, and that's clear, and the court agreed. However, under 544, there is a requirement for name of office. So adding the extra information was fine, or not actually adding the wrong information was fine in ban fracking. Here, the court says or the statute says you have to list those available positions, whether it's a full-term incumbent, full-term partial, or I'm sorry, non-incumbent partial, non-incumbent regular, 5 options. Those are your 5 options. And this is a 6th option, adding a different title of office to the petition. Does not follow the date issue because there's no reference and requirement for date. There is a requirement for office. Does not follow the initiative language. Again, different rule. There is a requirement for office here. And it does not follow the second case cited under raise the wage, because again, the statute is silent on this issue of can you apply?
Madam Chair, can I just make the motion so we can go to a discussion of the board members? Yes. Is that okay here? I know.
Draw set.
we just hear it. It's just, we got it. I move that the board accept the staff recommendation and find the nominating petition filed by Julia Kelly sufficient.
Support.
All in favor?
Aye.
Aye.
Thank you. So Chair, we're prepared to revisit Saul and Kumar, and I would like to try to get those done.
Okay.
We only have 30 minutes. They've been waiting. And then perhaps we can maybe get a couple more done, especially if people have come a long way today. So they don't have to do that again on Monday. But so with Saul, we've revisited this. So as you recall, we talked about the first district issue. It seemed like the board did not think that was a reason to disqualify. So we did go back and do a face review and process the challenge. After the face review, we had 1,156 that were facially valid. So we processed the challenge. We accepted 101 of the challenges, rejected 171. So that did leave Saul with 1,055 valid. So we would recommend, assuming you're comfortable with the first district thing, we would recommend finding the petition sufficient.
I'm not going to argue against that.
You were an eloquent advocate. Do we have a motion? We discussed this. What do we?
No, is it, we're saying that the new staff report is sufficient?
What I would recommend, if I may, your motion should say that you would reject the staff report and find the candidates sufficient if you are going to go with the updated numbers that Director Brader just read.
Thank you. Yeah, I'll do it. I move that the board reject the staff recommendation and find the nominating petition by Josh Saul sufficient.
I'll support.
All in favor?
Aye.
Thank you all very much. I appreciate it.
Okay, so now we also are ready to go back to the Kumar one. We did get those additional registrations, questions to look up. We did look them all up and we have an updated number, and I will just defer to Adam on that.
All right, so I went through the Excel sheet that was provided. Most everyone that was in here was something we had already received and had processed. So I want to start first with the, it's on the Excel sheet provided. It starts on the third page, sheets number 3 through 198. Every one of these is marked in the column. It says BOE error code, and then it says an R. I have confirmed that every single one of those was we confirmed those are registered voters. We did not reject those signatures, and we have not rejected those. Those were part of the original staff report, counted as registered voters. As far as the first 2.5 pages of the Excel sheets, we had already looked at all of them except for 25. There were 25 additions that were provided. With the exception of 4, the affidavits that are also provided are also included in this as well. So it brought it to a total of 51, if I have counted correctly. And a couple of things. So first, the affidavits are all to signatures that we coded initially as an invalid signature for determining that it doesn't match. And then the second, the remainder are primarily coding for not registered. There were only, as far as the not registered goes, there were a little bit fewer, but still part of that 51. I did flip 7 back. That was coded improperly. So I gave 7 back to Kumar. The remainder, though, are all I didn't change anything other than 7. Long story short, I gave 7 back. All of the not registereds that I looked up, I either looked them up or now or before, they are not registered in the jurisdiction at the petition. Several of them would write the jurisdiction on the petition was incorrect from how they are registered to vote, and that includes how it was provided here. So for example, the address provided in voter registration would say Utica, and on the petition, I'm sorry, the address provided, it says Shelby Township, and the address on the petition is listed in Utica. That's an invalid signature, encoded as not registered. So all in all, before we get to even determining whether or not any of the signatures actually do match, I did not go back through and double check. We have already looked at the signatures and coded them once and determined that they did not match once. Even if I were to flip every single one, the candidate would still be under. Right now, I have the candidate down by -43. If you presume that every single one of these is valid, and that would put the candidate at -17.
So the net effect, you made the effort to go the last mile and verify all the information, and we still come up negative. Your determination is still valid.
I would agree with that. And then I would also add that what I would want to do, we have affidavits. I will say that some of the signatures do not match still between the affidavit and the petition and QVF. There's still issues with that. So you may even still reject some of those. I am just presuming that everything in here is 100% valid. I have not verified these.
Even if it's 100% valid, we're still short.
Still under. That is correct.
And so to fine point, there's no chance with the information at hand that we could continue to get closer to certification. It could only go backwards because you're presuming. Okay, thank you.
Because I am just presuming at this point, the rest are that I would flip the rest.
If that's the case, then what I'd like to do is to make a motion. Is that okay? I move that the board accept the staff recommendation and find the nominating petition. Let me get it right here. Filed by Anil Kumar insufficient.
All in favor?
Aye.
Aye.
Aye, thank you.
So we have about 23 minutes before we get kicked out. I'm hopeful that we can get through all the quick ones. And so we minimize the number of people who have to come back on Monday. Apologies to the regular team. I think we're gonna need more than 23 minutes to talk about that one. But the next 5, I'm hoping will not take very long. So the next one is Burnell. The issue in that was a challenge to the fact that the candidate it's a new judgeship and the candidate put non-incumbent. We feel sort of similar to the Kelly one. We view this as extraneous, but not extraneous information, but not information that violates the statute requirement in a way that we would determine insufficiency. I mean, of course, any new judgeship is going to be a non-incumbent position because it's a brand new judgeship. So technically non-incumbent isn't accurate, but we don't think that that's inaccurate in a way that would render it invalid. Yeah, go ahead, Adam. Just go ahead.
Just to be clear, the candidate put both non-incumbent and new judgeship on there.
They needed to put new judgeship.
Yes.
They did not need to put non-incumbent.
Nobody has asked to speak to this. Do we have any questions for Director Brader?
Thank you for that clarification because I was gonna say that's a no-go. So thank you.
Do we have a motion?
We do. Get my paper out here. I move that the board accept the staff recommendation and find the nominating petition filed by Alice Burnell sufficient.
Or
All in favor?
Aye.
Aye. Motion carries. Excuse me, Hugh Woodrow.
Thank you, Chair Growitz. So this candidate, we found 0 valid signatures for the reason that the petition had to have the primary date on there, and it had the date as November 5th, 2024 as a general election. So based on the fact that the statute requires listing the primary election under case law as well, ALO, and our interpretation of the statute, we found that these were all invalid and needed to be rejected. So based on that, we would determine the petition insufficient.
And we have a request to speak to that.
You. Good afternoon. Thank you for giving me the time to speak. My name is Hugh Woodrow.
And your.
Is that better?
Spell your name. for the
Okay. My name is Hugh Woodrow. First name is Hugh. Last name is Woodrow, Woodrow. I've been sitting here all day just like everybody else, and I appreciate all the time and effort everyone's put into this. And I've heard a ton and a lot about the strict compliance, and I am in favor of that. I do have a question for you though. If I was put on this ballot, for what election would I be on the ballot for? The answer is November 5th, 2024. There is no primary election for this seat that I am seeking. There isn't one. There is no election in August for this position of judgeship that I'm running for. Therefore, if you want to follow strict compliance, then the information I put on my nominating petition was spot on. Because if I had put the date of the primary election on there, that would have been misinforming and deceitful to the voters, because they would have showed up in October or in August to vote for me. And guess what? My name wouldn't have been on that ballot because there's no primary election for my position. If I get validated, if my signatures are approved and my nominating petitions are approved and I get put on this ballot, I'll be put on the election in the general election for November 5th, 2024. So you want to follow strict compliance, then I followed it. There is no primary election for me.
Director Britter?
Well, so the statute requires putting the date of the primary on there. We don't know, when the petitions are getting circulated, it's impossible to know whether there's gonna be a primary or not, because it depends on how many people file for office. So we don't know that while they're going out. But in any case, the statute refers to the date of the primary. The yellow case, I think, is right on point. Correct me if I'm wrong, but I think it's pretty straightforward. Then just the fact that there didn't end up being a primary based on the number of petition people that filed doesn't retroactively allow you to omit the date of the primary.
I disagree. The case that you cite in your report, Ayla versus Sabaw, that is regarding a case where there's for a partisan position where there has to be a primary. There is a primary. There isn't one in my case. Whether there may be or may not be is irrelevant. The fact of the matter is there will be no primary election for the candidacy that I'm seeking. I put in the proper date.
May I ask to speak?
Yes. Yes, you have also asked to speak.
I compliment Mr. Grader on his concise example. The reality of the situation is that you put it down for the primary election. That's what the form says. What the statute says is that after the certification of candidates, there are less than twice the number of seats to be elected, then there is no primary and the candidates are automatically switched over to November. You concisely said that at the time you're circulating these petitions, you don't know. But more fundamentally, and I compliment the staff of the Bureau of Elections for putting out this very comprehensive how not to screw up getting on the ballot. And there's actually an exhibit that talks about one of the ways you can mess it up is to not put the primary date on the petition. He failed to do so. In the interest of brevity, I think you've got it right. Thank you.
I don't know who this gentleman is or why he's
I
opposing.
represent the complainant in the matter. Sorry.
Again, I still think if you're following the strict compliance, I did that. There is no primary election for this particular position. Therefore, what I put on that petition, the date that I put down there is 100% accurate. I don't know how you can go around that.
At the time you started circulating, you didn't know whether there would be a primary, isn't that true?
But that's irrelevant. That's completely irrelevant because there is no primary. I agree with you. If 15 people put in petitions for this job and there was a primary election, I'd probably be out of luck. Because I put the wrong date of the election that my name is going to appear on the position, on the petition or on the ballot for. But that's not what happened here. And again, we're talking about Tuscola County. We're not talking about Wayne County or Oakland County where there's 5 million people. Everybody in Tuscola County knows what everyone in Tuscola County is doing. We all knew that nobody else was running against Ms. Gerhart for this position except for me. But regardless, whether I knew or didn't know, and we've heard from a lot of people here said, well, I didn't know I was supposed to do that, or I didn't know I was supposed to do that. And your response was, that's too bad that you didn't know. We still have to follow strict compliance. Well, I didn't know if there's going to be a primary or not. I agree with that. But the fact of the matter is there isn't one.
But on the form, it says primary election.
I understand that. So if I put that date on there, if I put that date on there,
in August.
but if I put that date on there, am I not deceiving the voters when there's not going to be a primary? The statute.
You're stating when
all
the
all the
primary
case-
election is happening. That's what you're doing. I'm
No,
sorry.
it's stating that I'm going to be on the ballot for the primary election. That's what it states.
I was in a hurry to get home Monday night, the holiday, got to be home. And so down the East Belt line, I managed to get up to about 70 miles an hour. I felt good because I slowed down to 65. Now I was actually in a 45 zone. Nobody caught me. And then about a mile up the road, the speed limit changes to 65 and I felt pretty good. It's kind of the same argument. When you put the 5th on it, when you put the 5th of November on there, where it says primary and you didn't know if there's going to be a primary, you were outside of not just strict compliance, but you're outside of the statute. The fact that there's no primary now still doesn't change the fact that that's supposed to be a primary date. Does it actually say primary on the form?
To be voted for at the primary election to be held on.
Yeah, so that, I mean, now that even makes it more inaccurate, right? There is no primary on the 5th.
Correct. And I think that's actually a flaw in this petition, but that's not something for you guys to deliberate here. I understand that. But by putting that down there, by putting that primary date on there and forcing a candidate to put that primary date on there, when in fact there might not even be one, I believe is dishonest and distrustful and deceitful to the voter who then is going to show up in August to vote for that person and they're not going to be on the ballot.
But to make your argument work, you're talking to the wrong group of people. You need to be across the street talking to the legislature.
Yeah, I think we understand your position, Mr. Woodrow. We have a motion.
I'll make a motion. I move that the board accept the staff recommendation and find the nominating petition filed by Hugh A. Woodrow insufficient.
Or
All in favor?
Aye.
Aye.
George, if I might, could I just ask, other than the Ruggiero and Nielsen folks, who else is here waiting to speak? Because I want to try to, okay.
Other than public.
Well, I want to try to get them in because they've been waiting all day. So we have 4 different ones. Okay, and what are the petition names? Debt. Okay, well, Tomczak's next. So if it's okay with you, Chair, can we try to get through those 4 and then, okay, so Tomczak's up. So this one is just about court, like having to write court on the petition. We didn't think that there was a challenge that some of them said circuit judge as opposed to circuit court judge. We thought that was clearly referring to the right office, so we rejected that challenge.
And
I'm just gonna ask you to follow the staff recommendation.
I'm sorry,
I'm gonna ask you to follow the staff recommendation.
do we have any
And-
questions? Okay, would you please spell your name for the record?
Karen, Karyn. Tomczak, Tomczzyk.
And you have asked us to support the staff recommendation.
I have.
Do we have a motion?
I move that the board accept the staff recommendation and find the nominating petition filed by Karen E. Tomczak to be sufficient.
All in favor?
Aye.
Aye. Motion carries.
Is it
Thank you.
okay if we skip to Griffin? Is that okay, Chair? Is it okay if we skip to Griffin? I'm sorry. I just want to try to get,
He's here.
yeah. That's 27.
Herman Griffin.
Right. So this candidate required 2,000 signatures. The total filing was 2336. We found only 1,904 facially valid signatures. We did see some signature sheets that showed indications of signatures written in the same handwriting. And so based on that, we looked them up in qualified voter file. And we did find that 251 were not registered. Additional 86 were invalid signatures, and additional 94 had an invalid date. So combining all those, that it did bring the candidate below 2,000. So we recommend determining the petition insufficient.
Just for clarity, I have handouts of what I submitted. And so,
State your name for the reporter.
It's on.
oh, Herman Griffin, Herman Griffin, and Herman Griffin the fourth. These are the others. Apologies. First of all, I want to thank you for the opportunity to just respond and thank the board for the election review staff for their efforts to protect the process. It's difficult to believe that any of the circulators, have the accusations of fraud. I did speak with two of them. And I, as a defense attorney, I always look at accusations versus this is something that actually happened. So I did speak with them, and I did start to go to persons that were listed as the qualified voter file didn't match to try to get affidavits from those people. But just going forward, basically my argument is that, so I calculate that I have 2,085 valid signatures, and 251 signatures I don't contest at all. So they're uncontested. And so what I have is uncontested, not registered signatures, 214, uncontested invalid signatures, 36, and uncontested invalid date issues, 1. And again, this is based off of the information that I received from the board or from the Bureau regarding the discovery for the FOIA request that I asked for. So I asked for a FOIA request regarding how did they get to the 251 signatures that were just invalid, and how did they get to, the other parts, and what was provided. And so, basically, how did they get to the 251 not registered, the 86 invalid, the 94 invalid date? Now, what I received wasn't a spreadsheet, which I had asked for. So I had to create by hand, typing, to create spreadsheets for you all today, which I have attached. And the main thing is that basically there's suggestion that I'm 96 away. And the dates, the invalid dates, they're saying are 94 invalid dates. And so I looked, and at first I was just, before I received the discovery, I was thinking, oh, that's just what happened and everything. But once I got the discovery, the invalid dates, one is missing the date completely. And so I'm not contesting that. But the others, the majority, will say, I think at least 91, is just based on the person's handwriting. So these are people who signed. We're not saying that they didn't sign. We're not saying that they're not valid Detroit voters. We're just saying that maybe their 4 looks a little different from the way I would have written 4. Maybe when they put April, it looks more like something else. But these are not the same issues that, again, the date is completely missing. That's not what we have. And that's for, like I said, at least 90, I believe 92 of them. And then 2 I can rehabilitate to get to 93. The 86 invalid signature, and again, I've attached the spreadsheet to show what I'm speaking of. And the invalid signature sheets. So in general, it just says invalid signature. But when I went to, again, the discovery that was given to me from the FOIA request, only 63 actually have comments to say that, okay, either not valid based upon the voter file doesn't match, or something of that nature. So only 63. And out of that 63, you have 36 that I'm saying I'm not contesting because they had something other than the voter file doesn't match. It was like the address doesn't match and the voter file doesn't match. So I'm like, that's okay. But if it's just the voter file or just the signature, for me, I believe there's still a presumption that that signature is valid. And that's why I have affidavits from people who the board may have suggested, like, okay, or the Bureau may have suggested the voter file doesn't match, so we're saying it's not valid. But I have an affidavit from a person saying, no, I did sign this on that day. And so I wasn't the original circulator for those. So I went back and signed, and I'm the witness. And I went to these persons, and it was only, one person on this side of the city and that side of the city. But to me, is that presumption that they're still valid. And so I think that is, to me, the one of the core issues. So that's why I went from 86 to 63 and then went down to 36. Because again, if it was something connected to the voter file, if it was an address or if they misspelled something, I just said I'm not contesting it. And so that's, again, so I went from 251 to 214, that's the second page. And how I did that by saying that, again, that's all that I counted. I only counted 214 that had comments about name, address don't match, and or no record, unable to locate. Invalid signatures, I went from 86 to 36. I explained that. And like I said, I have several affidavits to show that part. And then the invalid dates, when you look at the sheets, they say again, and also I'm looking at due process issues, because even the comments are completely silent on a lot of the voter files. They don't say anything. So I'm saying that they should be included. And also the invalid dates, many of them, most of them don't even list the line number. And they don't say what's wrong with the date. And so again, for me, when looking at it, it was, there wasn't anything wrong. It's just, do you have a problem with how they wrote it? And so that's basically, and I put in the Court of Appeals case.
Yeah, Mr.
Yes.
Fracassi, do you want
So
to?
we're over time. So Chair, I think we're getting new information that we haven't reviewed. So I'd recommend that we take a look at this and bring it to you on Monday, because we're not going to figure it out in 5 minutes.
Right.
Not a problem.
Okay.
Okay. One
So-
other.
Yeah, so Odette should be really fast, I think. So let's do that, and then we can do Morales, I think, before we
Okay.
have to get out of here. So Odette, I'll just do that quickly. That is basically the challenge was that there's a challenge because people were writing GB for Grand Blanc. That's an acceptable variation. So we rejected that challenge and found that she had enough
Is that number
signatures.
30?
Yeah, that's number 30. Sorry to go fast. So we think that it should be accepted because GB is a perfectly fine abbreviation for Grand Blanc.
You want to state your name? and
Good
spell it for the
afternoon.
reporter.
Amanda Odette, AmandaOdettete.
And you said.
Recommending-
Recommender, The only.
yeah, sorry to go.
the only, challenge was to using GB for Grand Blanc.
There were other challenges, but once we removed that one, there were not enough in question to, I'm not even sure with that one, there were enough in question. So we didn't process the rest. Is that correct?
Yes.
Yeah. So we recommend determining sufficient.
I just have one question for Director Brader. Is Grand Blanc GB listed in that kind of index that we kind of, I don't know, you know what I mean?
I think it is, but even if it's, okay, it's not, but that list is not exclusive. If
Okay.
there's other,
That's
we
what I
accept other abbreviations.
Do you have anything to add to what Director?
All
Brader said?
I'm here to say is that I'm respectfully requesting that the board adopt the staff recommendation and determine that my petitions are sufficient.
Do we have a motion?
I will.
Or does anybody have a question? Actually? Do we have a motion?
Yep, we do. I move that the board accept the staff recommendation and find the nominating petition filed by, I have to slide up here, sorry about that. Yes, I've got that part. Amanda Odette, sufficient.
All in favor?
Aye.
Aye.
Thank you so much for taking me out of order. I appreciate it very much.
Thank you. Okay. So the last one I think we can get to today is Morales. Thank you very much. I'm sorry to keep you waiting all day. So the issue here was that the district number, District 44, was not written on the petition sheet. So that is required. The candidate did contact us to try to get help reviewing their petition. They sent us an email and with copies of the petition. We responded identifying a couple things that needed to be corrected. The email noted that the title and term of office needed to be corrected and the primary date needed to be corrected, and also referred the individual to the attachment to review. My understanding is that based on the candidate's response is that, and she can tell you herself, but that she didn't realize that there was something to look at in the attachment that was referring to the district number. So unfortunately, apparently didn't realize that the district number needed to be added. And because it wasn't added, we had to reject it. A couple of things I'll just say to that is like one, we did, in a perfect world, I agree, we would have put the District 44 in the cover email. We try to always provide perfect help. In this case, we did identify the issues that needed to be identified, but not in a way that the candidate noticed. But we did provide the information. The other thing is that unfortunately, even if we provide an effort to help, even if the information we provide isn't entirely helpful, we still have to process the petition based on the statute. So based on that, unfortunately, recommending that we determine the petition to be insufficient.
Questions for Mr. Director Brader?
So you did provide answers to the questions that were asked.
Yeah, she gave us a copy of the petition and asked us to review. We reviewed it. We identified three things that needed to be corrected. One was the title term of office. One was the primary date. And then one was that the district needed to be added. I think the confusion was that we mentioned the primary date and the title term of office in the cover email, but the district number was in the attachment itself. So I assume what happened is the candidate didn't notice that part because it was in the attachment itself. So, that's what happened. Like I said, in a perfect world, it would have been in the cover email, but we did provide the information. And again, we still have to enforce the law, and we tried to help.
Was that attachment done through like Adobe, like a note?
Yeah, it was
or
a comment on, go ahead.
I'm just asking because I know, just as a question of like how that is notified to candidates is, obviously you said in the cover letter, but if the district number was in like a note on Adobe, would that be available to a candidate if they do not have Adobe on their end? That's the question I have for you guys.
That's exactly the issue. Is I opened the attachment, the note was not available. And I didn't know there was a note available because I needed a third-party software to be able to open that. That exactly is what happened. Yes, you're right on the money.
I can't tell you what software is needed to see the comment, but
Right.
obviously I believe the candidate that she didn't see it. But again, I mean, we really try our best to help everybody. We did our best here. Obviously there was, the information wasn't communicated, but we still have to enforce the statute. So it does have to have a district number on it.
Just add a couple really quick comments. I've always wanted to run for office. I have done hundreds of hours of training. This is not something I expected. I was shocked. I didn't understand how this could happen when I know what needs to be done to not have any issues with petitions. I went above and beyond. I collected all my signatures in one city because I thought that perhaps the residents of Berkeley wouldn't know that their court has been closed. And so now it's Royal Oak. So I only collected signatures from Royal Oak. I was the only one that collected signatures because I didn't want any issues with the circulators. I also collected all my signatures in front of the courthouse, right in front of the Royal Oak Farmers Market. And that was part of my spiel. Please help me get my office right in there. That I did everything I could possibly do. everything. I didn't have the software. I downloaded the app. I downloaded the petition. It didn't even say it was a software issue or that I needed to download the correct software.
Chair, and I absolutely have like, these are not easy for us. Don't think that we're sitting up here and make this as easy for us, but like, if you came up to me, even if it was in Royal Oak and I lived in Royal Oak, which I don't, it still just says district court judge, and there are numerous district judges in the state of Michigan. Numerous. That's kind of.
I'm looking at this in the staff report.
I know.
Is that the Adobe?
That would be a note, that would be
This
highlighted.
note here, that's what
Mhm.
you're referring to, that you would need Adobe software?
I don't know if you did. That's the question that.
You did.
I don't have my, that's a question that I had asked. But I don't, But unfortunately,
This is really very difficult. Does anybody have a question? Either for the director or for the candidate?
The deciding factor for me is the form has the district, if any. And as much as you tried to make sure you did it right, still ultimately incumbent on the candidate to notice that and put the number in. And I'm this is like the worst one to possibly end on. Cause I am really sorry. But ultimately it's not an issue we can address.
and see you all looking at me. I'm very sorry. I really am. But I move that the board accept the staff recommendation and find the nominating petition filed by Bella Morales insufficient.
All in favor?
Aye.
Aye.
Thank you for your time.
Need to wrap up. So, yeah, obviously very unfortunate situation. So we have to revisit Nielsen. We have to do Frame and Barone and Moss. And then we need to talk about Ruggiero. I'm very sorry for folks who are here all day and we weren't able to resolve their issues. So I think we're going to be back Monday. And then we didn't need to wrap up Griffin too. So we'll be back Monday to talk about those. Is there anything you want to add, Adam? Or?
We will be putting out a notice specifically for Monday, so it's going to go out Monday to start at 10 o'clock. We'll be here as well. And then I would just say, as we end, anybody that wants to talk to the board, please go wait in the lobby because I need to clean the room out and we have to be out of here. So if you could wait in the lobby, I would appreciate it.
You have an issue for Monday?
Do we need to adjourn?
Are we in recess or are we adjourned?
Motion to recess? Is that?
We're recessed.
Oh, so we have to adjourn.
We have to adjourn.
Oh, we have
Then
to
we'll
adjourn.
reconvene.
Okay,
Motion to adjourn?
okay. All in favor?
Aye.
Okay, we adjourn at 4:37. So.